I am going to observe that and you will also face the wrath. No, no, sir. No, sir. Sir, whatever it is, you are saying impersonation. You have got that lady impersonated. I will at the so you also be why are you the complainant? You be an accused with them. Be innocent. No problem. No problem, sir. I will pocket money. Keep that pocket money with you. Yes. No problem, sir. We will observe that all of you should be proceeded against. Preliminary inquiry madly. Let the complainant also be proceeded against.
Then FIR has to go. If they want, if they have a liberty,
FIR
they
will
can
go.
They have a
FIR
liberty.
will go. P they will do and 17A approval they will take.
Whatever they want to do, my lords, it is their discretion.
In accordance with law.
FIR has to go.
FIR will be in the air. Oh, yes, sir. We will not leave anything in air, sir. I, for one, will not leave anything in air. No, no, at your asking, I will not keep anything in air, not in hanging somewhere. No, sir, that is not the law. 17A, Ildane, you could not have proceeded against them. FIR is registered without 17A, it should go. Yes. 7A, this is not a trap proceeding. Yes. Anything else? The new ready agbudi. Yes. Kodi.
Complaint is 1 year later, saying at the time of registration of sale deed, you have demanded, and thereafter, my lords, deed of cancellation is effected.
By.
And
yes, you have to. You better will do all that. Yavat the complaint kotiddu. So 17A was in place. Why did you not hold a PE or take approval? Why? This is the problem. This,
as soon as there is a perspective that as soon as 7A or 7 is involved, 17A is not required.
True. 70 in a trap that you lay down, definitely 17A is not required because he's caught red-handed. What else do you need? This it's not. See, 7 deals with criminal misconduct by a public servant. All right. So that's what I guess. There, 7A stands on a different footing where he is caught. This is not a case of trap. Yes, yes, all of it. If he is guilty, bring him also into books. Whoever is guilty, bring them to books. Yes. The petitioners in both these cases are said to be public servants. In criminal petition 5504 of 2024, the petitioners are accused. Ella one crime. The petitioners are accused 1, 2, 4. Imdrali Prithvish. The companion petition concerns accused number 5. Both these petitions call in question registration of a crime in crime number 17 of 2023, registered for offences punishable under section 7A, B and 7 capital A of the Prevention of Corruption Act. Heard so and so. Facts enumerated are as follows. The second respondent, complainant, is said to have purchased site number 20 from one Basamma. And on the strength of the said purchase, the complainant is said to have got the sale deed registered by bringing one Basamma to the sub-registrar's office. Correct, Adu? So and so. One lady claiming to be that she was the real Basamma and the one who has appeared before the sub-registrar was an impersonator bought by the complainant, the objections were taken note of in SS layout Davanagere from one Basamma. He takes Basamma to the sub-registrar's office, gets the sale deed registered in his favor. The real Basamma, who, a person by name Basamma who claims to be the real one, objects, files her objections later. The sale deed gets cancelled at the instance of the complainant himself. It could be realizing that real Basamma has objected to the registration of the sale deed, or the payment did not go in its entirety to the Basamma whom the complainant had bought before the sub-registrar's office. This is a matter that requires investigation. The involvement of these petitioners would date back to 30th June 2022 at the time when the sale deed came to be registered. And after 1 year, the sale deed comes to be cancelled. Khata was not changed. After getting the sale deed cancelled, the complainant appears before the Lokayukta and registers a complaint that 13 months ago, i.e. on 30th June 2022, the complainant, the petitioners had demanded money from the hands of the complainant, and the complainants have accepted that money. As observed herein above, it is not a case where the Lokayukta would lay a trap on these officers and the officers are caught red-handed by accepting bribe. It is only in that circumstance the compliance with the rigor of Section 17A would get obviated and not otherwise. Section 17, not otherwise. The complaint touches upon the decision taken by these petitioners in accordance with law or otherwise. Since they have taken a decision, the decision, if requires inquiry or investigation, compliance with Section 17A becomes mandatory. Therefore, the Lokayukta could not have straightaway registered an FIR on the say of the complainant, that it requires investigation. The mandate of Section 17A cannot be given a go by the Lokayukta in the aforesaid fact circumstance, as it is not a trap that is laid against these petitioners. The complaint, though, would not get obliterated by interpretation of Section 17A. The crime that is registered in crime number 17 of 2024 does get obliterated for want of compliance with 17A. However, leaving open to the Lokayukta to conduct a preliminary inquiry, then seek approval under Section 17A of preliminary inquiry Madangila. Seek approval under Section 17A and then conduct a preliminary inquiry, and if need arises, then register. How do you investigate otherwise?
Under Lalit Kumari preliminary.
Lalit Kumari 120.1 alla.
If the complaint is more than 3 months belated, then preliminary inquiry is mandated.
Then approval for what? Preliminary inquiry. I will see, yes. Shall seek approval from the hands of the competent authority for conduct of an inquiry. As 17A would require, 17A approval would require under 3 circumstances, be it inquiry, or investigation. In the case at hand, the complaint narrates an incident that is 13 months old. Therefore, the observations of the apex court in the case of Lalit Kumari versus State of Uttar Pradesh reported in 2014 2 SCC page 1 would spring. Extract para 120.1. The apex court in the aforequoted paragraph would indicate that in cases of corruption, where the complaint is belated beyond 6 months, or even in other cases where the complaint is beyond 6 months, 3 months. 3 months, a preliminary inquiry is a must. In that light, the approval being granted would be for the purpose of conduct of inquiry. And if the preliminary inquiry would pin down these petitioners, appropriate action be taken by the Lokayukta. at a later point in time. The later point in time, if the complainant is guilty of impersonation, the complainant also be proceeded against in accordance with law. For the aforesaid reasons, the following order. The petitions are allowed. The crime in crime number 17 of 2024 stands obliterated. The liberty is reserved to the Lokayukta to seek approval from the hands of the competent authority and proceed further, bearing in mind the observations made in the course of the order. Ordered accordingly. Yes.
Like,
Huh? Inquiry or investigation, all three circumstances. Next.
Lord, this is that case, my lords, arising out of an agreement. I had given by way of separate memos, my lords, for the.
Interim order ಕೊಟ್ಟಿದೀವಲ್ಲ?
ಇದೆ.
ಹಾ ಸರಿ. ಕೊಡಿ. Tag this petition along with heard the learned counsel Nitin Ramesh appearing for the petitioner. FR number. I will not connect FR numbers. Correct. 82 and
ಇಲ್ಲ,
185 and 82.
190.
190, sorry.
82 becomes 185.
190. ಅದು ಚಾಲೆಂಜ್ ಮಾಡಿದಾರಾ?
ಅಲ್ಲ, ಅದು ಇನ್ನು FR ಅಲ್ಲಿ ಇದೆ ಸರ್.
ಹಾಗಾದ್ರೆ ವಿಲ್ ಪರ್ಮಿಟ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಇನ್ ದಟ್ ಕೇಸ್.
ಅಲ್ಲ, ಅದರಲ್ಲಿ may I read that, my lords? It's a check bounce case. If it's a check bounce case, clearly they're saying, I'm providing the compilation.
Why don't you comply with the office
My
objection?
lords, we'll move it, my lords. My
You
lord,
have just
what
kept
happened-
it.
My lord,
we will
may I say
permit
what
investigation in
happened?
that.
May I say what happened?
Yes.
They instigate another complainant in Kerala and file a POXO case against, my lords, all this, against this petitioner.
ಯಾವ್ದ್ರಲ್ಲಿದೆ ಪೋಕ್ಸೋ?
ಅಲ್ಲಿ ಕೇರಳ ಕೋರ್ಟಲ್ಲಿ ಪಾಕ್ಸೋನು ಹಾಕಿದ್ದಾರೆ ಇದಾದ ನಂತರ.
ಅದು ಅಲ್ಲಿ ನಡೀತಾ ಇದೆ.
ಅಲ್ಲ, ಅವನು ಬೇಲ್ ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್ ಅಲ್ಲಿ ಇದ್ದ. ದಟ್ ಈಸ್ ದ ರೀಸನ್ ವೈ ವಿ ಆರ್ ನಾಟ್ ಏಬಲ್ ಟು ಗೆಟ್ ಪ್ರಾಪರ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇನ್ ದಟ್. ಇನ್ ಅರ್ಜೆನ್ಸಿ ವಿ ಹ್ಯಾಡ್ ಫೈಂಡ್ ಇಟ್. We will move it, my lords. We will get the FIR cleared and we will.
No, I will direct the matter to be listed along with that.
Please.
And if objections are not complied, interim order will get
Please.
vacated.
Please,
Yes.
very well.
The counsel for the response, CBI, complainant, the counsel for the complainant would submit that crime number 19, ಇದು Nitin Ramesh sir, ಇದು 190 or 185 ಇದು?
ಇದು 185.
The crime number 190 of 2024 is also called in question in FR number 8312, criminal petition ಅಂತಾನೆ ಇದೆ, filing number so and so 12 of 2024, and the matter has been kept without complying with the office objections. The learned counsel for the petitioner would refute the said submission, contending that they would immediately comply with the office objections. List the matter on Wednesday in the fresh matters list along with the said so and so 8312. Yes, interim order subsisting shall continue till the next date of hearing.
Lord, 19th, my lords.
19th, all right.
19th.
20th,
20th. Very well.
20th afternoon.
20th
All
can
right.
be passed over. Great.
Seventeen and 80 of KP Act, my lords.
KP Act.
Yes, my lords. Without, my lord, permission, they conducted raid and seized the income, seized the articles and arrested the petitioners. Thereafterwards, my lord, sought permission from the jurisdiction magistrate.
Yes, sir. Correct, Ado.
And produced the.
Subsequent or
Section A is the, my lord, NCR.
look into it. List on 26th, there shall be an interim order of stay of further proceedings with the petitioner to the next date of hearing.
Stay is
Idi
there.
already.
Stay is there.
Interim, list after 2 weeks, interim order granted earlier stands extended to the next date of hearing.
17.
No passover, no adjournment. Last time also. Maybe, yes. No. Senior counsel should be present when the matter is listed. We will not grant time for the purpose of senior counsel to come. Passover, that's fine, yes. Next.
18. Lord. Suicide.
Huh?
Is already placed.
Hmm. Yes, sir.
Lord, the complaint, my lord. Kindly come to page 19.
Your accused
Sorry,
number?
sir, 16. Accused number 6, my lord. Totally 13 accused are there. Against all
He
the
is
allegations.
one of those persons who demanded his money back. Yes, suicide.
There was just a demand of money. But
Demand of money, yes.
Allegation is not against any specific person. Allegation is general allegation, all 13.
The petitioner is before this court calling in question registration of a crime in crime number 90 of 2024. The crime is registered for offense punishable under section 149 and 306 of the IPC. The learned additional SPP has produced the entire papers of investigation for a perusal of the court. Perusal of which would indicate that the petitioner had in cricket betting guide.
ಅಲ್ಲ IPL betting ಅಂತ ಅದಕ್ಕೆ ಅವ್ರು ಸಾಲ ತಗೊಂಡಿದ್ರು ಅಂತ.
It would indicate that the deceased son of the complainant.
ಅಲ್ಲ. Deceased is the wife of the person who has indulged in betting. He had borrowed loan from the all this.
All right. They had borrowed money from several. Don't disturb. Perusal of which would indicate that the son-in-law,
Son-in-law had borrowed.
son-in-law of the complainant had borrowed monies from the market for the purpose of investing it into IPL betting. The persons who had lent money started demanding the money back. It is then the wife of the daughter of the complainant, commits
complainant.
suicide. The allegation is abetment is attributed to accused several petitioners, including accused number 6. The investigation papers would not reveal anything further than what is narrated herein above. In that light, permitting further investigation, this petitioner would run foul of the judgment of the apex court in the case of Kanchan Sharma versus State of file ಆಗಿದೆಯಾ ಎಲ್ಲಿದೆ
ಇಲ್ಲ ಆಗಿಲ್ಲ.
ಚಾರ್ಜ್ ಶೀಟ್ ಏನಾದ್ರು ಇಟ್ಸ್ ಆಲ್ ರೈಟ್. ಸೊ ಕಂಚನ್ ಶರ್ಮಾ ವರ್ಸ್ ಇನ್ನೂ ಒಳ್ಳೇದು. ಕಂಚನ್ ಶರ್ಮಾ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ ಉತ್ತರ ಪ್ರದೇಶ್ reported in 2021 SEC online SC page 737. Therefore, there shall be an interim order of stay of further proceedings this petitioner to the next date of hearing. Now all 5 will come to you. Yes. ನೆನೆದಲ್ಲ ಸುನಿಲ್ ಗವಾಸ್ಕರ್. ಎಸ್ ಮೇಡಮ್, ಇಂಟರ್ ಮಾಡ್ರಿ ಇದೆ, ವೆಕೆಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ಎಸ್ ಸರ್, ಹೇಳಿ.
Mother filed a DV case against the son.
Mother filed
a domestic violence case.
Against the son.
But kindly see the para 1 and 2.
Para 1 and
2. Facts of the case.
Complaint
Complaint. At ink page, annexure E, ink page 30, the relevant para is 31.
Yes, sir.
The petitioner has married one Narayan Reddy on 19/11/82 at Narsitirtha Mantapa, Mulva.
ಏನ್ ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ?
Sorry?
ಏನ್ ಕೇಸ್ ಹಾಕಿ? ಮೇಂಟೆನೆನ್ಸ್
Alla,
ಮತ್ತೆ ಏನ್ ಕೇಸ್?
as per their own statement.
Okay, what is the case that the mother has filed against the son?
Son, Domestic Violence Act.
What are the legal grounds?
As per their own pleading, clearly states that the petitioner is staying at Kerpuram.
So what?
The petitioner is staying at Mulbagi. the respondent is, number one is the son of the petitioner, and Srimati Deepa, Mamata and Kumari Asha are the daughters of petitioner, and Deepa and Mamata are married and are residing with their husbands and the matrimonial homes. Kumari Asha is residing at Bangalore, working as an engineer. Next, ma'am. The respondent herein has completed the MA graduation, post-graduation in MA from Bangalore University, and the petitioner and her husband has taken care of all educational expenses of the respondent number one. He got a job revenue department at Parandalli Gram Panchayat, and he is working as a secretary and earning more than 35,000 month. Further, the respondent has married one Srimati Nandini, who is the respondent number two herein. Marriage held at KVR Chowdhury.
Prayer in Odi, sir.
Swami?
Even facts, prayer in Odi.
Prayer.
Ilder I will hear the respondent.
Why, prayer. Wherefore the most respectfully press that this honorable court may be pleased to grant a relief as claimed herein and pass such other orders as this honorable court deems fit and proper to given circumstances the case of the protection the aggrieved persons from domestic violence in the interest of justice and equity. Reliefs. The committing any act of domestic violence, aiding or abetting the.
I note the petitioner.
Sorry?
No, note there. Wait. Yes, sir.
They will forcefully obtain a gift from the respondent.
You should have gone before the assistant commissioner. Wait, sir.
What he does is, he will tell the respondent to gift the property which she is residing right now in the present scheduled property. What he does is, once they deny to execute gift deed with respect to the shared household part, he tries to dispose the respondent from the.
Then you have approached the court.
Whatever.
ಈಗ ಮೇಂಟೆನೆನ್ಸ್ ಅವಾರ್ಡ್ ಮಾಡಿದಾರಾ? What shared household? Anything else, sir? You are
Whatever
the
the
son, you are a son.
Yes, yes, yes.
Take care of your mother.
That's
If
what
you-
I am paying every
If
month.
this is the,
5,000.
I will dismiss the petition with costs.
No, no, no. Because,
No, illa. If
My
son
lord,
cannot
one
take care
second.
of the mother, who else? Yes.
no, my lord, 1 second on the video ತೋರಿಸ್ಬಿಡ್ತೀನಿ. They don't want to come the daughter-in-law into the house. When daughter-in-law gone out of the house, they were visited to the
To
house.
register a separate crime, sir.
ಅಲ್ಲ ಯಾವ್ದಾರ ಹಬ್ಬಗಳಿಗೆ ಊರಿಗೆ ಹೋದ್ರೆ ಸೊಸೆ ಮನೆ ಹೊರಗಡೆ ಬರಬಾರ್ದು ಅಂತ, ಸೊಸೆ ಹೊರಗಡೆ ಹೋದ್ರೆ ಗೇಟ್ ಬೀಗ ಹಾಕ್ತಾ ಇದ್ದಾರೆ. ದಟ್ ಈಸ್ ದ.
What is this? ಕ್ಯೂಂಕಿ ಸಾಸ್ ಬಿ ಕಭಿ ಬಹುತ್.
ಒಂದು 2 ಸೆಕೆಂಡ್ ವಿಡಿಯೋ ನೋಡಿದ್ರೆ ತಮಗೆ ಗೊತ್ತಾಗುತ್ತೆ ಸ್ವಾಮಿ.
ವಿಡಿಯೋ ನೋಡೋದು ಬೇಡ.
ಅಲ್ಲ ಏನೆಲ್ಲ ಪ್ರಾವಿಷನ್ ಆಫ್ ಲಾ ಇದೆಯೋ, 1 ಸೆಕೆಂಡ್, ಏನೆಲ್ಲ ಪ್ರಾವಿಷನ್ ಆಫ್ ಲಾ ಇದೆಯೋ ಅದನ್ನೆಲ್ಲ ದೇ ಮೇಕ್ ಯೂಸ್ ಆಫ್ ಇಟ್.
If that is presumed to be true, she would have approached police and she would have filed a complaint alleging that this is the incident. Until this case is being filed, there was no certain allegation at all.
ಈಗ there is nothing that you have challenged here. There is no order passed by the concerned court.
ಇದು
ಏನ್ ಬರೀ proceeding,
senior
full
civil-
You have challenged the entire proceeding. All right. I am not going to.
My wife
interfere.
also filed a case against the complainant, and it is also passed the orders.
ಈಗ 1 minute. Daughter in law, mother in law ಕೂತ್ಕೊಂಡು ಸೆಟಲ್ ಮಾಡ್ತೀರಾ ಅಥವಾ ಆಗದೇ ಇಲ್ವಾ?
ಅಲ್ಲ ಆಗುತ್ತೆ.
ಏನಾಗುತ್ತೆ?
One of the daughter is a advocate. She make use of all the law against the brother. ತಂಗಿ ಹೆಸರಲ್ಲಿ ಒಂದು ಡೊಮೆಸ್ಟಿಕ್ ಅಲಯನ್ಸ್, ಅಪ್ಪನ ಹೆಸರಲ್ಲಿ ಒಂದು ಸೀನಿಯರ್ ಸಿಟಿಜನ್. She is the only the.
Sit across. You are all in the same family. Don't fight.
Yes, the.
Don't fight
one
and
daughter
close
is
everything.
an advocate. She make use of all the provision of law against the brother.
Correct.
ತಂಗಿ ಹೆಸರಲ್ಲಿ ಒಂದು ಡೊಮೆಸ್ಟಿಕ್ ವೈಲೆನ್ಸ್ ಆಕ್ಟ್, ಅಪ್ಪನ ಹೆಸರಲ್ಲಿ ಸೀನಿಯರ್ ಸಿಟಿಜನ್ಶಿಪ್ ಇದರಲ್ಲಿ ಬಿಫೋರ್ ದ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್.
ಅಷ್ಟೆಲ್ಲ ಯಾಕೆ ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ನೋಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ಏನಾಗಲ್ಲ.
ನಾವು ಅಲ್ಲಿ ಊರಲ್ಲೇ ಇಲ್ಲ. ಆಸ್ ಪರ್ ದೇರ್ ಓನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಐ ಆಮ್ ರಿಸೈಡಿಂಗ್ ಇನ್ ಕೇರ್ಪುರಂ. ಯಾವತ್ತಾದ್ರೂ ಹಬ್ಬಕ್ಕೆ ಊರಿಗೆ ಹೋದ್ರೆ ಮನೆಗೆ ಸೊಸೆ ಮನೆಗೆ ಬರ್ಬೋದು,
ಅವ್ರೆಲ್ಲಿರೋದು?
ಬೀಗ ಆಗ್ತಾ ಇದಾರೆ.
ಅಲ್ಲ ಅವರೆಲ್ಲಿರೋದು?
ಅವ್ರು ಕೇರ್ಪುರಂ
ಪಕ್ಕದಲ್ಲೇ?
ಅಲ್ಲ, ಇಲ್ಲಿ ಬೆಂಗಳೂರಲ್ಲೇ.
ಹಾ.
ಅವ್ರಿರೋದು ಮುಲ್ಬಾಗ್ಲಲ್ಲಿ.
ತುಂಬಾ ದೂರ.
ಮುಲ್ಬಾಗ್ಲಲ್ಲಿ ಊರಲ್ಲಿ ಇರೋದು,
ಎಸ್ ಎಸ್.
ವಿಲೇಜ್ ಅಲ್ಲಿ.
ನಥಿಂಗ್. ಸಿಟ್ ಅಕ್ರಾಸ್ ಅಂಡ್ ಸೆಟಲ್
ನೋಡಿ
ಎವ್ರಿಥಿಂಗ್.
ಸ್ವಾಮಿ, ಇನ್ನೊಂದು ಸಿಸ್ಟರ್ ಹೆಸರಲ್ಲಿ ಡೊಮೆಸ್ಟಿಕ್ ವೈಲೆನ್ಸ್ ಆಕ್ಟ್ ಹಾಕಿದ್ದಾರೆ.
ರೆಡಿ ಒಂದು ನಿಮಿಷ. ನಾವು 1 minute. What do you want? What does the mother want? Tell me.
That's all, nothing else.
All right. That is what you want. What do you want?
ನಾವ್ ಯಾವತ್ತಾದ್ರೂ ಹಬ್ಬಕ್ಕೆ ಊರಿಗೆ ಹೋದ್ರೆ ಮನೆಗೆ ಒಳಗಡೆ
ಹಬ್ಬಕ್ಕೆ ಹೋಗ್ಬೇಕು ಅಷ್ಟೇನಾ?
ಹಬ್ಬಕ್ಕೆ ಯಾವ್ದಾರ ವೀಕೆಂಡ್ ಅಲ್ಲಿ ಮನೆಗೆ ಹೋದ್ರೆ
ಹಾ.
ಮನೆ ಒಳಗಡೆ ಬಿಡಲ್ಲ,
ಯಾಕೆ?
ಗೇಟ್ ಬೀಗ ಆಗ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ.
It's all right. ಒಂದ್ ನಿಮಿಷ. ಇನ್ಮೇಲೆ ಬೀಗ ಎಲ್ಲ ಹಾಕ್ಬಿಡಿ. I'll take it after 14 days. All of you sit together and settle. ನೀವು ಬೀಗ ಹಾಕಿದ್ರೆ ಆಮೇಲೆ ನಾನು ಬೇರೆ ಇಲ್ಲ. ಬೀಗ ಹಾಕಕ್ಕ ಸೆಟಲ್ಮೆಂಟ್ ಟ್ರೈ ಮಾಡಿ.
ಅಲ್ಲ,
ಯಾರು ಹೇಳ್ತಾ ಇದಾರೆ? ಅಷ್ಟೇ ಗೊತ್ತಾಯ್ತಲ್ಲ ಏನಂತ ಈಗ.
ನಾನು ಹಬ್ಬಕ್ಕೆ
Sir,
ವೀಕೆಂಡ್
ಇವ್ರು ಬರೀ ಹಬ್ಬಕ್ ಬರಕ್ ಕೇಳ್ತಾ ಇದಾರೆ ಅವಾಗಿಂದ. ನಿಮ್ಗೆ ಏನ್
ಮನೆ ಒಳಗಡೆ ಬಿಡಲ್ಲ, ಬೀಗ ಆಗ್ತಾ ಇದಾರೆ. ಅತ್ತೆ ಸೊಸೆ ಮನೆಗೆ ಬರಬಾರ್ದು.
ಗ್ರೀವೆನ್ಸ್ ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ
ಗ್ರೀವೆನ್ಸ್. ಅವ್ರೇನ್ ಕೇಳ್ತಾನೆ ಇಲ್ಲ ಬೇರೆ. ಮದರ್ ಇನ್ ಲಾ ಶುಡ್ ಅಲೋ ದಿ ಡಾಟರ್ ಇನ್ ಲಾ ಇನ್ಸೈಡ್ ದಿ ಹೌಸ್. ಅದಕ್ಕೆ ಡೋಂಟ್ ಪ್ಲೇ ದಿಸ್ ಕ್ಯೂಂಕಿ ಸಾಸ್ ಬಿ ಕವಿ ಬಹುತಿ.
ಇದೆಲ್ಲದಕ್ಕೂ ಕಾರಣ ಒನ್ ಆಫ್ ದ ಡಾಕ್ಟರ್ ಇಸ್ ಅಡ್ವೊಕೇಟ್. ಶಿ ಇಸ್ make use of all the provisions against the brother.
Don't tell anything against advocates, sir.
This is the documents.
Don't tell anything against advocates.
Doctor ಹೆಸರಲ್ಲಿ ಇನ್ನೊಂದು
ಆಯ್ತು, obvious things ಹೇಳ್ಬೇಡಿ ಸರ್. ಎಸ್, ಈಗ ಅರ್ಥ ಆಯ್ತಾ? All right, yes. List this matter on 25th. The parties, the squabbling petitioner and the respondent are mother and son. The allegation of the petitioner is that when the festivities happen, the daughter-in-law is not let into the house of the mother-in-law. The mother-in-law alleges that the son is insisting that he should part. That the mother-in-law mother should part with the property in which she is residing, which is disputed by the petitioner. The dispute appears to be on the periphery. Therefore, the parties to sit across and strike out a settlement to live peacefully ever after. Yes. Now the cat is out of the bag. Yes, sir.
After obtaining interim order by this number, from this number, comes with the gadari.
Gadari? What do you mean gadari? Crowbar. Yes.
That lot. What he does is break the lock of the house.
ನೀವು ವಿಡಿಯೋ ಮಾಡಿಲ್ವಾ ಅದೆಲ್ಲ? ಆಲ್ ರೈಟ್. ನೀವೇನ್ ಕಮ್ಮಿ ಇಲ್ಲ, ಇವರು ಏನ್ ಕಮ್ಮಿ ಇಲ್ಲ.
ಎಲ್ಲರೂ ಎಜುಕೇಟೆಡ್. ಅಪ್ಪನ ಫಾದರ್ ಟೀಚರ್, ರಿಟೈರ್ಡ್ ಟೀಚರ್. ಈ ಮಕ್ಕಳೆಲ್ಲ ಡಬಲ್ ಡಿಗ್ರಿ ಗ್ರಾಜುಯೇಟ್ಸ್.
ಅದಕ್ಕೆ ಹಿಂಗ್ ಆಡ್ತಾ ಇರೋದು.
ಅದೇ.
ಎಸ್, ಸಿಟ್ ಅಕ್ರಾಸ್, ಡೋಂಟ್ ಕ್ಯಾರಿ ಯುವರ್ ಏನದು ಗಡಾರಿ.
ಅದೇ ಇಲ್ಲಿ ಗವರ್ಮೆಂಟ್ ಜಾಬ್ ಅಲ್ಲಿ ಬೆಂಗಳೂರಲ್ಲಿ ಇದಾರೆ, ಇಲ್ಲಿ ಗಡಾರಿ ತಗೊಂಡೋಗು. ವೀಕೆಂಡ್ ಅಲ್ಲಿ ಎಲ್ಲಾದ್ರೂ ತಂದೆ
ವೀಕೆಂಡ್ ಅಲ್ಲಿ ತಗೊಂಡ್ ಹೋಗ್ತೀರಾ?
ಅಲ್ಲೆಲ್ಲ ಮನೆಗೆ ಹೋಗ್ಬೇಕು ಅಂದ್ರೆ ಮನೆಗೆ ಬಿಡ್ಲಿಲ್ಲ.
ಸುಮ್ನೆ ಹೋಗಿ ಡೋಂಟ್ ಕ್ಯಾರಿ ದಟ್ ಗಡಾರಿ. ಎಸ್,
ಹೆಂಡ್ತಿನ ಒಳಗಡೆ ಬಿಡಲ್ಲ ಅಂತಂದ್ರೆ
ಪ್ರಾಬ್ಲಮ್ ಅದು.
ಗೇಟ್
you must understand, he has to go back home. If you don't allow the daughter-in-law, he will not be allowed inside the house. Sit across and settle. Yes. Entry model ಇದೆಯಲ್ಲ, ಇದೆ. Entry model ಇದೆ ಅಂತ don't indulge in anything. Then I will see the video ಆಮೇಲೆ. Yes. Yes. Yes, sir. Next.
For the petitioner has challenged the order passed under section 19. Direction, no, not section 91.
91.
Please, Lord.
Hmm.
Lord, the case of the prosecution, Lord, the complainant filed a complaint on 29/11/2021. The complaint allegation that the accused number 1 and 2 had been to the shop. Who is
No.
the,
In a 7A proceeding,
please, Lord.
who is the respondent? Government servant?
Yes, Lord.
All right. Yeah, trial
No.
start ಆಗಿದೆಯಾ?
The charge sheet is filed
Ah.
before, during the investigation, they filed an application for seeking information about the
Now,
call details
one
of the
minute.
investigation
Nine-
officer.
91 right would spring to you only after the commencement of the trial. You can seek that document at the commencement, once the trial commences. Mic use ಮಾಡಿ.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ 3 ವರ್ಷ ಮಾಡಿದ್ರೆ ಡಿಜಿಟಲ್ ಡಾಟಾ ಡಿಲೀಟ್ ಆಗಿರುತ್ತಲ್ಲ ಲಾರ್ಡ್ಶಿಪ್, ಕ್ಲೈಮ್ ಮಾಡಕ್ಕೆ ಹೇಗೆ ಸಾಧ್ಯ?
ಅಲ್ಲ,
Parties-
but ಈಗ
parties
I will
judgment ಅಲ್ಲಿ
direct,
restrictions-
I will reserve liberty and direct conclusion of the trial within a time frame.
ಎಸ್ ಲಾರ್ಡ್ಶಿಪ್, ಬಟ್ ಪಾರ್ಟೀಸ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿರೋ ರೆಸ್ಟ್ರಿಕ್ಷನ್ಸ್ ಬರೀ ಪ್ರೊಡಕ್ಷನ್ ಮಾತ್ರ, ನಾವು ಪ್ರಿಸರ್ವೇಷನ್ ಕೇಳ್ತಾ ಇದೀವಿ ಲಾರ್ಡ್ಶಿಪ್.
No, not parties judgment, 2004 you're talking of.
Ah.
There's Nitya Dharmananda in 2018, which distinguishes parties judgment, saying that that right would flow only after, Nitya
Defense.
Dharmananda, would flow after the commencement of the trial. Will reserve your right, but that would run counter to, see, parties judgment went on a footing that if that was of a sterling quality, then yes, it can be produced in 482 also.
Yes.
So that would not inure to your benefit now. ಈಗ ಯಾವ ಸ್ಟೇಜ್ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್
Charge
ಆಗಿದೆ?
sheet is filed.
3 ವರ್ಷ ಯಾಕೆ ತಗೊಂಡ್ರಿ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಕ್ಕೆ?
Lord, initially it was.
That is why I say you should put your
ACB
house in order. ಏನ್ ACB ಇಂದ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗ್ಬೇಕಾಯ್ತಾ?
house.
ACB did nothing?
Lord, the initial trap and the sanction it was pending for the obtaining sanction.
Sanction ಎಲ್ಲ ಆಗಿದೆ.
ಆಗಿದೆ.
everything.
Charge sheet was filed.
Whatever application is now pending, what's your name?
ಅವಿನಾಶ್.
Avinash ಅವರೇ. Whatever application is pending, you can revive that the moment trial commences.
ಬಟ್ ಡಿಜಿಟಲ್ ಡಾಟಾ ಯಾವ ತರ?
Digital data ಏನು?
2 years ಆದ್ಮೇಲೆ ಡಿಲೀಟ್ ಆಗುತ್ತೆ ಲಾರ್ಡ್ಶಿಪ್ ಅದು.
ಏನ್ ಡಿಜಿಟಲ್ ಡಾಟಾ ಕೇಳ್ತಾ ಇದ್ದೀರಿ?
TDR.
CDR of whom?
Investigation officer and the riding party there is asking. Lord, the trap was successfully laid. And he is claiming that, Lord, he had demanded 10 lakhs initial,
I don't
10,000.
think CDR gets deleted.
ಇಲ್ಲ ಲಾರ್ಡ್ಶಿಪ್,
Deleted? ಒಂದ್ ವರ್ಷನ?
ಗವರ್ಮೆಂಟ್ ನೋಟಿಫಿಕೇಶನ್ ಇದೆ, 2 years ಆದ್ಮೇಲೆ ಡಿಲೀಟ್ ಆಗುತ್ತೆ.
ಮತ್ತೆ ವಾಟ್ ಡು ಯು ಡು? ಇವಾಗ
2 years ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ.
ಈಗ ಅಲೋ ಮಾಡಿದ್ರು ಏನಾಗುತ್ತೆ?
ವಿತಿನ್ 2 years ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ ಲಾರ್ಡ್ಶಿಪ್.
ಅಲ್ಲ, ಆರ್ಡರ್ ಆಗಿದೆ, ಬಟ್ ಈಗ ಅಲೋ ಮಾಡಿದ್ರೆ ಏನಾಗುತ್ತೆ ಹೇಳಿ? ಟುಡೇ ಐ ಅಲೋ your application. If the data is deleted as per the government direction, and what is the use of the?
ಪ್ಲಸ್ ಸೆಷನ್ಸ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ವಿತಿನ್ 2 years ಅಲ್ಲಿ ಆರ್ಡರ್.
ಅದು ಆಯ್ತು, it's now gone. Today we are at a stage where it is 3 years. Does the sessions court say that it should be preserved?
ಪ್ರೊಡಕ್ಷನ್ ಆರ್ಡರ್ ಮಾಡಿದೆ.
ಪ್ರೊಡಕ್ಷನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ಪ್ರೊಡಕ್ಷನ್ ಆರ್ಡರ್ ಯಾವಾಗ ಆರ್ಡರ್ ಮಾಡಿದ? 2 years ಒಳಗಿತ್ತ ಅದು?
ವಿತಿನ್ 2 years. ಅಟ್ಲೀಸ್ಟ್ ಪ್ರೊಡಕ್ಷನ್ ಆರ್ಡರ್ ಮಾಡಿದಾಗ ಒಪ್ಪ ಮಾಡಿರ್ತಾರೆ, ಅದನ್ನ ಸೀಲ್ಡ್ ಕವರ್ ಅಲ್ಲಿ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕಸ್ಟಡಿಗೆ ಆದ್ರೂ ಕೊಡಬಹುದಲ್ಲ.
The trap was
That is
laid
also
in the
preservation.
2020. Please.
When did the court direct production of that CDR?
Lord,
November 2023.
17/11/2023.
17/11,
Sir,
date of trap in?
Date of trap, Lord, on 1.
2/12/2021. All right. 17/11/23 is the allowing of
9/11.
the application.
9/11/23 ಲಾರ್ಡ್ಶಿಪ್.
9/11/23. So it is within 2 years.
ವಿತಿನ್ 2 years.
All right.
Please,
When did you file this petition? 14 June 24.
please.
What have you done with the data now?
Lord, what the information he sought, Lord. Lord, as per the complainant, Lord.
If you have deleted the data, adverse inference will be drawn because order was passed prior to 2 years. You have challenged it only after 6 months, 7 months after the passage of the order.
Lord, the application was filed in the year 2023.
ಹೌದು ಸರ್, 9/11/23 is the order.
Please,
Correct. 7 ತಿಂಗಳಾದ್ಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ ನೀವು.
yes.
He is right in saying that data should be preserved.
Lord, it is our case, Lord. I have to prove the case, our case, Lord. He can take a defense at the stage of defense when it is posted for defense.
So preserve the data. In terms of the order, data should be produced at the stage of evidence. I will order that.
Lord, what the information, kindly see the order, Lord.
Sir,
He is
if you are-
seeking the
if you are
tower
pleading
location.
impossibility of production of a data on the score that it would be deleted in terms of the government order or government circular, you cannot now do it because you're 6 months late.
I'll verify it, my lord.
What verify?
Whether it is preserved or.
ಇದೆ ನಿಮ್ಮ ಇವ್ರ ಹತ್ರ ಇದೆ ನೋಡಿ. He will have everything ಕೊಡಿ.
2021 ಡಿಸೆಂಬರ್ ಅಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. 1 year ಇದ್ದಿದ್ದು 2 years ಸ್ಟೋರ್
2 years ಮಾಡಿದಾರಾ? Anything else, sir?
I'll cross verify it, my lord.
ಇದನ್ನ
whether
verify
it is
ಮಾಡ್ತೀರಾ?
No, my lord.
ಹಾ.
Whether they preserved or now it is available or not.
ಅಲ್ಲ, if it is not preserved, deleted ಅಂತ if you come, that will run counter to the order.
I'll make submission.
ಈಗ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀವ ಇದರಲ್ಲಿ?
There is a stay.
ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ದು?
Lord, interim order was granted.
7/8/2024.
7/8?
2024.
8/7/24.
8/7.
Please.
All right. So March order has flown. 23 ಗೆ ಆಗಿರೋದು order. You better will preserve it because interim order is granted after 7 months or 8 months. I'll take it on Friday.
Please.
If there is no information, we will dismiss this petition, directing its preservation till he files an application or revives it.
And next week.
Tuesday, yes, list on Tuesday in the fresh matter, Wednesday in the fresh matters list. Yes. Idu file ಅಲ್ಲಿ ಇರಲಿ madam. Yes, next.
The petitioner speech.
ITP and 370, sir.
Yesterday, my lords had directed the state to.
They've employed the foreigner.
Huh?
They've employed a foreigner in the spa.
So foreigner ಇದ್ದ ತಕ್ಷಣ it is presumed.
No, that is not the only thing.
Then, sir.
There is also
But
a Mazar, my lord, which speaks about.
Give the records.
In the Mazar, my lord, it speaks about the.
List this on Wednesday in the fresh matters list. ಇದೊಂದು madam. ಈ records receive ಮಾಡ್ಕೊಂಡಿರ್ತೀರಲ್ಲ, ಮಾತ್ರ ಕಳಿಸ್ಬೇಕು. ಸರಿ, CH-3 ಜೊತೆಗೆ ಅದೊಂದು ನೋಟ್ ಮಾಡ್ಕೊಂಡ್ರೆ. Yes. Next.
Await services. Await service.
Post immediately after service of notice upon the respondent.
Entry mod.
ಇದೆಯಾ interim?
It is error.
Subsist, interim order, comma, if any subsisting shall continue to the next date of hearing.
In both.
ಇದ್ರೆ. Oh, sorry, list note.
Here for the petitioner.
My lord, it appears in this matter, the police may not file a B report. And then, my lord, a protest memo was filed, protest memo has been accepted. And then, my lord, there is a further order for investigation by the magistrate. So, my lord, they have to tell your lordships what they have done, and
Where are the
last time
papers?
last time that was what was required to be done.
Additional SPP is directed to.
Password, my lord. Exactly. Received the papers.
You have received the papers. Anyway, I have granted some protective order.
No, my lord, your lordship said after the. I'm seeking for a protective order.
Yes, we'll pass it over. Password. 4 o'clock. Yes.
Anyway, I have another matter, my lord.
Then come. Yes. Oh, that further hearing matter.
Yes,
All
further. Yes.
24.
Petitioner. Lords, this is a matter wherein, my lords, initially there was an apprehension by the respondent number 3 that there is companies which are being floated in India where they are they have launched betting apps and they try to destabilize the economy. On that information, my lords, the respondent number 1 and 2 register an FIR against 9 companies.
Correct.
On the 9, all the 9 companies, they call for records, and 7 of them are probably guilty, please, my lords. 2 of them, we, especially the petitioner herein.
Not guilty at all.
No, we give whatever documents are given, asked for. And we show our bona fide saying we are people who are manufacturing wheelbases and we are exporting it, importing it from China. Now we want to start a plant here, manufacturing plant here. We have acquired lands in Siri City. We showed them all those things. They defreeze the account. But only problem was, my lords, now they have not filed charge sheet. Because my name is reflected as an accused, nobody is doing business with me. It's a small marketplace, my lords. We have only two customers, TVS and Honda. They are not doing business with me. On that pretext, my lords, we are come here.
What
On
is
the-
your company? Chong Quing Jeli. What do you mean by that?
It's a name, please. my
A
lords.
name, all right, yes.
That's why it's the only ground, please, my lords. The 2 years, 2.5 years have lapsed. They have asked for every documents, they defreeze the account. If they say now that there is nothing, I have nothing to do with the crime which has been reported, it may be quashed. Because they cannot file a charge
So
sheet.
you are dependent on his say. We will ask Shanti Bhushan.
They say of R1, R2.
My learned friend has
You're
to
the-
say why he is the investigation, my lord, with regard to the investigation.
2 ವರ್ಷದಿಂದ ಇನ್ವೆಸ್ಟಿಗೇಷನ್
What
ಮಾಡ್ತಾರೆ.
happened, I believe, my lord, that number of complaints was given on the same day with respect to all these Chinese apps.
All right.
About 60 plus charge sheets have been filed,
ಇವ್ರದ್ರಲ್ಲಿ
right?
ಹಾಕಿದ್ದಾರೆ.
Not against him, in all the complaints which they have given on that day.
All right.
So some more cases are being investigated, but this case, my lord, it is not a Chinese app, loan app case.
If it's not, then why freezing of the account?
Freezing.
No,
the
freezing, they defreezed it. Now
Already-
it is being showed as an accused. I have been showed as an accused, that's all.
Investigation officer says, my lord, since it is not a Chinese loan app case, they probably file a different report.
Please.
ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕ್ತೀನಿ ಅಂತ.
Ma'am,
Only against me, if they file B report, I have no problem. But they are not filing it only against me.
ಅದೇ ಬೇರೆಯವ್ರಿಗೆ ಯಾಕೆ ನೀವು worry ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
No,
Only
they can't
against
file
you.
a partial final report. That's the only
Why
problem.
are you worried about others?
we have filed 60 plus charge sheets.
ಚಾರ್ಜ್ ಶೀಟ್ಸ್ ಹಾಕಿದ್ರೆ ನಿಮ್ಗೆ ಹಾಕಿಲ್ಲ ಅಲ್ವಾ ಇನ್ನು? ಆಯ್ತು, ಈ ಕಾಂಗ್ ಚಿಂಗ್ ಜೈಲಿಗೆ ಏನ್ ಮಾಡ್ತೀರಾ ಹೇಳಿ.
Time, my lord, we will file a.
ಯಾವತ್ತು when will
No, problem is time only, please, my lords.
ಪ್ರಾಬ್ಲಮ್ ಇಸ್ ಟೈಮ್.
Please.
ಜಾಸ್ತಿ
ಏನಾಗಿದೆ ಅಂದ್ರೆ-
ಜಾಸ್ತಿ ಕೊಡಲ್ಲ. Yes. Come up with whatever you have.
End of the month, my lord.
We'll take it on 25th. By then, if it is not there, I'll quash it.
Published.
I'll consider quashing it. ಯಾಕಂದ್ರೆ ರೆಕಾರ್ಡ್ ಬೇರೆ ಆಗ್ಬಿಡುತ್ತಾರೆ. ಕ್ವಾಶ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಿ ಅಂತ. Yes.
Yesterday, my learned friend told my lord.
No, no, I'll
Constitution is
rise.
not cooperating. That was when I don't know that I. But I'm scared now.
ಎಲ್ಲ don't tell anything in the lighter way, sir. Yes.
Published.
I meant his client, not his.
ಗೊತ್ತಾಯ್ತು. Well, he will not mind. He knows what Jagdish is. Yes.
25.
My lord, I filed my wakalat in the counter yesterday, please, my lord, for R2.
ಯಾರಿಗೆ ಸರ್?
R2, respondent number 2. R2, I filed my wakalat in the counter yesterday.
Lord,
My name is not shown.
Petitioner in criminal petitions.
Come this side. Come this side, sir. You are the petitioner, right? Now, why are you standing away from him? Yes.
Lord, there's a writ petition pending before your honors, writ petition number 7122 of 2024.
ಅದು
wherein-
482 ಏನು?
Read with 482, yeah.
711 ಇದೆಯಲ್ಲ already
In
connected.
the last occasion, your lordship had connected this matter with my matter, my lord.
All right.
Yes.
ಏನ್
Lord,
ಪ್ರಾಬ್ಲಮ್?
In that, there's a stay operating. again.
ಏನಾ?
In my matter, there's no stay. my
All
lord.
right, sir.
It's
Yes,
upon my-
Tulsi Kumar, sir.
I'll file my statement of
Every
objection,
case will stay.
my lord. My name may please be shown, please.
The learned counsel B.N. Tulsi Kumar submits that he has ಅವ್ರ ಹೆಸರು ತೋರಿಸಿ ಅನ್ಬಾರ್ದಾ? ಸ್ವಲ್ಪ ಇರಿ. Yes. The learned counsel B.N. Tulsi Kumar submits that he has entered appearance for the second respondent. Registry to print the name of B.N. Tulsi Kumar is appearing for the second respondent. ಏನ್ ಹೇಳಿ?
Case filed by me, my lords, the petitioner in the cell number 25 is the complainant.
You're the complainant.
My contention,
Why do you want to stay in that?
my lord, no, my lord. There's a counter blast.
Wherein he is.
It is arising out of the same crime, my lord.
That two different FIR.
But it's arising
You
out
have
of the
been
same.
protected, will protect him also. This court, ನಿಮ್ದು ಯಾವ್ದು 7122 ನಾ?
7057.
This court in writ petition 7122 of 2024 on 27/3/2024 has passed the following order. In the light of the common facts obtaining in both these cases, there shall be an interim order of stay of further proceedings in criminal petition 7057 of 24 as well till the next date of hearing. List on 26th, yes.
Great.
Interim order subsisting in so and so shall continue till the next date of hearing.
Great.
Stay application alone. Yeah.
Hmm.
26. Next week. Okay, sir. List after 2 weeks. Yes, next. Next bench munde try ಮಾಡಿ. Yes. Huh?
During the course of the day, my lords.
Interim order ಇದೆಯಾ?
Ide Swami.
Learned counsel submits that needful would be done in the next 2 days. In the event needful is not done in the next 2 days, interim order subsisting will stand vacated. Yes, next. Subject to the aforesaid condition, interim order stands extended till the next date of hearing, list after 4 weeks. Next.
28.
For petitioner minutes. It's 138 proceedings minutes. Absolutely non-compliance of section 56. Without endorsing the payment made by the.
Without?
Endorsing any payment minutes, they have.
No, that's all right. Where? Counsel for the petitioner to serve on the counsel.
Already served.
ಆಗಿದೆಯಾ?
ಆಗಿದೆ. 6/9 ಅಲ್ಲಿ ಆಗಿದೆ.
List the matter after 2 weeks awaiting the representation of the counsel for the awaiting the representation of the respondent. There shall be an interim order of stay of further proceedings further proceedings before the concerned court till the next date of hearing. Next.
29.
354, my lord. Lord, there is a dispute with regard to property between the, my lord, the complainant's wife, sister, husband, family, and my lord, accused number 4.
Learned HCGP Tejesh to secure the investigation papers.
But in fact, I have placed all the records, my lord. Charge sheet is filed here.
The entire charge sheet material is not produced,
Ah.
my lord. Inside-
Well, if you go by this, then I will dismiss it. Wound certificate ಇದೆಯಾ?
ಇದೆ.
ಕೊಡಿ. Anything else?
Lord, wound certificate, my lord, that is against, my lord, accused number 2 to 4, not against A1. As far as A1 is concerned. As far as, my lord, allegation against A1 is concerned, my lord, he slapped, my lord, the on Uma Devi. She is the mother of, my lord, the, no, that is allegation. My lord, as far as, my lord, assault is concerned, my lord, that is against.
That's a matter of trial, sir. 354B is what is alleged.
My lord, hear the case, my lord, kindly appreciate. My lord, here, my
A1
lord,
ಮೇಲೂ allegation ಇದೆ.
Huh?
A1 ಮೇಲೆ even in
ಯಾಕೆ?
number
ಎಲ್ಲ
31,
ಇದೆ.
kindly see.
ಅಲ್ಲಲ್ಲ, A1, my lord, as per the charge sheet allegation, my lord, as far as the A1 is concerned, Lord, ಸಾಕ್ಷಿ ಅವರ ಬಟ್ಟೆಯನ್ನು ಹಿಡಿದು ಎಳೆದಾಡಿ ಕಪಾಳಕ್ಕೆ ಹೊಡೆದಿದ್ದು. Lord, that is,
ನಿಮ್ಮ ಮೇಲೆ.
as far as A1 is concerned.
ಸಾಕಲ್ಲ?
Lord,
Anything else?
kindly appreciate, kindly appreciate. My lord,
Anything
yeah,
else?
my lord, he being the, my lord, the police officer, my lord, he is nowhere concerned with the, my lord, the dispute with regard to, my lord, the family of A4.
Take chance, October 2nd week. List in the 2nd week of October.
But three,
Pendency
my
of this petition
as
will
far as
not come in the
354
way
is
of further
concerned, there is
proceedings
no
before the
ingredients,
concerned
my lord.
court. Yes. Sorry. ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ.
Lord, in so far as
Change ಆದ್ರೆ
350
chance.
ಅಲ್ಲಲ್ಲ, 354 is concerned, Lord. Lord, there is no ingredients of 354. here.
ಇದಕ್ಕಿಂತ ಬೇಕಾ?
Lord, kindly see, Lord, in terms of the judgment
Yeah.
of apex co.
Groped her and
My lord,
that's a matter after evidence. Sir. ಕೊಡಿ 482 354 ಕೊಡಿ.
482 ಆಯ್ತು, and in the appeal.
Yes.
Lord, some and substance, Lord, I just pass on this. Lord.
I will hold some and substance.
Allala, my lord, when, my lord, 354, my lord, my lord, that come into play. I just, my lord, my lord, first, my lord, in the bottom, what constitute?
No. ಇದರಲ್ಲಿ hair, the accused had dragged the hair and pulled her.
Here, my lord, in this case, what happened, my lord, why, my lord, how, my lord, in what circumstances, my lord, 354, my lord, gets subtracted, that's, my lord, it's, my lord, called out here.
Yes, 2nd week of October. Yes, next. Give the papers back.
My lord, petitioner is accused number 4, my lord. Accused number 1, 2, 3, and 5 been acquitted, my lord. Split up charge sheet.
Split,
Yes, my lord.
Pages.
My lord, 116, my lord.
116.
6, my lord.
Paragraph. Adena,
Yes, my lord. First, but from page number 116, my lord.
as per prosecution, para 16,
Yes, my lord.
is government,
Please.
page 116. Kavya, 116 to 118. The petitioner is accused number?
4, my lord.
Accused number 4. He, along with other accused, would get embroiled in a crime in narration in crime number 133 of 2015 for offences punishable under section 324, 323, 447, 149 and 506 of the IPC. The petitioner is arrayed as accused number?
4, my lord.
Accused number 4. At the relevant, the police, after investigation, filed a charge sheet. The concerned court would try the other accused who were available for trial in CC 293 of 2016. On the score that the petitioner was not available for trial or had escaped trial, a split-up charge sheet is drawn against him in CC 14 of 2019. The concerned court, after drawing up of the split-up charge against the petitioner, acquits the other accused in terms of its order dated 17/1/2019. In terms of its order dated 8/2/2021. The accused who are acquitted are accused number 1 to 3 and 5. Who remains in the story of crime is the accused number 4, the present petitioner. The learned counsel for the petitioner submits that the reasons so rendered by the concerned court to acquit accused 1, 2, 3 and 5 would 1, 2, 3 and 4.
1, 2, 3 and
1, 2,
5.
3 and 5 would inure to the benefit of the petitioner, as what is alleged is a common act performed by all the accused. He would seek quashment of the proceedings. The learned HCGP would refute the submission contending that the petitioner has escaped trial and should not be shown any indulgence. He should undergo the trial and come out clean, as the other accused have undergone trial and come out. I have given my source. The four narrated facts are not in dispute. The petitioner is the one who has escaped trial. In the normal circumstance, would not be shown any indulgence for quashment of the proceedings to a person who did not stand trial like the other accused. The permitting further proceedings against the petitioner on the aforesaid score would only result in wastage of precious judicial time, as eventually the petitioner would get acquitted. For the reason that others are acquitted due to lack of evidence. The lack of evidence qua other accused cannot spring as evidence in the case of the petitioner accused number 4. In that light, I deem it appropriate to obliterate the crime against the petitioner. The view of mine source. Yes. Next.
51,
Covered, same, disposed.
52.
One submission.
You know,
There are 2 pending petitions. Only one of them has
Kodi,
been
Kodi,
listed today.
Kodi, give that.
Much.
Number Kodi. To the experiment. Does not.
Much of it.
Therefore, the petition,
32.
therefore the petitioner, madam.
Huh?
Therefore the petitioner, petitioner is,
ಆಮೇಲೆ
therefore the petitioner.
ಅದಾದ್ಮೇಲೆ ಹೇಳಿ ಸರ್.
Petitioner is a student, my lord.
Student.
He is studying second year PUC. Have produced an actual A, my lord.
NDPS sir.
Pending case, my lord.
Yes. 27B ಕೊಡಿ. ಏನಿದೆ?
One submission.
Confession ನಾ?
One submission, my lord.
ಹೇಳಿ ಸರ್.
Earlier, we have challenged the same FIR, my lord, that has been quashed on the ground of FSL report is not submitted, my lord.
Page number.
Para 6 of the annexure B, I have annexure B, my lord.
Number 4, my lord, impugned judgment. There's no FSL report, my lord, on that cause.
ಇದರಲ್ಲೂ ಇಲ್ವಾ? We'll say it as covered and close it.
One submission, it is a competent, government doctor is not a competent authority to issue this medical certificate. They have not issued the certificate.
We will hold it is covered by what is written by the coordinate bench and close it. The petitioner is before this court. calling in question registration of a crime in crime number 99 of 2024 registered for offences punishable under section 27B of the Narcotic, Drugs and Psychotropic Substances Act 1985, hereinafter referred to as the Act for short. Then reference ಬೇಕಾಗಲ್ಲ ಬಿಡಿ. Yes, so and so. The learned counsel appearing for the petitioner submits that against the is a different crime ಅದು
Same crime, same crime.
1453 ಏನ್ crime ಅದು FIR stage
FIR states. FIR is quashed.
ನಿಮಿಷ
Criminal proceedings.
different crime ನೀವು ಹೇಳಲ್ಲ
Crime
ತೇಜಸ್.
number.
It is a different crime, my lord, but
Crime number one.
The learned counsel appearing for the petitioner would seek to place reliance upon an order of the coordinate bench in criminal petition 1453 of 2023, by which the coordinate bench had obliterated the crime registered against this very petitioner in crime number 1 of 2023. The subject crime is different, but the finding rendered therein would inure to the benefit of the petitioner as the grounds urged and the grounds answered by grounds urged would cover the grounds answered by the coordinate bench in the aforesaid judgment. The coordinate bench has held as follows, para 3 to end. In that light, the following order allowed quashed. Next.
33.
A1 ಇಲ್ಲ ಬೇರೆಯವ್ರಿಗೆ ಮಾತ್ರ. Yes, Kashkan. Yes, no A1. Next.
34.
List on 20th. Yes.
35.
Fresh matter.
20.
Fresh matter.
ಬೇಡ. List on 20th at 4 PM ಅಂತ ಹಾಕಿ ಮಾಡಿ dictation.
35.
Appearing for the petitioner. Atrocity Act, my lords, make a recollection. Atrocity Act, my lords.
Yes, sir.
Petitioners are, my lord, 78, 76 and 69-year-old. There was an issue between petitioner and the complainant with regards to the car parking. That has now, my lord, ended up in filing the FIR and a counter FIR.
ಕೌಂಟರ್ FIR ಇದೆಯಾ?
Please.
ಅದನ್ನ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ? ಯಾವ್ದದು? ಲಿಸ್ಟ್ ಆಗಿಲ್ವಾ ಅದು? ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಾ ನೀವು?
ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
ಎಲ್ಲಿ ಮಾಡಿದ್ದೀರಾ? ಅದು ಚಾಲೆಂಜ್ ಮಾಡಿ 2 ಕಾಸ್ಟ್ ಮಾಡೋಣ. ಕಾರ್ ಪಾರ್ಕಿಂಗ್ ಜಗಳ ಎಲ್ಲೆಲ್ಲಿಗೆ ಹೋಗಿದೆ? ಯಾವ್ದಕ್ಕೆ ಫೈಟ್ ಮಾಡಬೇಕು ಅಂತ?
Till then, there may 78-year-old, kindly.
1 minute, sir. Yes. The list the matter on 25th. ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ. List the matter on 25th. There shall be an interim order of stay where these petitioners till the next in the impugned proceedings till the next date of hearing. You also file. Well, good.
Great.
25th ಹಾಕಿರ್ತೀನಿ. 25th in the fresh matters list.
36.
Happy for the petition. Forest matter. File our objections. We have filed our objections.
So I not serve the copies.
Normally send an email. I'll give a copy.
Yes. 18th.
Please, madam. Lordship, have it on 19th.
19th. Interim order ಇದೆಯಾ?
Interim order not to pursue any further action at this.
The issue is, my lord, he is challenged in this writ petition, notice issued to him is under 64A proceedings.
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ. Forest Act.
The entire proceedings.
No, you have challenged that. Then you should go to the GM court.
He challenged the FOC, but the notice is produced or the notice issued under 64A proceedings.
Because the proceedings, my lords, which was initiated against the violation of the certain acts.
19th is the fresh matters list.
Because there are several sections have been levied, my lord. I have challenged that also.
Imposed. Imposed. Levied tax. Yes.
37.
Sawmill. ನಡೀತಾ ಇದೆಯಲ್ಲ sawmill? Yes, Latif.
ನಡೀತಾ ಇದೆ.
ಏನು ವುಡ್ ಕೇಳ್ತಾ ಇದಾರ? ಪೆಟಿಷನ್ ಕಾಪಿ ಕೊಡಿ. ನಿಮ್ sawmill ಇಂದ ಏನ್ ಕೇಳ್ತಾ ಇಲ್ಲ.
ಕೊಡ್ತೀವಿ.
Yes. Counsel for the petitioner is directed to serve complete set of papers upon the council is Bhimaya forthwith. List the matter. In the second, third week of October, interim order subsisting shall continue till the next date of hearing. Next.
This case, I am the petitioner. Petitioner is a complaint before the trial court. He filed a complaint.
Post immediately after service of notice.
Take notice
for.
Notice is not necessary.
Not necessary.
Because Millard, the complaint.
Party ಯಾಕೆ ಮಾಡಿದ್ರಿ?
Normal party ಮಾಡಿರೋದು, but it-
ಅವ್ರು ನಾರ್ಮಲ್ ಆಗಿ ಬಂದಿದ್ದಾರೆ ಇಲ್ಲಿ. Wait, yes sir.
I'll take notice for Milord 4, 5 and 6.
Millard,
Lord, in
date
fact,
is there,
in,
trial court date is there.
In criminal revision petition, Milord, I have represented all the respondents. No, I have not received instructions.
1 minute sir.
Kindly see Millard, annexure B Millard for a moment. ನಾನು ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ, PCR ಒಂದು ಸೋನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಆಗಿದೆ. ಸೋನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಆದ್ಮೇಲೆ 201 ಕಡೆ ರಿಟರ್ನ್ ಮಾಡಿದ್ದಾರೆ. That is not correct.
He's also challenged criminal RP order where I have been a party and it is dismissed on.
Revision petition ಏನಾಯ್ತು?
Revision petition dismiss ಆಗಿದೆ.
Confirm ಆಗಿದೆ ಆರ್ಡರ್.
ಹೌದು.
But Millard,
Yes, the learned counsel. Kasif undertakes to enter appearance for respondents.
Lord, 3, 4, 5 and 6.
Respondents 4, 5 and 4, 5 and 6.
I had appeared for all the people in the trial court.
Take notice.
I'll take notice.
Learned
Except
counsel-
for respondent number 3, Milord, I'll take notice because
The
that I have
learned
not.
counsel would undertake to enter appearance for all the respondents except respondent number 3.
Please.
Registry to print the name of Kasif as appearing for all the respondents except respondent number 3. Respondent number 3 ಗೆ emergent notice ಮಾಡಿದೀವಾ? Emergent notice to the ಆಗಿದೆ already. Yes, so and so.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 19th ಇದೆ.
ಇರ್ಲಿ ಏನಕ್ಕೆ? So what?
Until then ಅವರು ನಮ್ಮಲ್ಲಿ ಮತ್ತೆ ಕೇಸ್ ಡಿಸ್ಮಿಸ್ ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದಕ್ಕೋಸ್ಕರ
ಏನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ?
ಅವರು ರಿಟರ್ನ್ ಮಾಡಿದ್ದಾರೆ. 4th ASM ನಾವು ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡಿದ್ವಿ. ಲ್ಯಾಕ್ ಆಫ್ ಜೂರಿಸ್ಡಿಕ್ಷನ್ ಅಂತ ಹೇಳಿ ಅದನ್ನ ನಮಗೆ ಮತ್ತೆ ರಿಟರ್ನ್ ಕೊಟ್ರು.
It was returned, but he has represented it also.
List on 18th in the fresh matters. Next.
39.
A2.
A2, Milord.
A1 gyara.
A1, yeah.
A1 what is the matter?
Milords, this is a crime against the petitioner, Milords, for the offences under section 13(1)(a) of PC Act 468, 471 and 477. Milords, there was
Why are you now before the court?
Milords, there was a departmental proceedings, Milords, which was
ಅದರಲ್ಲಿ exonerate
exonerate ಆಗಿದ್ದಾರೆ.
13(1) ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎನ್ಕ್ವೈರಿ ಮಾಡಿದ್ರಾ?
ಅಲ್ಲ, on consequence of this registering of the FIR, Milords, there was a departmental inquiry.
ನೋಟಿಸ್ ಆಗಿಲ್ವಾ?
Notice ಆಗಿಲ್ಲ.
First time.
Okay.
Learned counsel, BB Patil is directed to accept notice for the respondent petitioner to serve 2 sets of papers upon counsel Sri BB Patil. List the matter on 20th, madam. List on 20th.
Milords, until then, Milords.
Oh.
Milords,
Yes, next. On 20th. please.
wait for me.
Freeze. Yes, government, why freezing of the account?
Milord, he has registered the complaint online, my lord. While registering the complaint, he has given his own account number for
Freezing.
freezing. On
Right.
account of which it has
Mistakes.
mistake ಮಾಡಿದಾರೆ. But the IO, he has brought to the notice of the IO. IO has also intimated the concerned bank to defreeze it. They have to do it. The respondent bank has to do it.
Who is the respondent bank?
Lord, primary and secondary. account.
ಯಾವ bank, sir?
Citibank and SBI.
Who represents them?
Notice ಹೋಗ್ಬೇಕು.
The investigating officer has frozen certain accounts on account of a complaint being registered by the petitioner. Inadvertently, the petitioner has mentioned his own account to be frozen while seeking freezement of the account. The investigating officer has so done is the submission of the learned HCGP on verification of the records. He would further submit that the account of the petitioner is directed to be defrozen by the investigating officer. The banks have not acted so. Therefore, though the banks are represented, notice ಆಗಿಲ್ವಾ ಅವ್ರಿಗೆ?
ಇಲ್ಲ, notice has not been notified.
The emergent notice to the respondent banks, the petitioner is at liberty to produce the said order, which would enable the banks to defreeze the account of the petitioner by the next date of hearing. List the matter on.
Lien is being marked on a daily basis, man. I'm running at 30 lakhs
ಆಯ್ತು, ಈಗ they will do it. List the matter on Wednesday in the fresh matters list. ಇದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಬಾಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ will direct what is to be done.
Please.
Yes. Next. Prepare ಆಗಿಲ್ಲ. PF ಕಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ, ನೋಟಿಸ್ ಆಗಿರ್ಲಿ.
ಆಗಿದೆ ನೋಟಿಸ್. ಇವತ್ತೇ ಕಟ್ಟಿ. Yes. Next.
41.
Post immediately after service of notice. ಇದೀರಾ?
Respondent number 2 in the.
Learned counsel so and so undertakes to enter
I've
appearance.
already filed wakalat yesterday.
Submits that he has entered appearance for the second respondent. Registered to print the name of so and so is appearing for the second respondent. Objections?
I'll file it on the next week, my lords.
Learned counsel seeks 10 days time to file interim order.
No man.
Seeks 10 days time to file statement of objections. Objections, if any, in the next 2 weeks. List the matter after 2 weeks. Next.
42. Charge sheet is filed in this case, my lordship. They have filed the prime lordships.
Charge sheet.
Charge sheet is filed ಮೇಲೆ during pendency of this.
Amend interim order ಇದೆಯಾ?
Interim order ಇಲ್ಲ, ಅದೇನಾಗಿದೆ?
Amend ಮಾಡ್ತೀರಾ?
I will.
Amend ಮಾಡ್ತೀರಾ?
Amend ಮಾಡ್ತೀನಿ.
ಬೇರೆ ಹಾಕ್ತೀರಾ?
Amend ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. Until then, my lordship.
No.
Stay me.
I
No,
will not.
this matter was listed on second, my lordships.
You
They
said you will amend, you will file an amended petition.
Please, my lords,
Ah.
allow me to, my lords,
Yes.
make submission, please, my lords. ಒಂದೇ ಒಂದು submission ಇದೆ.
ಅದಕ್ಕೆ ವಿಡ್ರಾ ಮಾಡಿ ಇಮಿಡಿಯೇಟ್ ಹೊಸದು ಹಾಕಿದ್ರೆ ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಬರುತ್ತೆ. ಇಲ್ಲ ಯು ವಾಂಟ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಓನ್ಲಿ ಅಂದ್ರೆ ಇಟ್ ವಿಲ್ ಕಮ್ ಇನ್ ಅಪ್ಲಿಕೇಶನ್ಸ್.
ಇಲ್ಲ, ಅದು ಮೊನ್ನೆ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಲಾಸ್ಟ್ ಸೆಕೆಂಡ್ ನೀವೇನು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿರಿ, ಸೆಕ್ಯೂರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಪೇಪರ್ಸ್ ಅಂತ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ರಿ. ಅದಕ್ಕೋಸ್ಕರ ಇನ್ ಸ್ಟೇ ಕೊಟ್ರೆ ಇನ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕೋದಕ್ಕಾಗಲ್ಲ ಅಂತ ನಿನ್ನೆ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ಇವತ್ತು ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಿದೆ.
ಪರವಾಗಿಲ್ಲ ಬಿಡಿ, ಆಮೇಲೆ ಸ್ಟೇ ಕೊಡಬಾರ್ದು ಅಂತಿಲ್ವಲ್ಲ. ಏನು ಒಫೆನ್ಸ್?
498A 304B, my lordship.
ಓ ಸ್ಟೇ
ಅಲ್ಲ, ಟೋಟಲ್ ಎಲ್ಲ ಇನ್ಲಾಸ್, ಎಲ್ಲ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಕಂಪ್ಲೀಟ್ಲಿ
ಏನ್
roped in, my lords, falsely roped in.
ಪರವಾಗಿಲ್ಲ, ಆರಾಮಾಗಿ ಹಾಕಿ, ತೊಂದರೆ ಇಲ್ಲ. ಏನ್ ಮಾಡ್ತೀರಾ?
Permit to
Amendment
withdraw,
ಹಾಕ್ತೀರಾ?
permit to withdraw, my lords,
All right. Sir.
with liberty.
Yes. With liberty. File it immediately. No
Please,
problem. We'll consider.
Please. Oblige,
Get the latest judgment of Supreme Court.
please.
Unless demand of dowry is established, 304B will not come.
Please.
That you should travel in that.
ಇಲ್ಲ ತಗೊಂಬಂದಿ.
How manzira? Yes. Justice Pardiwala.
ನಿಮ್ದು ಒಂದು
And ಬೇರೆ.
ನಿಮ್ದು ಜಡ್ಜ್ಮೆಂಟ್.
ಸರಿ ಆಯ್ತು, ಕೊಡಿ, ಚಾಲೆಂಜ್ ಮಾಡಿ.
Please.
ಆಮೇಲೆ ಮೂವ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಹೇಳಿ, I withdrawn since charge sheet is filed and we'll take it the very next day. Yes.
43.
My lords, I appear for the petitioner, my lords. My lords, I seek, my lords, 1 week's accommodation, my lords, in the matter. Need to seek some instruction, my lords, from the party.
Only committal procedure, man.
Huh?
Only committal procedure is not followed. There is a contention.
This has to be allowed and sent back ಅಷ್ಟೇ sir.
My lords, a week's accommodation, my lords,
List on
to seek
19th
instructions.
List
My lords,
on
a week's,
material
Please.
instruction.
please.
List on 19th in the fresh matters list as a last chance. Interim order subsisting shall continue to the next date of hearing.
In both the petitions.
ಎರಡಿದೆಯಾ? ಆಯ್ತು.
ಎರಡು.
We'll allow
Same
it and
issue.
send it back.
Please.
Yes.
44.
But in this case, my lord, on a
Please
fake
maintain.
crime,
It
in this
pertains to
case,
Kalburgi branch.
account defreeze, my lord, savings bank account, in the annexure,
ಅಲ್ಲ ಆಯ್ತು, ಆಲ್ರೆಡಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದೆ. ಈಗ ವೈಫ್ಸ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಅದೇ ತಾನೇ ಇದು.
Yes,
ಸುನಿಲ್
ma'am.
ರಾವ್
Yes,
ಅಪಿಯರ್
ma'am.
ಆಗಿದೆ.
Son-
ಕೊಡಿ ಆರ್ಡರ್. ಹಾ. Yes,
full
Jagdish.
copy along with the,
Amount of 50,000 rupees has been, 5 lakh rupees has been received in this account. There
my lord,
Whatever lien is marked and
My lord.
other accounts ಅಲ್ಲಿ ಇದೆ. ತಗೊಳ್ಳಿ ಅದು.
That can be done.
my lord, here, in the complaint, my lord,
ಅಲ್ಲ, just look into it. ನೀವ್ ಯಾರು ಕಂಪ್ಲೇಂಟ್? ಅಂಡರ್ಟೇಕ್. ಅಲ್ಲ, ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸೇ ಬಿಡೋಣ.
my lord, here, I just read the complaint, my lord. Page number 47. It is the interim order passed by this honorable court, along with the updated annexure G. Annexure G ಅಲ್ಲಿ ತೋರಿಸ್ತಾ ಇರೋದು ಮೈನಸ್ ಅಕೌಂಟ್ ಅಲ್ಲಿ ಅವರದ್ದು 20,000 ರೂಪಾಯಿ ಬ್ಯಾಲೆನ್ಸ್ ಇರ್ತದೆ. ಆ 20,000ವನ್ನು ಸಹ ಮೈನಸ್ ಮಾಡಿ 2,51 lakhs ಅಗೇನ್ ಬ್ಯಾಲೆನ್ಸ್ ಮೈನಸ್ ಬ್ಯಾಲೆನ್ಸ್ ಅಂತ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ. ಅಂದ್ರೆ ಇಲ್ಲಿ FIR ಫೈಲ್ ಆಗುತ್ತೆ 1,26 lakhs ಅಂತ ಹೇಳಿ. ಆ 1,26 lakhs ಅಲ್ಲಿ my lord 72 lakhs ಕ್ಯಾಶ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಮತ್ತೆ 5 lakhs ಬೇರೊಬ್ಬರ ಅಕೌಂಟ್ ಇಂದ, ನಾಟ್ ಇವನ್ ಬೈ ಫ್ರಮ್ ದಿ ಕಂಪ್ಲೇನೆಂಟ್.
This was the case of your husband, is it?
ನಾಟ್ ಇವನ್ ಫ್ರಮ್ ದಿಸ್ ಕಂಪ್ಲೇನೆಂಟ್, ಬಟ್ ಫ್ರಮ್ ದಿ ಅದರ್ ಪರ್ಸನ್ 5 lakhs ಇವ್ರ ಅಕೌಂಟಿಗೆ, ದಿಸ್ ಪಿಟಿಷನರ್ಸ್ ಅಕೌಂಟಿಗೆ ಬಂದಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಬೇಕಾದ್ರೆ ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ. ನೋಡಿ.
Yes.
ನಾಳೆ ತಗೊಳ್ಳಿ.
5 lakhs ಹೋಗಿದೆ, that lien can be marked.
That too, my lord, I will read the page number.
So we'll mark lien on that 5 lakhs.
My lord, I will read the complainant.
ಅದು ಬೇಡವಾ?
Complaint ಅಲ್ಲೇ ಇದೆ my lord. ಅದರಲ್ಲಿ
ಅಲ್ಲಿ ಇವ್ರು
ಗೆಳೆಯನಾದ ಬಸಪ್ಪ ತಂದೆ ಉಪಾಶಪ್ಪ ಅವರ ಅಕೌಂಟ್ ಇಂದ 5 lakhs ಬಂದಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
No, that's
ಇವ್ರ
the
ಅಕೌಂಟ್ ಇಂದನೂ ಅಲ್ಲ, ನಾಟ್ ಇವನ್ ಫ್ರಮ್ ದಿ ಕಂಪ್ಲೇನೆಂಟ್ ಅಕೌಂಟ್.
No, that's the matter.
And the same 9 lakhs rupees, so same Siddha, this complainant's friend, ಅವರೇ ಅದರಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡ್ತಾರೆ, there is a separate agreement ಇರುತ್ತೆ, 9 lakhs ಅವರಿಗೆ ಹೋಗುತ್ತೆ ಈ ಕಂಪ್ಲೇನೆಂಟ್ ಕಡೆಯಿಂದ, ಈ victim
These
ಕಡೆಯಿಂದ.
things you should investigate fast and
Yes.
finish it.
No.
Till how long will you keep this maze of facts?
My lord, here 1,26 lakhs ಗೆ complaint.
ಒಂದು ನಿಮಿಷ. Yes. Yes, sir.
But now, we collected all the documents, my lord, which shows the financial trail between all these people, between the petitioner and other people. Basically, my lord,
Complainant,
farmers.
ನಿಮ್ದು ಎಷ್ಟು ದುಡ್ಡು ಹೋಗಿದೆ?
My lords, we are the president of a Basavana Vadagadi Horticulture Farming Production Company. These are all members. We have collected the money and we have transferred them. They are told they will build a poly house and they'll statutory income will come, monthly income will get. It was promised, my lord. Based on that, we have transferred the money.
How much
Even
money you
if I will undertake, my
Wait,
lord.
sir.
My lords, on different occasions, I have transferred the money, my lords. In the complaint only I have stated that on 28/8, 5 lakhs was transferred. And Galaya is honors of member of the company only, my lords.
Total 1.2.
ಗೆಳೆಯನಾದ ಬಸಪ್ಪ
ಪರವಾಗಿಲ್ಲ.
ಅಕೌಂಟ್ ಇಂದ 5 lakhs ಬಂದಿದೆ.
ನಿಮಗೆ ಬಂದಿದೆ ಅಲ್ವಾ?
Yeah.
ಪರವಾಗಿಲ್ಲ.
And 9 lakhs rupees has been given to same member. ಅದೇ ಸೊಸೈಟಿ ಮತ್ತೊಬ್ಬರು ಮೆಂಬರಿಗೆ ಹೋಗಿದೆ.
ಈಗ
ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಸಪರೇಟ್ ಅಗ್ರಿಮೆಂಟ್ ಸಹ ಇದೆ, my lord.
ಪಾಲಿ ಹೌಸ್ ಏನ್ ಮಾಡಿದ್ರಿ?
That is a, my lord, their own, they have invested in the same neighboring village. They invested around 18 lakhs. And when this company, that is
Have you
from the
taken money?
accused company, 1,80 lakhs has.
Have you taken money from these people?
No, my lord.
Why?
That is actually, my lord, here only
Who has taken
42
money?
lakhs, only with regard to 42 lakhs rupees.
Now 5 lakhs lien will be marked. Yes. ಅದು ಮೈನಸ್ ಅಲ್ಲಿ ಇದ್ರೂ ಪರವಾಗಿಲ್ಲ, ಹೆಂಗ್ ಬರುತ್ತೆ ಅವಾಗ ಲೀನ್ ಮಾರ್ಕ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ. The petitioner is before this court seeking defreezement of the account that is frozen on account of idyavadu Kalburgi bench.
Yes.
I have considered on account of certain crimes being registered against the petitioner. Against this petitioner, the allegation is that there is a transfer of 5 lakhs for construction of a poly house. The learned counsel for the petitioner would submit that the amount is not received from the hands of the complainant, but his friend. Be that as it may, since the freezement of the account of the petitioner would cause hindrance to the transactions and to the property of the petitioner, as the account held is akin to a property held. Therefore, I deem it appropriate to direct marking of a lien of 5 lakhs that has come into the account of the petitioner and permit defreezement of the account for it to become operational as usual. Yes. Operational in the normal way. Yes. And delivery. Idyaಕೆ ಬರುತ್ತೆ ಬಿಡಿ. Yes. Next. Or register to print the name of so and so on the
Petition.
yes, fine.
Petition can be disposed of. That's
I will, all right.
other prayers are saying that police should not arrest him, harass him and other things. Main prayer is.
Will dispose it or what?
Yes, my lord, here,
ಮತ್ತೆ ಈಗ argument, let it come. Yes, next.
my lord, based on one small complaint, 2 crore, ಅದರಲ್ಲಿ 42 lakhs ಮಾತ್ರ ಬ್ಯಾಂಕ್ ಟ್ರಾನ್ಸ್ಫರ್ ಅಂತ
That's all right, sir.
2
Yes.
crore 52 lakhs ಲೀನ್ ಮಾಡ್ತಾರೆ.
No, no. Yes, next.
45. 45, I'm requesting for passover, my lord.
45 requesting passover.
My senior has stopped.
Passed over by 1 week, 20th. Yes.
Kindly, my
next.
lord. My lord, at
In
2:30.
7A alva?
Please, ma'am. I'm requesting for interim order, my
No,
lord.
7A, 20th. Yes.
My lord, I'll take one chance, my lord, in the afternoon.
20th.
In the
You can
afternoon.
take a chance. Yes. 46 to 7A.
Illa, my lord. Matter pertains to disproportionate asset, my lord.
13.
Please.
Yes, sir.
The alleged properties.
20th, yes.
My lord, there is a threat of suspension, my lord. Your lordships have granted interim order in similar circumstances. The alleged properties.
ನೆನ್ನೆ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಕೇಸಲ್ಲಿ ಅವ್ರು ಮಾಡಿದ್ವಲ್ಲ.
alleged properties
No
are
coercive. The list on 20th, no coercive or precipitative action. shall be
Annexure J,
taken.
my lord, in
No.
similar circumstances. my lord.
Service matter mail ಮಾಡಬೇಡಿ ಅಲ್ಲ. No coercive or precipitative action shall be taken against these petitions. ನೆನ್ನೆ ಮಾಡಿರೋದು ಅದೇ ಅಷ್ಟೇ.
Annexure J, my lord, kindly see.
ಇಂಡೈರೆಕ್ಟ್ ಆಗಿ ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ ಸ್ಟೇ ಕೇಳ್ದಂಗೆ ಕೇಳಬೇಡಿ. ಎಸ್ ನೆಕ್ಸ್ಟ್.
Please.
ಎಸ್ ಅರೌಂಡ್.
For the petitioner. Now, the third respondent entertains a complaint from the fifth respondent on the allegation that he had deposited a sum of rupees 3,05,000 in a link which is forwarded by his brother, and the company has not refunded the amount. Not what this investigating officer does is, he freezes the bank account of 116 persons and liens not 3 lakhs in every account, 116 accounts.
We'll see, yes. Not learned additional SPP is directed to accept notice, secure the investigation papers and the role of this petitioner in the alleged episode of crime. By ಈಗ respondents ಯಾಕೆ ಮಾಡಿದ್ರಿ ಇವ್ರನ್ನೆಲ್ಲ?
Not sir, amounts are freezed. My bank accounts are freezed.
ಅವ್ರ respondents da?
ಹೌದು. From 6 and 7, we have the bank accounts. Petitioner number 2 is the wife of the first petitioner. She is also having a bank account. That account is also freezed.
Oh, Axis Bank. Yes. So get the papers. Petitioner to serve 2 sets of papers upon the learned additional SPP, 18th fresh matters. Next. 18th ಇಲ್ಲ 19th fresh matters.
ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದ್ದಾರೆ. He is the only employee. ಅವನೇನು ರೋಲೇ ಇಲ್ಲ.
ಕಸ್ಟಡಿ ಇರೋಕ್ಕೂ ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ಗೆ ಏನ್ ಫ್ರೀಸ್ಮೆಂಟ್ಗೆ ಏನ್ ಸಂಬಂಧ?
ಅಲ್ಲ ಅದು ಇರ್ಲಿ ಮತ್ತೆ ಬಟ್ ಈಸ್
ಬೇಲ್ ತಗೊಳ್ಳಿ. ಸೆಕ್ಯೂರ್ ಬೇಲ್. ಎಸ್.
18th ಸಂದೇಶ 19th minutes.
19th fresh matters.
But I seek a week's time, Lord, we are happy for R2.
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
Covered by decision, the Islamic Court Master.
ಏನ್ ಸ್ಯಾಂಕ್ಷನ್?
ಅಲ್ಲ 498A.
It's between the colleague advocates, Lord.
Petitioner 1 and 2 is the husband and wife, Master.
Today only I received the paper.
Today
Joint Wakalat and I'll file.
ಇಲ್ವಾ? Learned counsel
ಇಲ್ಲ,
appearing for the second respondent seeks a week's time.
My lordship, one submission.
Seeks a week's time. List the matter on 20th.
My lordship, one submission. Covered by decision, ತಾವೇ ಮಾಡಿರ್ತಕ್ಕಂಥ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ. ಯಾಕಂದ್ರೆ ಅವ್ರು ಮದ್ವೆನೇ ಮಾಡ್ಕೊಂಡಿಲ್ಲ, ನಾನು ಕ್ಲೈಮ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
20th ನಾನೇ ಮಾಡ್ತೀನಿ. Yes. List the matter on 20th in the fresh matters list. Yes. Objections square the office the statement of objections be complied by then.
Entry ಮಾಡಬೇಕು.
Entry order subsisting shall continue till the disposal of the petition. Next.
49.
For petitioner in this matter, my lord, needful has been done.
Learned counsel submits needful has been done office to verify. Next.
Stay ಇದೆ.
Entry order subsisting shall continue. Next.
50.
Vacating stay, Siddharth.
Online transaction through bank only they have received the two and a half 33 lakhs and order. And by suppressing the material facts, these people have obtained the interim order of stay. Malad.
Yes.
There are
Interim
several
order by
complaints.
coordinate bench.
Coordinate bench.
Yes, sir.
Malad, there are several complaints registered by the IVO. That is the reason why from Kuvembinagar police station to CCB it has been transferred. Even this de facto complaint has been taken for granted by taking away money through bank transfer itself. In the guise of getting some help from the government and other things, these people have cheated. There are the
How much money, sir?
33 lakhs and odd, my lord.
ನಿಮ್ ದುಡ್ಡ?
ಹೌದು ನನ್ನ ಬ್ಯಾಂಕ್ ಇಂದ ಹೋಗಿರೋದು ಸ್ವಾಮಿ.
ಬ್ಯಾಂಕ್ ಇಂದ ಹೋಗಿರೋದ?
ಹೌದು, ಬ್ಯಾಂಕ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್.
ಯಾರಿಗೆ ಹೋಗಿರೋದು?
ಅವ್ರಿಗೆ ಅಕ್ಯೂಸ್ ಗಳಿಗೆ. The accused number 1 is absconding now. Till today he is not traceable.
Who is accused? Your accused number?
I am accused number 2 and 3, please.
Your account ಹೋಗಿದ್ಯಾ?
Yes. 2 is also recipient of the amount.
How much money has gone to his account?
My lord, that is a Nikita, that is A2 has received around 12,65,000 rupees.
Your account ಈಗ?
Your account ಈಗ
One ನಿಮಿಷ. You have received that amount?
A3, my lord, the accused number 3, that's a daughter who was, my lord, at that point of time a student.
It's all right. Who has received the amount?
12 lakhs has come to the daughter's account. To the wife's account, my lord, accused
You
number.
You are the wife, is it?
Wife and daughter, my lord.
Wife and daughter.
Wife and daughter.
Right.
May I explain to you?
No explanation. Have you received the amount?
Amount is received to the account of accused number 3, that's a daughter.
All right,
My lord, she is, according to them, my lord, 12,65,000 is received to her account.
all right.
Insofar as, my
Accused
lord,
number 1 yaru?
accused
Husband?
number husband. My lord,
Oh,
he is
family,
family, he's,
all right.
my lord,
Yes,
he is
that's
gone
family.
absconding.
Yes, sir.
My lord, the issue, my
ಸ್ವಲ್ಪ ಸುಮ್ನೆ ಇದ್ಬಿಟ್ರೆ ನಾನು
Yes,
ಕೇಳ್ತೀನಿ.
please.
Yes.
lord, the issue, my lord, is that
ನೀವು ವಾಪಸ್ ಕೊಡ್ತೀರಾ ಇಲ್ಲ?
Lord, my sub,
Are you returning the amount or not?
Lord, my only sub,
Not, family cannot indulge in all this.
Lord, may I not make submission, Lord, I produced several documents, Lord, I have milk.
To show what?
Lord, the problem is, Lord, the father, my lord, has taken money, Lord, he's absconded, he's gone away, deserted me.
Hmm.
I have, my lord, filed proceedings against him, the matters are pending.
Hmm.
And what he, my lord, modus is,
Let the trial go on.
Lord, insofar as these people, Lord, women, Lord, concerned, Lord,
What, account ದುಡ್ಡು ಬಂದಿಲ್ವಾ?
only insofar as the daughter is concerned.
Give it back.
And she, my lord, she was a student, Lord. at
Give
point of
it
time.
back, sir.
She was
You have
about-
received amount.
about 18
Don't
years.
project this woman and daughter in a cheating case. You have received the amount. Daughter has received the
What
amount.
is account? It is
Return
account.
it.
Lord, what is mentioned in, my lord,
You
the-
forget about the husband. You
Lord.
return the amount.
Lord, what is they have taken, my lord, 33 odd lakhs, Lord. 12 lakhs is what has come to their account.
Sir, 12 lakhs daughter account ಬಂದಿದ್ಯಾ ಇಲ್ಲ?
Lord, I will make, my lord, may request, my lord, to the client.
Give it back.
And may post it, my lord, next week sometime, Lord.
I'll post
So
it next week.
that
You
portion
first
of-
you give that back, then I will consider.
Lord, that particular portion, my lord, I will, my lord, seek instructions. Kindly post next week,
Give
any
it
day,
back.
my lord.
Yes. ಒಂದ್
Because
ಸ್ವಲ್ಪ
my-
ಸ್ವಲ್ಪ ಬರ್ಲಿ. ಇರಿ.
Please, please,
ಏನಾಗಿದೆ ಅಂದ್ರೆ
please.
that's, my lord, I will not, that I will not pursue. What's happened, my lord, he's gone up, so he's promised many people and several people, my lord, have
I'm not
contacted me.
worried about the person who is gone absconding.
Please.
You or your daughter has received, student or whatever you're trying to project, has received 12.5 lakhs.
That is, my lord,
ಹೌದಾ?
ಅದೇನಾಗಿದೆ, he has, my lord, misused her account also. I have not given
Don't
stop payment
project
check
all
and-
this. Otherwise I will permit trial to go on.
I understand, my lord.
12.5 lakhs next week ಅಷ್ಟೊಂದು ಬಂದ್ರೆ okay.
And I will not persuade
Yes.
my client to not on that pass.
This
Next
is
week,
not.
any date may kindly be fixed. my lord.
20th, sir.
Please.
Or better, I'll post it on 24th. List on 24th in the fresh matters list. The learned counsel for the petitioner, learned counsel for the complainant would submit that the accused number 3, the daughter, has received 12,65,000. The accused number 3 is not the petitioner in the case at hand.
Lord, accused number, she also petitioned.
Idara,
Yeah.
okay, all right. 3 received so and so aಷ್ಟು ಸಾಕು. Received. The projection by the mother and the daughter is that the father has hoodwinked several people and is now absconding. But the fact remains that 12,65,000 is received to the account of the accused number 3. Therefore, the counsel to seek instructions with regard to when the amount of 12,65,000 which is alleged, which is in the account of this accused number 3 would be returned to the complainant. List on 24th in the fresh matters list.
Then, my lord, interim order may until then.
Interim order subject to the aforesaid condition shall continue to the next date of hearing. Yes.
Much obliged.
51.
End Latif.
Lord, I'll report the settlement in the next week.
20th, 2:30 PM to report settlement. Yes, next.
52.
Furnishing of PF to R2. Order could you? Not complied, why waiting?
My lordship, please permit to R to delete it.
No, why have you not paid process?
My lordship, decreased R2 ಇಲ್ಲ my lordship ಇದ್ರಲ್ಲಿ. They may
ಅದೇ
not
R
made the
ಆಗಿದೆ.
complaint as party.
Delete ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ my lordship, ಇವತ್ತು ಮಾಡ್ತೀನಿ my lordship.
I'll vacate the interim order now.
Please.
Yes.
Permission.
Needful, ಈಗ ಮಾಡಿ. Delete it right away. Yes. What do you? Interim order stands extended till the next date of hearing. Delete it now. Yes.
53.
In terms of
4.
For the petition, 53, my lords, 53, my lords.
50?
53, my lords.
You want to argue the matter?
No, my lords, I want to make a small submission, my lord.
I have withdrawn, sir.
Yes, my lord.
Dismissed, disposed as withdrawn.
Yes,
In
my
terms of
lords.
the memo.
My lords,
You want to make
withdrawn, my-
submission in that?
Nothing, my lords. I wanted to say that.
Reserve it for a better case.
Much,
Yes.
much obliged, my
Huh?
lords.
And I appeal for the petitioner's counsel in seal number 54,
Huh?
wherein we are seeking further investigation.
The matter is posted.
You are seeking 54.
Yes.
Further investigation.
Yes, the office note is not relevant because my lord did not order notice for the other respondent. Maybe
Their
office has
hands
posted
in the
that.
charge sheet. Yes, sir. Comment.
They want to convert into 302.
Huh? ಅದೇ 302 convert ಮಾಡ್ಬೇಕು ಅಂತ. It's not that easy to say convert into 302 unless I have
We
material.
are seeking 306. Sorry, we are not seeking 302.
What is the offense now?
The offense now is only the 324.
498 A, sir.
Oh, yes, ma'am. 498.
You are, who are you?
I am the deceased father. She has written a diary at page number 169, my feelings and my story, which is running into 66 pages. The investigation officer, in spite of offering this, did not take at all.
ಇದನ್ನೇ ಕೇಳಿದ್ ನಾನು last time. Who is the IO? Yes, sir. ಇದು ಕೊಡ್ಲಿಲ್ವಾ ನಿಮಗೆ?
Page number
I have made specific.
Page one,
Page number 48.
48 of what, sir?
Complainant further statement. What
Of
the,
charge sheet.
48 of the charge sheet, huh? ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಎಷ್ಟು? Page ಇಲ್ಲಿ ಹೇಳಿ.
48.
No, what is alleged is 498A and 304B.
Charge sheet is filed for that.
ಅದಕ್ಕೂ ಅದೇ punishment.
Ignoring 306. Abetment
ಅದಕ್ಕೂ
of
ಅದೇ
suicide.
punishment.
My lord, kindly appreciate abatement of suicide, wherein the material, the father went to the police station. In fact, he reported the matter to the higher ups also by writing a letter, which I have.
ಅದರಲ್ಲಿ ಏನಾದ್ರು ಹೇಳಿದಿರಾ ಇದ್ರ ಬಗ್ಗೆ?
Yes, ma'am.
ಡೈರಿ ಬಗ್ಗೆ ಹೇಳಿದಿರಾ?
Yes, ma'am.
ಎಲ್ಲಿದೆ?
Yes, ma'am.
Show me one document.
Yes. Put the representation copy. Representation copy. 335, page number 335. 335 in the review. How did it? Page number 335, yes, ma'am. I'm looking at diary. What do you?
Date ಏನಿದು?
This is.
What is the date of the incident, date of filing of the charge sheet?
Yes. The date of the incident, the charge sheet was filed on 28/4/2023.
28/4/23.
28/4/2023.
All right, this letter is the 3/10/23.
Yes, my lord, that is.
No, show me something, some communication that is prior to 28/4/23.
The prior to 28/4/2023, in fact, I visited the police station.
You visited ಅಲ್ಲ, ಏನಾರ ಒಂದು letter saying that this diary ಇರೋದಕ್ಕೆ ಎಲ್ಲಿದೆ? Proof. You may have produced it. You
Yes,
have
my
given it to the IO ಅಂತ ಎಲ್ಲಿದೆ?
My lord, he refused to take it. In fact,
do
if
you
he
say
files an
that?
affidavit, if he files an affidavit, I will be able to counter.
Who will file an
The
affidavit?
risk of perjury, if the IO were to file an affidavit that nothing was offered to me. In fact, he
He
did
is
not.
here, sir, saying before the
My
court.
lord, saying that it was not, my lord, it is a case for
Yes,
arising out
please
of an illicit relationship, an influential person.
ask him.
Even this report, my lord, even this letter, in this letter, they are not saying that they have made a representation in the earlier.
ಎಲ್ಲಿದೆ?
Page 335.
Communication ಕೊಡಿ sir.
335 at page number 335.
Yes.
I write to request for fair and proper investigation to the
All right.
Commissioner of Police.
All right.
And I go on narrating the events.
All right.
And then at para 11, at para 9 is relevant. The investigation officer has not summoned and recorded the statement of Raju, who is the husband of Srimati Kalavati, who knew about the illicit relationship which his wife Srimati Kalavati had with Guru Prasad, and took suitable measures to prevent Guru Prasad from indulging in immoral and illegal activity affecting the interest of both the families. His statement is just as necessary to show and establish the guilt of the accused number 1. In the aforesaid circumstances, it is very clear that the investigation officer has not been done in a fair, proper and unbiased manner.
Why did you not say that there are story written or diary that is
Para
there?
6. The said illicit relationship gets established by the diary maintained by Srimati Madhuri, which even though tendered
Yes,
to the.
sir.
My lord, the issue is, my lord, that there is no representation given in the past. It is only post.
Post ಗೊತ್ತಾಯ್ತು.
ಹೌದು.
ಮುಂಚೆ, where is your statement recorded?
As per the charge sheet.
In your statement, have you said you have a diary?
Yes, ma'am.
ಎಲ್ಲಿದೆ ಕೊಡಿ, ಆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡಿ, will pass some order.
My lord, that statement was recorded by the police as per their liking.
No,
Police-
don't tell me all
may
this.
I- Here is.
Diary ಇದೆ ಅಂತ ಎಲ್ಲಾದ್ರೂ ಹೇಳಿದೀರಾ?
My lord, that could be that question, because the statement of in a charge sheet, all
Do
statements.
you have
are
the
recorded.
specimen handwriting of the deceased?
No, they didn't do that investigation. in
We
that
can,
way.
even now we can send it, my lord.
That is why you have the specimen handwriting of the deceased.
Have to provide.
In fact, the deceased has given a complaint to have the specimen
Give,
handwriting.
give that, sir. Where is it?
Complaint.
Produce it, send it to FSL and get to know the.
May I just draw my lord's attention to
Let
the
them hand over the original, we will send it.
Original of what?
Diary, my lord, Annexure C.
I
FSL.
am ready to hand over the diary. I am.
Do it, sir.
Yes. They summon me or I can hand over in the what if they
Send
summon me. I
it,
am
send it to FSL.
We'll send it.
The
Handwriting expert.
petitioner, the petition is preferred on the score that there is a shoddy investigation by the investigating officer who has filed a charge sheet only for offense punishable under section 498A, 304B read with 34 and 4 of the Dowry Prohibition Act of the IPC and Dowry Prohibition Act. The learned senior counsel B.V. Shankar Narayan Rao would take this court through the documents appended to the petition with particular reference to a diary alleged to have been scribed by the deceased. The same is not a part of the charge sheet. The learned senior counsel would submit that the investigating officer has refused to take it as a material at the time of investigation, though none of the statements of the petitioner would refer to a diary, but a subsequent communication on 3/10/2023 would make reference to the
Can I
said
just
diary.
interrupt for a minute, my lord? My sincere apologies. Statement is at page number 89 of Chandra.
ಅದರಲ್ಲಿದ್ಯಾ?
Yes.
All right. Though ನಾನು ತೆಗಿತೇನೆ
Fact,
ನೋಡು.
it
Therefore,
refers-
the petitioner shall hand over.
It refers to a
1 minute.
statement which Madhuri gave in the hospital.
I don't know who is it. Wait. The petitioner shall hand over the diary to the hands of the investigating officer, who shall forthwith send forthwith after receipt of the diary, send the same to the FSL for to the handwriting expert along with the specimen signature or the writing of the deceased.
May I make one submission? I'm not resting my case not only on the diary, even mobile phones were not seized.
ಅದ್ ಮಾಡ ಫಸ್ಟ್ ಒಂದೊಂದಾಗ ಮಾಡ.
Yes,
Even let them hand over that also,
Because
we'll send it for it.
it will be a part of further
ಎಲ್ಲಿ
investigation.
ಮೊಬೈಲ್ ಫೋನ್ ಎಲ್ಲಿದೆ?
ಇಲ್ಲ ಅವ್ರಿಗೆ ಏನು ಮಾಡ್ಲಿಲ್ಲ ನಾವು ಕೊಡ
ಕೊಡಿ
ಅಲ್ಲ ನಾವು ಕೊಡ್ಲಿಕ್ಕೆ ಹೋದಾಗ ರಿಪೀಟೆಡ್ ಆಗಿ ಕೊಡ್ಲಿಕ್ಕೆ
ಕೊಡಿ ಸರ್ ಈಗ. Give it now. The learned counsel would further
further investigation.
wait, sir. The learned counsel would further submit that the mobile phones were also not taken by the investigating officer. Those also shall be handed over to the investigating officer, who shall submit the FSL who shall send it to the FSL, and the FSL shall report the same back to this court through the additional SPP within 4 weeks. No. Within 4 weeks. Otherwise, I will order further investigation by somebody else.
Further investigation would be a better.
Why?
For the reason that there is so much of incriminating material. Raju's statement is not recorded. If I go on, I will be giving a list. Kalavati with.
Adhik, I told you to prepare a list and give what.
May I-
See, if you want further investigation for the asking, it cannot
No,
be
it
done.
cannot be. I have made out
So,
a prima facie.
you should give me the list of lacunae
Yes,
that is in the investigation, which according to you is shoddy.
Yes, ma'am. I can
ಎಲ್ಲಿ
provide that.
ಕೊಡಿ.
I can provide that.
No, then ಏನು ಬೇಡ, let him give it.
My lord, open further investigation would be a better approach for the reason.
You
that
first produce that, sir.
My lord, I have produced the diary.
Give me the list of lacunae that you are seeking to project.
Yes, my lord.
Without that, I will not pass any order for further investigation.
Yes,
ಯಾವಾಗ?
Friday or Monday, whatever, Tuesday.
Give
whatever
it
my
on
lord
Tuesday.
said. Or if they agree for open further investigation, it would.
They need not agree, sir. If you give the material, if it is to be given, we will give it further investigation.
Because Raju, who is the.
Because ಬೇಡ, first ಅದು ಕೊಟ್ಬಿಡಿ. ಆಮೇಲೆ ಕೊಟ್ಮೇಲೆ we will see.
Tuesday.
Yes.
That office note may be overruled. because
Wednesday,
every
fresh
time-
matters list, yes.
65.
He need not be present.
Yeah.
Yes. Yes, Abraham, what is this? Respondent ಅಲ್ವಾ? ಈ ಕಡೆ ಬನ್ನಿ.
filing the objection to the petition. Lord, in spite of the order, Lord,
Oh.
he is not cooperating the investigation.
Ibrahim is the complainant.
Please, I am the complainant.
Please,
There is an-
Your Lordship may kindly grant a short date.
Lord, there is an order.
You applied before the committee?
Yes, Your Honor.
Committee has granted permission?
No, Your Lordship.
It's pending.
They called me day first day and told me my Form A is not,
All right,
not
then
raised.
we will hear you
I'm-
after the,
2 days. I'll do
no
that.
problem, yes.
On
Lord,
25th
there
or
is an order.
24th,
Wait.
there is an order to cooperate to the investigation, that the petitioner is not cooperating the investigation.
Yes, sir, why?
Your Lordship, I personally am not aware of the
You
non.
need not be aware personally. But this is the allegation.
Lordship, I'll seek instructions regarding that.
The learned counsel representing, the learned counsel B. Latif representing the Lokayukta has alleges that the petitioner is not cooperating with the investigation. The 13(1),
Please.
as a disproportionate, huh?
Your Lordship, a lot of offences have been alleged.
No, all right, disproportionate asset.
Please.
Then the BD official, huh?
BD office.
Oh, yes, sir.
Including the offence of PMLA, which falls under the PMLA Act, had also been alleged. The matter has been referred for investigation by the Lokayukta court, despite not having the jurisdiction as well. Also, section 17A approval is not there.
If it is amassing wealth disproportionate to the known source of income, 17A need not be followed.
In fact, 17.
TV Ashok, I have myself held that except in disproportionate asset cases, 17A is mandate.
Your Lordship, disproportionate asset is not the only offence alleged, Your Lordship.
If it is amassing wealth disproportionate, no 17A.
Your Lordship, then section 17 sanction. So section 17.
Sanction?
No. The second proviso to section 17 has also been, has not been complied with.
Application of mind while registering the crime.
Please, Your Lordship.
We'll see, we'll answer all that. Yes. Objections hakidira?
I'm filing the objection.
File. Ega ಬರ್ಕೊಳ್ಳಿ.
Him cooperate the
1 minute.
investigation.
The learned counsel appearing for the learned counsel B. Latif submits that the petitioner is not cooperating with the investigation. The learned counsel of the petitioner seeks to project certain statutory aberrations in the case at hand, all of which would be considered on the next date. The petitioner shall cooperate with the investigation during the pendency of the petition. Interim order ilvalla? ಮತ್ತೆ ಯಾಕೆ cooperation?
Not to file the charge sheet, that was an order.
ಇಲ್ಲ,
Not
that
the
order
last
also
date
not
also,
filed.
Lordship,
No,
has
that is
directed
the
them to cooperate the investigation.
Oh, correct, ಇಲ್ಲಿ ಬರ್ದಿದ್ದು ಮಾಡಿ.
In spite of that order.
So and so. In the event the petitioner would not cooperate with the investigation, the order dated 8/8/2024 would stand vacated. Cooperate with the investigation. That this order is passed, as I have passed orders in every case. I don't think this case deserves that order even. We'll see. Yes. The case officer.
Case officer, Your Lordship.
Yes. List on, by then your form C, you correct it.
Yes.
List on, what date, 24th in the fresh matters list, yes.
56.
Steps already taken.
Counsel with the petitioner submits needful has been done, office to verify.
Interim protection.
Interim order / protection, if any, shall continue till the next date of hearing. Will continue at 2:30, yes.
Submission, Submission. Serial number 119.
Adjournment ಬೇಕಾದ್ರೆ court of cert.
Parties has.
Settlement ಎಲ್ಲ ಮಧ್ಯಾಹ್ನ.
Yesterday's matter is law. It is settled.
Settle ಆಗಿದೆಯಾ?
ಈಗ
ತಗೊಳ್ಳಿ. Settlement ಎಲ್ಲ ತಗೊಳ್ಳಿ ಮೇಡಮ್.
4 ಗಂಟೆಗೆ.
ಸೆಟಲ್ಮೆಂಟ್ ಯಾವ್ದು ತಗೊಂತಾರೆ ತಗೊಳ್ಳಿ, ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಯಾವ್ದಾದ್ರು ಅವ್ನು ಕೊಟ್ಬಿಡಿ, ಕಂಪ್ಲೈನ್ಸ್ ಇದ್ರೆ ಮಾಡಿ.
ನಿನ್ನೆ ಇತ್ತು.
Serial number.
Why at 2:30? Pending matter. Kodi. What urgency?
Petitioners are ready to repay. The police register something called an LP was upon the petitioners. And we say that yes, we are repaying money. Give us some time. And he registers the FIR under 420 without even issuing any notice privately. And second petitioner's wife of the first petitioner is nowhere named in the company. And again, an FIR will be lodged against her for no reason.
We'll see. Give it. Friday. Friday, sir. Yes. ಮತ್ತೆ FR ಅದಕ್ಕೆ ಪೋಸ್ಟ್ ಆಗಿಲ್ಲ. ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ. 2 ಸರಿ ಮೆಮೋ ಹೋಗಿರುತ್ತೆ, ನೀವು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ಲ. ಈಗ ಹೋಗಿ go and complain. Tomorrow why? Why apprehension of arrest? ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ? ತಗೊಂಬಿಡಿ, ಪರವಾಗಿಲ್ಲ, ಬೇಲ್ ತಗೊಳ್ಳಿ. No sir, no madam. Take secure bail, we'll post it on Tuesday. Don't convert this to a bail court unless Atrocities Act is alleged. Yes. Good. Gottu. I'm not yet made up my mind. We'll take it tomorrow. L. Sunil Kumar. No problem. She's a colleague. That's all right. But tell Jyota sir, I may have to hear him again for 5 minutes. I have some clarification. In that. So, well, Kodak, I have not yet made up my mind, so I have not passed the order today. You can also tell senior. Yes. Yes, Jesham? Nale haktin madi. Nale la, day after tomorrow I'll post. Yes. Day after tomorrow, Ashok. ಅದರಲ್ಲೂ ನೀವೇ ಇರೋದಾ? ಯಾವ್ದು ಆ ಮ್ಯಾಟರ್? ಬೇಲ್ ಮ್ಯಾಟರ್ಲಿಯಾ? ಗೊತ್ತಾಗಲಿಲ್ಲ. ವಾಟ್ ಇಸ್ ಇಟ್? 140? ಅದನ್ನ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಹೇಳಿದ್ನಲ್ಲ.
ಒಂದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಒಂದು ಕೊಡ್ಬೋದು.
ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ನನಗೆ ಕೊಡ್ಬೇಕಾ?
ಅಲ್ಲ, ಇಲ್ಲಿ ಫೈಲಲ್ಲಿ ಇಡ್ಬೋದು. ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ರೂಲಿಂಗ್ ನಾನು ರಿಲೀಂಗ್ ಮಾಡಿದ್ದೆ, ಒಂದು ಸಾಧ್ವಿ.
ಡೋಂಟ್ ವರಿ, 2011.
ಹೌದು, ಅದರಲ್ಲಿ ನಾನು ವಿದೌಟ್ ಕೋರ್ಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಅದು ಸಪೋರ್ಟ್ ಆಗೋದಿಲ್ಲ ಅದಕ್ಕೆ. ಅದು ದಟ್ಸ್ ವೈ.
ಏನ್ ಪರವಾಗಿಲ್ಲ, ಡೋಂಟ್ ವರಿ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್ಗೆ ಯಾರು ಏನು ಸಪೋರ್ಟ್ ಮಾಡಬೇಕಾಗಿಲ್ಲ.
ದೇ ಹ್ಯಾವ್ ಟೇಕನ್ ಟು ಕನ್ಸಿಡರೇಷನ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್.
ವಿಲ್ ಸಿ, ಡೋಂಟ್ ವರಿ.
ಆಯ್ತು.
Why default bail is rejected? And why before this court? Original ಮಾಡಿದ್ದೀರಾ? Just challenge it in the bail jurisdiction. I have. That doesn't mean that I entertain every petition. Go before the bail court. You would have got bail by now. You go before the bail court and seek bail, sir. You need not challenge the order. You can seek enlargement of bail.
It is rejected.
See, ನಮ್ಮ ಮುಂದೆ ಇದ್ರೆ ಇದೇ ಪ್ರಾಬ್ಲಮ್ ಆಗಲ್ಲ. If you go to the bail court, it will happen immediately. No, tomorrow I doubt I will post it day after tomorrow. ಅದು in the fresh matters ಹಾಕಿ madam, day after tomorrow.
It is rejected on the ground that charge sheet has been. It is rejected on the ground that charge sheet has been filed.
There is a technical argument that has to be made.
Let's see. ಏನು offense ಏನು? ಏನಾಯ್ತು? Yes.
Body warrant produce ಮಾಡಿದ್ದಾರೆ. Charge sheet insofar as other accused. Again, there was no charge sheet.
That has been taken.
Oh, you are still being held under body warrant?
Yes.
All right. Yes, sir.
Therefore, no, he is in connection with custody in some other case.
No,
Let's see.
138.
ಆಯ್ತು. We'll take it on 13th in the fresh matters list. Yes.
48 people yesterday for the further hearing. Reserved for orders. I have given the
ಗೊತ್ತು, ಆಯ್ತು, ಸರಿ.
Further hearing, request to review. That's all.
ಹಂಗೆ ಇರ್ಲಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ರಿಸರ್ವ್ ಮಾಡ್ತೀನಿ. 20th ಹಾಕಿ ರಿಸರ್ವ್ ಮಾಡ್ತೀವಿ. ಅಲ್ಲಿವರೆಗೂ ಸ್ವಲ್ಪ ಪೈಲಪ್ ಆಗಿರೋದು ಕಮ್ಮಿ ಆಗಲಿ. ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬಿಡಿ. 2:30 ಯಾವ್ದಾರು ಇದೆಯಾ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ? ಯಾವುದು? 1 ನಿಮಿಷ. 2:30 orders. 2:30. ಯಾಕೆ 2:30 ಹಾಕ್ತಾ ಇದೆ? It's all right. But continue the list.
Let's continue. Number 57.
One ನಿಮಿಷ, just one moment. Just call this, sir, ಒಂದೇ ನಿಮಿಷ.
Please, please.
146 on ಕರೆ.
One 46.
The dictating, heard reserved. Yes. Now continue the case. Yes. 47. 57. Ah, yes, sir. 2 points. Mike use ಮಾಡಿ sir.
The allegation is that on May 28, 2020, the petitioner has sent 24 emails containing company confidential documents from his official email ID to his personal email ID that was discovered on the next day, that is on May 29th. On May 29th itself, I have voluntarily handed over my laptop, my mobile phone, and my Google Mail user ID credentials. Now, complaint is filed on September 24th, 2020. No preliminary inquiry is done. FIR is registered on the same day.
For what offense are you saying preliminary inquiry should be done?
420 is alleged cheating.
All right.
Okay. Next, on October 15th, I'm issued a termination letter. On October 22nd, a civil suit is filed wherein an order of injunction is granted restraining me from disclosing any company confidential material to any third parties.
All right.
Now, the fact that a civil suit has been filed after the complaint, the allegations should be the same in both the complaint and in the plaint. Now, my lords, I'll walk through the embellishments that have been made in the complaint to make out the necessary ingredients of offenses under the IT Act and of cheating. Kindly come to page number 158, my lords.
Objections are filed?
Yes, my lords.
Summons issue ಆಗಿಲ್ಲ. We are at the stage of not even source statement is recorded. He comes before this court.
One moment, sir.
My lord, let me put it in just two
Is
or
it
three
correct?
sentences. Just 2 or 3 sentences. I am the informant to the police.
Yes.
I am his former employer. That he would stealthily remove certain confidential and proprietary
All right.
information. He would apologize to us and give us a letter also. I'm sorry, this is what has happened.
All right.
But the policeman, upon completion of investigation, would submit a B report to the court saying that nothing is found in his laptop. It has been erased. They ought to have probed further into the matter and got it retrieved and all that.
That's pending before the court.
Now, my lord, the Narad trial magistrate would reject the B final report and would take cognizance of the offence and would post a matter for recording of sworn statement.
That is
We are
not
at
yet
that stage.
happened.
Not even sworn statement is recorded. It is premature.
My contention is that this is primarily a civil dispute. I'll walk through the specific embellishments that have been made in the complaint vis-a-vis the plaint, my lords.
Let the magistrate do something.
Even that there is flaw in the order of taking cognizance. If I may point out, kindly come to page 71, my lords. Please come to page 71, my lords.
All right, you.
May I read out, my lords?
Our objections ಹಾಕಿದಾರಾ?
ಹಾಕಿದ್ದಾರೆ. I've gone through the objections. I'm ready.
I have not gone through. Yes.
Sorry.
Let's see. This has come up in orders. We'll take it another days. Yes, list the matter on 19th in the fresh matters list.
He would question the order of taking cognizance and rejection of B report. How could he do it, my lord? He has not even been summoned before the court. But certainly an accused can question the order of taking cognizance in the event of there being a prohibition imposed upon the court for the purpose
Now,
of taking.
after taking of cognizance, sworn statement is recorded.
Not recorded.
No, 1 minute. Sworn statement is recorded. Would the court close the complaint?
No.
No, they will
It
issue.
has got to pass an order under
No,
204.
issue 204 order ಆಗ್ಬೇಕು.
It is
Prior to 204, it cannot be said that there is no right under 482. We'll see. Yes.
Great.
List on 19th in the fresh matters list.
Grateful.
58.
60?
58.
58 needful done anta. 58 learned counsel submits needful has been done. Office to verify. Next.
59.
Same order. Same order.
61.
For the petition, but the respondent is served. no?
Post immediately after service of notice upon the
No,
second.
she is
respondent.
present in this court. But I have produced the copy.
What copy?
Lord, this is a petition.
You're,
Lord,
you're appearing?
For the respondent number 3, 6 and 11, my lord.
1 minute. Sir.
Which one is it? 61.
498. Yeah.
Please, my lord, 493 and 4 of the.
Who are you?
Lord, I am the
Husband?
husband, please.
Yes, sir.
No, I just,
Settlement.
ಅದರಲ್ಲಿ
Settlement.
marriage dissolve ಆಗಿದೆ.
Huh.
I mean, dowry has been, I mean, permanent alimony is settled now.
Hmm.
Now they have said that I have no objection that, I'll come before the court and see that matter being passed.
Where is the settlement?
I just produced it along the copy and the certificate copy is now produced. And in, my lord, seal number 145,
One?
my lord has granted, in seal number 145, it's listed today. In this matter, interim order is granted by my lords. This petition is by father-in-law and
So are we disposing both the petitions
See,
now
one-
by
the
on
same,
account of a settlement?
it's on the same,
Excuse me, my lord. By mistake, I have appeared, another serial number, my lord. In the northwest case.
But who is appearing for the,
Lord,
she's the wife?
please, Lord, she is before the
Who's
court.
appearing for her? Not there? The matter is settled and closed?
Yes.
This certified copy of produced it, my lords.
Where?
That is the one now which I've handed out to my lords. Compromise petition as well as the order of the Honorable Family Court judge.
Madam. Madam, 498. ಇಲ್ಲಿ ಇದೆ, flag ಹಾಕಿದ್ದೀನಿ. Same ಅಷ್ಟೇ.
The same crime.
145 is by whom?
By, my lord, the father-in-law, mother-in-law and the,
Who is the petitioner there?
there the petition again, the respondent before now, my lords.
No, the same complainant.
Yes, my lord, same complainant.
Who appears for the petitioner?
Now, I
That
appeal for the
case.
petition both the
ಅದರಲ್ಲೂ
cases.
ನೀವೇನಾ?
Please,
All
Lord.
right, same, 145 also. Respondent counsel is not there, ಅಲ್ಲೊಂದು ಬರ್ದ್ಬಿಡಿ. Respondent complainant has appeared before the court and accepts that the matter has been settled in the family court and no objection to close these proceedings on account of the said settlement before the family court. That's it. Yes.
Connected matter line.
145 counsel ಇದರಾ?
I am appealing for the petitioner.
Respondent ಗೆ.
Respondent counsel ಇದ್ದಾರೆ, but, madam,
That's all right, you can do it. You tell your counsel.
always.
Yes.
Madam, sign this.
Come on. Sixty-two,
2.
a week's time to comply with the, post immediately after service of notice upon respondents 3 to 5.
Yes.
Next.
My lord, I am appearing from 62. yes.
ಇದ್ರಲ್ಲಿ ನೀವಾ?
Yes, sir.
ಯಾರಿಗೆ?
Respondent number 2, 6 and 11.
2, 6 and
11.
learned counsel so and so submits that he has entered appearance for respondent 2, 6 and 11. Registry to print the name of so and so as appearing for respondent 2, 6 and 11. List after 2 weeks. Enter ಮಾಡಿದ್ರೆ continue ಮಾಡಿ.
63.
Point number 2, my lords,
Hmm.
in both the matters. 63 point, in 63, my lords, it's the,
Post immediately after service of notice upon the second respondent. Entry ಮಾಡಿ ಉಂಟಾ?
I'm the respondent number 2, my lords, in both the matters. I
A
filed
registry to print the name of case Ponnappa is appearing for the respondent in 63.
And 63.1, my lords.
ಅದು already ಇದೀರಾ? So and so.
I'm ready, my lords.
Ready? What's the matter?
Lords, the first division assistant and the sub-registrar have approached this court saying that they've only registered a document, they have no part in it. The allegations, my lord, are at,
All right. Wednesday in the fresh matters list, 18th. Interim order subsisting shall continue till the next date of hearing. Yes, next.
64.
Yes, madam. ಬರೀ T2
Office objection ಏನು sir?
ಅದು ಕಂಪ್ಲೈ ಆಗಿದೆ.
Comply ಆಗಿದೆಯಾ? ಹ? A week's time is granted to comply with the office objections, comma, finally. Interim order, failing which the interim order subsisting would stand vacated. Subject to the aforesaid condition, the interim order subsisting shall continue till the next date of hearing.
Kindly extend the interim.
ಅದೇ ಮಾಡಿದ್ದು. Kindly comply with the office objection.
Foxco case, my lordship, on 20th it may be.
ಇದು ಸೆಟಲ್ಮೆಂಟಾ?
Yes.
ಏನಂದ್ರೆ?
Foxco case, my lordship.
ಏನಂದ್ರೆ?
Foxco.
ಹಾ, yes.
ಮ್ಯಾರಿ ಮದ್ವೆ ಆಗಿದೆ.
ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ. List on 20th.
65.
Post immediately after service of notice upon the second respondent. Interim order ಉಂಟಾ? ಇದೆಯಾ?
My lord, my lawyer advocate is not here actually because we need to hire a lawyer. So.
No, the advocate's name, who is your advocate, madam?
Need to hire one.
All right, I'll give you 2 weeks' time.
My request, so we need government lawyer.
Then you'll have to approach the legal service authority, madam. I'll take it after 2 weeks, you approach the legal service authority in the meantime, yes. 1 minute, sir. The respondent has appeared in person and would submit that she would approach the legal service authority for assistance of a counsel. List this matter on 24th. By then you do it. List the matter on 24th. Interim order subsisting shall continue till the next date of hearing. Next.
66.
Two weeks to comply with the office objections. Post immediately after service of notice upon the first respondent. Interim order.
For petitioners, yes, my lord.
A week, hello, madam.
Pencil.
Yeah.
4 and 6 of Foxco Act, my lord. Petitioner with him.
Settlement,
Yes, my lord.
20th, list on 20th. Yes, next.
69.
Office objections in.
Not furnished the order sheet of the 30th of 19/20/24 till 31.
Office objections overruled. Post the matter in the fresh matters list on Tuesday. Yes.
Serial number 67, my lord. Serial number 67.
So
ಅಲ್ಲ, ಅವ್ರು 68 ಗೆ appear ಆಗಿದೆ.
ನೀವು 67 68 sir?
ಈ serial number 67, my serial number is 68.
67. Post immediately after service of notice upon the second respondent. ಅದೇ order. Yes. ನೀವು ಹೇಳಿ sir, 68 ಏನು?
So, my lord.
ಅದು 20th, list on 20th. 69. Shrikant. Yes, office objections ಏನು?
Let's have complied with all the objections except for filing of the certified copy of the charge sheet of the
ಮಾಡ್ಬೋದು.
FIR and the complaint.
List on Tuesday in the fresh matters list in the event office objections would stand complied.
If I can submit. The difficulty is this, the petitioner, who is the president of a housing society, crime against him has been fastened against as against 406 and 420 minutes.
I'm not hearing it on merit, sir.
Minutes, they have notified my employer also minutes. They have notified
List
the
on,
postal department.
list on Tuesday in the fresh matters list in the event. Last time ಅದೇ order ಮಾಡಿದ್ದೀನಿ, I'll dismiss it. In the event the office objections would stand complied. Yes, next.
71.
It is not generated.
Huh?
It is not generated.
Overruled Tuesday, fresh matters.
Thank you.
72.
2 weeks time is granted to the needful. Respondent.
For petition.
ಆಯ್ತು, yes. Interim order ಇದೆಯಾ?
Interim order ಇದೆ.
Continue, yes, next. ಶಾಂತಿ ಭೂಷಣ್.
23.
Post immediately after service of notice upon the respondent, interim order subsisting shall continue to the next date of hearing. Next.
4. Grateful.
Current counsel submits needful has been done, office to verify. List after 2 weeks, IO. Next.
25.
Post immediately after service of notice upon the respondent, interim order subsisting shall continue to the next date of hearing.
76.
56 first time matters coming up. No, I mean,
First time either.
First time ಬರ್ತಾ ಇರೋದು, but in all fairness, this matter was, petition was filed earlier at the stage of FIR. Your lordships.
Then give it. Yes.
and passed an order, my lord, saying that this is a, even though it's civil in nature, it's a case for trial and therefore dismiss the petition. Now, my lord, we're on a very limited aspect. Charge sheet has now been filed. Now, why we're approaching your lordships once again is the charge sheet, my lords, is at page 525. It relies upon an FSL report. The offenses, my lords, are largely 420 and 464. 464 is regarding forgery and so on. My lords, may kindly see the FSL report.
This is that Prasanna Kumar had appeared for the respondent, Ada.
I think
Where is my order?
Your lordship's order is at the operative portion, my lords, will find at page 367. 367, 368. A brief background of facts, my lords. Now, the petitioners before lordships today are the purchaser of a property. The owner says that I was never there when the sale deed was registered. It was purchased on the basis of a power of attorney. He says, I was not there. Those are not my signatures. That is the crux of the complaint, my lords. Now, charge sheet has been filed. Now, my lords, may kindly see the FSL report. Now, since one of the main allegations is that the page starts at page 557, the relevant, I'm sorry, that's right, 557. The relevant portion at 560. (561), if my lords were to kindly see. Now, he has compared the signatures upon analysis at point number 2, my lords. The question signature, my lords, has at 561. The
All right.
question signatures K1 to K10. K1 to K10 are the complainant signatures.
All right.
And the specimen signatures marked so and so. That is the first petitioners.
All right.
Are not comparable one another since they are different patterns of execution. The same thing is for 3 to 9.
All
Of course,
right.
one of them is not a petitioner, but the remaining are petitioners before my lords.
All right.
Now, on the basis of this, my lords, charge sheet is fine. Now, since the one of the main allegations that the complainant says I was never there, my signature was forged. Now, the FSL report says the signatures put by the petitioners before my lords today, and the signatures on the the specimen signatures of the complainant, they are totally different. So the question of forgery, my lords, now, so when the charge sheet is filed, this should have been.
Anyway, that this is a matter of trial again. Not that I can accept this and close it. It may be an added circumstance.
Correct.
Yes,
I understand.
Jagdish.
I'm only on this limited aspect. Of course, there's one aspect possibly, I can't agitate this now, but at the time, the first.
Anyway, yes, Shota sir is here only. We'll ask him to take notice. I mean, like the advocate on that side. Anyway, appear I last time. On the earlier occasion.
You were in.
Now you cannot take notice. Yaridru barbunde, yes. Who was the counsel on record? Serve on him, we'll see.
Yes, sir.
Yes. Counsel for the petitioner to serve set of papers upon the
Akash Rao. Anish.
counsel who represented the respondent complainant in the earlier proceedings. We'll take it on Thursday next, list on Thursday next. Fresh matters list. Yes.
77.
Beyond dispensation.
For the petitioner, my lord. Pass over, my lord.
Pass over.
Seniors engaged in the other court, my lord.
13-1, 13-2, list on 20th. Yes.
78.
Tahir, ಬಂದಿದ್ಯಾ?
I was expecting disposal, lordship.
Yes, sir.
Seniors, my lords, for the special bench.
ನೀವು ಹೇಳಿ. I have heard you.
Lord, seniors before the special bench. 4 o'clock he'll come.
At 4 o'clock. Yes. Next.
Okay, IA order, IA may be disposed of.
Delay.
Yeah, delay.
ಬಿಡ್ಲಿ ಅವ್ರೆ. Let him come. ಐಎಗೆ ಕೊಲಿಗೂ ಮೇನ್ಗೆ ಸೀನಿಯರ್ ಯಾಕೆ? ಎರಡು ಒಟ್ಟಿಗೆ ಬರ್ತದೆ. ನೆಕ್ಸ್ಟ್. ಐಎ ನಾಟ್ ಪ್ರೆಸ್ಡ್. ಸ್ಟೇ ಬೇಡವಾ?
No, I'm ready, my lord, but what they said was they wanted to settle
our client said,
settle.
ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು, but I don't know if they also say some, in fact, they have mail, there is a mail issued from them. It's okay. Where they said that some terms are given, but I am ready to argue also, if my learned friend says so. But
Yes,
if
sir.
it is to be always resolved, it is good. That is why.
A short date, my lord.
Settlement.
ಗೊತ್ತಿಲ್ಲ
ಗೊತ್ತಿಲ್ಲಲ್ಲ. I am sorry, no, not ಗೊತ್ತಿಲ್ಲಲ್ಲ. You have not been instructed. Your clients are regularly in touch.
ಅಲ್ಲ when I say ಗೊತ್ತಿಲ್ಲ ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ
ತಮಗೆ ಗೊತ್ತಿಲ್ಲ ಅಷ್ಟೇ. Because no, it should not be that, Lord, that with this criminal petition they are trying to settle. I am ready to argue, not purely a civil dispute, but I honestly feel that when the clients they have shown interest to settle it, we should encourage them only for that purpose.
We will encourage.
Yes.
short date, my lord. Date will be given.
By granting a short date.
Tuesday, Lordship, my habit.
Tuesday ಆಗಲ್ಲ. Wednesday or Thursday.
Wednesday.
We'll take it on Wednesday.
Please.
Yes. Less the man heard the learned senior counsel Prabhulang Nawadgi appearing for the petitioner and the learned senior counsel Sandesh Chowta representing the complainant. The learned senior counsel would submit that the petitioners, the complainant and the petitioners are in talks of settlement. List on, therefore list on Wednesday in the fresh matters.
They don't come to around any agreement, no, we'll argue them.
Yes, that is obvious.
No, I'm just.
Don't take too long. Complaint ಓದಿದ್ರೆ ಆಯ್ತು, my lord. Both will be on the same footing. Please.
ಏನು same footing ಅಂದ್ರೆ?
Say, other than the complaint, nothing else to be read, my lords, whether it makes out a case of breach of trust or not. That's it, my lords. That's the bottom line.
Please.
Whether it is breach of trust or speech of trust. We'll see.
I'm not, I'll be in a
No, just
position.
a
to-
lighter
No, but
way
you know,
that-
it's, ನಾನು ಇಷ್ಟೇ ಹೇಳ್ತಾನೆ. If settle.
serious ಆಗಿದೆ.
ಇಲ್ಲ, ಇಲ್ಲ. Settlement ಆದ್ರೆ ಯಾವತ್ತು ಒಳ್ಳೇದಂತ ನಾನು. That's my.
Correct. But ಅದು ಹೇಳಿದ್ದಕ್ಕೆ ನೀವು ಸೀರಿಯಸ್ ಆಗಿ.
ಇಲ್ಲ, I'm not serious on it. I'm not
It
serious.
was in the lighter ways.
Yes.
ಇಲ್ಲರ ಲಂಚ್ ಡೈಜೆಸ್ಟ್ ಆಗಲ್ಲ.
I'm not serious. Sorry.
ಹೌದು. Yes, sir.
Admission number 80.
Petition. 38 proceedings.
ಒಂದು ನಿಮಿಷ, one second. Third list on matter ಇತ್ತಲ್ಲ ಮೇಡಮ್.
Number 3.
ಎಲ್ಲಿ? Nobody is there? ಬಸವರಾಜ್ sir. List number 3 ನಿಮ್ದು.
Dictation.
ಹಾ, ಎಲ್ಲಿ ಇವರು? Petitioners ಯಾರಲ್ಲಿ? I have heard it. Dictate time ಆಗಲ್ಲ, I'll reserve it.
Yes.
ಉದಯಹೊಳ್ಳ ಸರ್ಗೆ ಹೇಳಿ. If there is anything,
I shall inform.
I am inform ಮಾಡ್ಬಿಡಿ ಅಷ್ಟೇ. Yes, reserved ಅಂತ ಹೇಳ್ಬಿಡಿ. Yes. ಹಾ, ಈಗ ಕರೆ.
Admission 80.
I have the petition. 138 proceedings. Lord, the check pertains to a company. Lord, the company is not made a party.
Where is the checks?
Lord, the check is at page number 19.
Huh?
19.
19. For Manikya Spirits and Breweries.
Yes, ma'am. Private limited.
It's a company or?
It's a company, my lord. I produced that document also.
Page?
It's at page number 49. Certificate of incorporation.
49.
Yes, ma'am.
All right.
Page 12 will have friend.
Of what? Petition.
Petition. What my learned friend says, my lord, the company is shown there. The caste title itself.
Huh?
Caste title itself is shown.
You want your case to be dependent on the cost title?
Company party ಮಾಡಿಲ್ಲ ಅಂದ್ರು.
ಹಾ.
ಅದಕ್ಕೆ ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ ಅಂತ.
ಮಾಡಿದ್ದೀರಾ?
ಅದೇ ಪೇಜ್ ನಂಬರ್ 12 ಅಲ್ಲಿ ಇದೆ ಸರ್.
ಸುನಿಲ್
ಬಾಟಮ್.
ಎಲ್ಲಿದೆ ಕಂಪನಿ?
ಅದೇ ಸರ್ ಕೆಳಗಡೆ ಬಾಟಮ್ ಅಲ್ಲಿ.
ಬಾಟಮ್ ಅಲ್ಲಿ ಸುನಿಲ್ ಕುಮಾರ್ ಅಂತಿದೆ.
ಸುನಿಲ್ ಕುಮಾರ್. ಕೆಳಗಡೆ ಮಾಣಿಕ್ಯ ಸ್ಪೈಟ್ಸ್ ಅಂಡ್ ಬ್ರಿವರೀಸ್ ಪ್ರೈವೇಟ್
ದಟ್ ಇಸ್ ಸುನಿಲ್ ಕುಮಾರ್.
ಅದೇ ಸರ್ ಅದನ್ನ ತೋರಿಸಿ ಕಂಪನಿನೂ ಅಲ್ಲಿ ಹೇಳಿದ್ದೇವೆ ನಾವು. ಕಂಪನಿ ಇದೆ ಅಂತ.
No, you should make the company as independent accused.
ಇದೆ ಇದೆ.
ಇಲ್ಲ ಇಲ್ಲಿ.
ತಪ್ಪು ಅಲ್ಲ, so the situation is so complex is coming up. Now, it is not that totally it is not given up. The company is shown as one of the parties there.
Where?
ಅಲ್ಲ, ಒಂದು ನಿಮಿಷ. ಈ ಕಾಸ್ಟ್ ಗೆ ಅವರು ಹಾಕಿದಾಗ ಇದನ್ನು ತೋರಿಸೇ ಇಲ್ಲ.
ಕಾಸ್ಟ್ ರೇಟ್ಲು
ಪಿಟಿಷನ್ ಅಲ್ಲಿ. ಅವರ ಪಾರ್ಟಿ ಹೆಸರನ್ನ ಪಿಟಿಷನ್ 1 ಅಂತ ಹೇಳಿ ತೋರಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅಕ್ಯೂಸ್ಡ್.
ಹೌದು ಸ್ವಾಮಿ,
ಸೋಲ್ ಅಕ್ಯೂಸ್ಡ್ ಅಲ್ಲಿ 1 ಅಂತ ಯಾಕೆ ತೋರಿಸ್ಬೇಕು ಅವರು?
ನಮ್ಮ ಹೆಸರು ಇದೆಲ್ಲ ಇದ್ದಾರೆ ಅಂತ ಹೇಳೋದನ್ನ ಕಾಸ್ಟ್ ರೇಟ್ ಇಲ್ಲ ಅಂತ.
Sir, M. Gopal is the complainant.
I understand.
ಹೌದಾ?
Yes.
Sunil Kumar is the accused.
Correct.
You describe him as director of some so and so. The company is not a party.
ನಮ್ಗೆ ಸುನಿಲ್ ಕುಮಾರ್ ಡೈರೆಕ್ಟರ್ ಅಂತ ಹೇಳಿ ಕಂಪನಿನ ತೋರಿಸಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಿದ್ದೇನೆ. ಅಲ್ಲ, ಐ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಇಟ್ಸ್ ನಾಟ್ ದಟ್ ಟೋಟಲಿ ಗಿವನ್ ಅಪ್ ಅಂತ ಹೇಳಿದ್ರೆ ತಮಗೆ.
Is what is considered in Godfather.
ತಮ್ಮದೇ ಆರ್ಡರ್ಗಳಿವೆ.
ಎಷ್ಟೋ ಇದೆ.
ನೋಡಿದ್ದೇನೆ.
So
ಹೊಸದಾಗಿ ಒಂದು ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಏನೋ ಬದಲಾವಣೆ ಆಗಿದೆ ಕೆಲವು.
ಏನ್ ಬದಲಾವಣೆ ಆಗಿದೆ?
ಅದನ್ನ ಮೊನ್ನೆ ಹೇಳಿದೆ ನಮ್ಮ ಹುಡುಗ.
ಕಂಪನಿ ಬೇಕಾಗಿಲ್ಲ ಅಂತ.
ಬೇಕಾಗಿಲ್ಲ. ಎನಿ ಪಾಯಿಂಟ್ ಆಫ್ ಟೈಮ್ ಯು ಕ್ಯಾನ್ ರೇಸ್ ಇಟ್ ಅಂತ ಹೇಳಿ ಅಗೇನ್ ಮಾಡಬಹುದು ಅಂತ ಹೇಳಿ ಒಂದು ತೋರಿಸ್ತಾರೆ.
File an application under 319.
ಅದನ್ನೇ ನನಗೆ ಅವಕಾಶ ಕೊಡ್ಲಿ.
ಅದು ಅವಕಾಶ ಇದ್ದೇ ಇದೆ if you want.
ಅದೇ ಅವಕಾಶ ಕೊಟ್ಟರೆ ನಾನು I finish this because not that I have kept it silent or ignored.
It is tacit silence. Spirits and breweries.
138.
ಎಷ್ಟು ಕೊಡ್ಬೇಕು?
ಅವ್ರ ಪ್ರಕಾರ ಪ್ರಾಪರ್ಟಿ ಮಾರೋದಕ್ಕೆ ಅಂತ 70 ಲಕ್ಷ ತಗೊಂಡಿದ್ರು.
ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ ವಾಪಸ್?
My lord, the property does not belong to me. I was only an agreement holder from the landlord.
Why did you issue the check?
My lord, that's what in the police station they register a FIR. In the police station they take the complaint, checks.
Which FIR?
My lord, at crime number.
ಚಾರ್ಜ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ಇಂಪರ್ಸನೇಟ್ ಮಾಡಿದ್ದಾರೆ.
And Sarjapur crime number 28 of 2021.
ಅದು ಕಂಟಿನ್ಯೂ ಮಾಡಿ ಕ್ರೈಮ್
ಮಾಡ್ಬೋದು. ಇದ್ರಲ್ಲಿ ನಾನು ಅದು 139 ಕೆಳಗಡೆ I will have ಅವಕಾಶ ಮಾಡಿ ಕೊಟ್ಟರೆ
139 ಇಲ್ಲ 390.
ಸಾರಿ, the later judgment says so.
Yes. Where?
ತಾವು ಹೇಳಿದ್ರಲ್ಲ.
ಅಲ್ಲಿ ಎಲ್ಲಿದೆ?
ಮೇಡಮ್
ಅದಾ? ಹರ್ದೀಪ್ ಸಿಂಗ್ ಕೊಡ್ಬೇಡಿ
ಸ್ವಾಮಿ.
ಡೋಂಟ್ ಗಿವ್ ಮಿ ಹರ್ದೀಪ್ ಸಿಂಗ್ ನಾವು.
ಇಲ್ಲ, ಇದು MPP ಟೆಕ್ನಾಲಜೀಸ್
ಕೊಡಿ.
ಅದರಲ್ಲಿ several cases have been taken into account, not one.
Give it,
ಮೇಡಮ್. ಕಾಪಿ ಇದೆಯಾ? ಕಾಪಿ ಮಾಡಿ. Some new developments are coming up. ಅದಕ್ಕಾಗಿ ನಾನು ಇನ್ನೊಂದು ದಿವಸ ಅದನ್ನ ನಾವು ಅಪ್ರೈಸ್ ದಿಸ್ ಇಶ್ಯೂ.
ನನ್ನ ಆರ್ಡರ್ ನನಗೆ ಕೊಡ್ತಾರೆ.
ಅದೇ ನಾನು
That is 319. Yes.
Sorry.
Their proprietorship concern
House.
was not made an accused.
Correct.
But proceedings were pending there. At that time, an application was filed.
ಕೆಲವು ಬದಲಾವಣೆ
Permissible.
But in the company, my lord, the no notice has issued to the company.
That has to be now made. Look into the judgment and compass. Let me see. There is one more judgment where that is not a curable defect.
Yes.
319 bere. Other than 319, you can't, it's not a curable one. We'll list it on Tuesday. On Tuesday in the fresh matters list ಹಾಕಿರಿ. List on Tuesday. ಅದು ನಾನೇ ಕೊಡ್ತೀನಿ. Yes, both. Enter ಮಾಡಿದ್ಯಾ? Enter order subsisting shall continue till the next date of hearing. Next. Whereas
81.
There are petitioners in this case.
enter ಮಾಡಿದ್ಯಾ? Enter ಮಾಡಿದ್ಯಾ? Charge sheet is filed. How?
The subsequent tag, because after filing of the charge sheet, all the proceedings have been stayed by this.
No, that's all. Charge sheet is challenge ಮಾಡಿರೋದಾ?
ಮಾಡಿದ್ದೀನಿ.
Madam, what is this? Correct. List after,
Subsequently, is furnished that along with this memo.
all right, list after 4 weeks, interim order subsisting shall continue till the
Only
next
one
date of hearing.
submission. One submission. The agreement of sale was entered on 2013. The
Ah.
complaint was registered in 2022. In respect of that agreement of sale, already a suit has been filed, 2401/2 of 2016.
Let the
Annexure A, page
respondent,
65.
respondent comes. Yes. Stay ಕೊಟ್ಟಿದೆ.
Next week.
Continue ಆದ್ರೆ ತಗೋಣ. Yes.
As per in 2013 agreement, 2022 ನಲ್ಲಿ ಕೇಸ್ ಹಾಕಿ.
ಅದಕ್ಕೆ stay ಕೊಟ್ರು.
82.
Rejection of B report, my lords, and taking of cognizance. Now, the incident has taken place in January 2021, my lords. A drug inspector and his team would come to the place of business of the petitioner. Allegation is unparliamentary words were used against them. They get the FIR registered, investigated, B report filed, placed before DYSP, approval taken. When it is placed before the court, my lords, the order passed by the court, my lords, there's no, my lords, the B report is not rejected, straight away cognizance taken. The impugned order, my lords, we have produced it along with a memo, my lords. So Ravi Kumar's case is directly applicable to this, my lords. My lords, has a memo dated 30/11/2022, my lords. The order
30/11.
impugned is at page 18.
Who is the complainant?
My lords, complainant is the drug inspector.
URL.
ಹೌದು. ಈಗ ಈ ಆರ್ಡರ್ ಅಲ್ಲಿ, my lords,
Individual capacity. They filed it in individual capacity.
ಎಲ್ಲಿ ಯಾರು ಹಾಕಿದ್ದಾರೆ?
ಅವ್ರ ಇನ್ಸ್ಪೆಕ್ಷನ್
SPP for R2, HCGP for R1.
ಈಗ ಆರ್ಡರ್ ಒಂದು
Drug
ನೋಡಿದ್ರೆ,
inspection.
my lords, ಆರ್ಡರ್ ಒಂದು ನೋಡಿದ್ರೆ ರವಿ ಕುಮಾರ್ಸ್ ಕೇಸ್, my lords. Order, my lords,
Page, sir.
page 18 ಅಲ್ಲಿ, along with the memo which we have produced. The reasons, my lords, would get at page 21.
ನಿಮಿಷ.
Sorry. This is a memo dated 30/11/2022, my lords. ಅದರಲ್ಲಿ, my lords, page 21 ತಾವು ನೋಡಿದ್ರಿ. Reasons ಅಂತ ಹಾಕಿದ್ದಾರೆ. B report is not rejected. And cognizance taken.
The petitioners,
Petitioners
are before this court calling in question proceedings in CC 1041 of 2022. Calling in question an order dated 1/7/2022 passed in CC 1041 of 2022 by which the learned magistrate would take cognizance of the offense on rejection of the B report. They heard the learned senior counsel Sandesh Chowta appearing for the petitioner and the learned additional SPP. The second respondent, Inspector for Drugs, Bangalore, is the complainant. A complaint comes to be registered on an allegation that springs on 4/1/2021. The allegation is that when the Inspector of Drugs, the second respondent, would inspect other.
ಹೌದು, he comes to the premises, Ayur Park Healthcare
Inspect
Center.
the premises of the petitioners. The petitioners have spoken, have picked up a quarrel and used abusive language against the complainant. Based upon this incident, based upon the complaint, a crime in crime number 3 of 2021 comes to be registered for offense punishable under section 353/504, read with 34 of the IPC. The police conduct investigation and file a B report before the concerned court on 12/8/2021. 2021. The protest petition ಹಾಕಿದ್ರ?
ಹೌದು, protest
The
petition on
second
16th.
respondent complainant is said to have filed a protest petition on the B report so filed by the police on 16/10/2021. The concerned court takes cognizance of the offense, appearing to be rejecting the B report, and issues summons to these petitioners. It is this that has driven the petitioners to this court in the subject petition. The learned senior counsel would submit that would take this court to the order passed on the Bay report to contend that it is in blatant violation of the law declared by this court in the case of Ravi Kumar versus KMC so and so, reported in ILR 2018 Karnataka 1725. The learned senior counsel would further contend that there is that even on the merit of the matter that there is no case made out for an offense punishable under section 353, and the police had rightly filed a B report B report on the investigation so made. Per contra.
Page 27, my lord. The report. Last pair.
27.
Last pair. ದಿನಾಂಕ 15/5/21.
ದಿನಾಂಕ
15/5/21.
Which petition page 27?
Yes. The report, man.
ಏನ್ ಕಂಡು ಬಂದಿಲ್ಲ. Yes, so and so. Per contra, the learned additional SPP would defend the action of the police filing a B report. He would take this court to the contents of the B report that is placed before the concerned court, but would submit that in the event cognizance is now taken, that will go on in the court then, would defend the action of the police in filing the B report and leave the order to the hands of the court. The second respondent again, madam, separate.
I think there is a
Protest petition separate agi hakirodrinda.
I will have to say, my lord, that this statement.
But my lord, I think state is representing the drug inspector.
No, he has filed the protest petition separately in his independent capacity.
No,
But probably as a drug, my lords, what happens is he inspects as a drug inspector,
No,
not
true.
in his individual capacity at all.
QI is issued to represent.
To represent Agidiya. Sorry. The learned additional SPP would, however, contend that the respondents have hurled used abusive language upon the second respondent inspector of drugs at the time of inspection of the property, and therefore would contend that it's a matter of trial for the petitioners to come out clean, as the offense is stopping a public servant from performing his public functions. I have given my source. The aforenarrated facts are not in dispute. The incident that leads to registration of the crime is as narrated herein above. The crime is investigated into, and the police, after investigation, file a B report. On the B report, the protest petition is preferred by the second respondent. And on the protest petition, the concerned court passes the following order, page 21 and 22 of the flag agreement. Pass the following order. The order, a perusal at the order would fly foul of the order passed by the coordinate bench in case Ravi Kumar so and so reported to and so on. Paragraph 5 extract madi. The coordinate bench has clearly held postulates of consideration of a case where a B report is filed before a concerned court, and the concerned court would take cognizance of the offense on rejecting the B report. The 5 postulates that are laid down are all given a go by the learned magistrate in the case at hand. Therefore, the order that rejects the B report and takes cognizance of the offense is rendered unsustainable. On the merit of the matter, the submission of the learned additional SPP in support of the allegation of the complainant is again unsustainable, for the reason that while filing the B report, the observation of the police is as follows. Page 27, marked portion. The recording that was made by one Shiv Kumara.
Shiv Kumar.
The recording that was made by one Shiv Kumar was examined at the time of investigation, which clearly indicated there is no abusive language used nor abuses hurled against the second respondent complainant. Therefore, the submission of the additional SPP that the petitioner should come out clean in a full-blown trial is unacceptable, as the offense laid against the petitioners is the one punishable under section 353 of the IPC. The section 353 would require use of criminal force by the accused upon the public servant, which would stop or deter him from performing public functions. This is not the allegation, that is not the evidence. Therefore, remitting the matter back to the hands of the concerned court to pass appropriate orders on the B report would be of no avail in the light of the ingredients not meeting the charge. Therefore, I deem it appropriate to obliterate the crime itself against these petitioners. For the aforesaid reasons, the following order allowed first.
Please, my lords, Ravi Kumar, it's 7 postulates, my lords, 5
Five
ಇದೆ,
ಅಲ್ವಾ?
7
Seven.
ಇದೆ.
All right.
Obliged.
1725 then.
ಹೌದು, correct.
Para 5.
Para 5, in that 7 aspects have been laid.
Yes. Next.
83.
For petitioners in this case.
Vacating stay ಯಾರು ಹಾಕಿದ್ದಾರೆ?
Respondent number 2.
State
State, my lord. There is
ನೀವು
no
ಹಾಕಿದ್ದೀರಿ.
representation from respondent number 1 from
Sir,
past 6 years.
one is state, sir.
ನಮ್ಮವರು ಹಾಕಿ
ನೀವು ಹಾಕಿದ್ದೀರಾ? ಸ್ಟೇಟ್ ಹಾಕಿರೋದು.
State.
Yes. Yes, sir. ಏನ್ offense?
My lord, 465, 468, 471, 420.
Civil suit pending?
Please, my lord. My lord,
Civil suit by the complainant
my lord, there are multiple suits filed by both complainant
against
and
the
accused.
MOU.
Yes, my lord.
All right. Yes. Yes, government
ಕಂಪ್ಲೇಂಟ್ my lord.
heard the learned counsel appearing for the petitioner and the learned additional SPP. There is no representation on behalf of the second respondent. Awaiting his appearance, list the matter on 26th. List the matter on 1st October. Interim order subsisting shall continue till the next date.
Please, my lord.
Yes.
84.
Not well. Shankar Narayan. Listen, oh, correct. Yes. Court notice, issue court notice in the light of the fact that the counsel representing the petitioner is no more. Notice hogli, party. Interim order subsisting shall continue to the next date of hearing.
85.
ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ಸೆಟ್ಲ್ ಆಗಿದೆ ಮ್ಯಾಟರ್.
ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ?
ಸೆಟ್ಲ್ ಆಗಿದೆ,
ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದೆಯಾ?
ಸರ್ವ್ ಆಗಿದೆ.
ಸೆಟ್ಲ್ ಆಗಿರೋದು ಎಲ್ಲಿದೆ?
ಪೇಜ್ ನಂಬರ್ 27.
ಯಾವತ್ತು ಸರ್ವ್ ಆಗಿದೆ ನೋಡಿ ಮೇಡಮ್.
28
ಒಂದು ಚಾನ್ಸ್ ಕೊಡು. ಲಿಸ್ಟ್ ಆನ್ 20th in the fresh matters list. Interim order ಇದೆಯಾ? ಏನಿಲ್ಲ.
ಇದ್ರಲ್ಲಿ
ಅವತ್ತು ಬರ್ಲಿ.
ಇಲ್ಲ,
Yes.
connected.
Next, yes, Dhanesh.
86.
ಏನ್ 4 ಕೇಸ್ ಇದೆ?
In the sense, it is a case of.
ಏನು CCTV ಇದೇನಾ ಇದನ್ನು?
They are caught red-handed and he tried manipulating the thing by changing the IO by using his police powers. By 2 IOs he changed. Even then, his own department, considering the evidence on fact, on the case file, they have filed the charge sheet for me. And even none of the petitioners have filed entire charge sheet, but they are challenging the charge sheet. I have produced the certified copy of the charge sheet to your lordship last occasion.
All right, yes, sir, come on.
And everything is available on record. If you
Password. Here is the next.
Senior ಹಿಂದ್ಗಡೆ
very
ನಿಂತ್ಕೊಳ್ಳಿ.
time, there, last time also it happened. Sir.
Don't worry, wait. Yes.
Today
No
ಇದೆ
passwords.
ಅಲ್ಲ,
ಅವ್ರಿದ್ದಾರೆ,
very
ಮಾಡ್ತಾರೆ.
ಇವತ್ತು
ಪರವಾಗಿಲ್ಲ.
ತುಂಬಾ matter
ನಿಮ್ದು
ಗಳೆಲ್ಲ-
ಕ್ಯಾಮಲ್ ಕೇಳು. ನೀವು ಹೇಳಿ.
I tighten my breath and come back. ತುಂಬಾ ಕಡೆ ಎಲ್ಲ ಇವತ್ತು ಇದೆ ತರ ಆಗುತ್ತೆ ಸರ್ ಆಗ್ಬಿಡಿ.
ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
Sometimes it happens.
You're a
Sometimes
very
it's very free and.
busy counsel, sir. ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. Yes, sir.
I think.
No, ಅವ್ರ ಬಗ್ಗೆ ನೀವು ವರಿ ಮಾಡಿ. ನೀವು ಸ್ಟಾರ್ಟ್ ಮಾಡಿ. Yes. Yes, sir.
But the allegation appears to be, my lord, little very.
ಅವರು ಮೈಕ್ ಬಿಡಿ ಸರ್.
Complaint, my lord, at page 28.
Now petition remains only que petition number 2.
In my case.
Only that.
In your case,
In my case,
your
this
case
is-
ಅಲ್ಲಿ
It is not maintainable, so. The other one.
ಯಾವ್ದು ನಾಟ್ ಮೇಂಟೈನಬಲ್ ಅಲ್ಲ ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
My lordship, my only, my
Maintainable.
respectful submission is, they have played with the administration of justice by filing multiple petitions, suppressing the previous petition.
Yes.
There is a huge judicial
When
time
I-
has been wasted.
When I come to you, you can make your submission.
Please, my lordship, please.
ಎಸ್ ಕುಲ್ಕರ್ಣಿ ಸರ್ ಹೇಳಿ.
ಇವತ್ತೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗ್ಬೇಕು.
ಅವ್ರದ್ದು ಪೆಟಿಷನ್ ಕೊಡಿ ಮೇಡಮ್.
86.2. Double it.
ಎಸ್ ಸರ್.
Lord, at page 61, my lords.
Hmm.
Page 61. ಅವ್ರದ್ದು ಹೇಳಿಕೆ ಇದೆ ಅಲ್ಲಿ, ಅನುಪಮ ಅಂತ ಅವ್ರ ಹೇಳಿಕೆ ಇದೆ.
Page 61.
Page 61.
All
lords. Para 1, my lords, I think in the middle of page. ಈ ಘಟನೆ ನಡೆದಿರೋದು ಸೆಪ್ಟೆಂಬರ್ 6ರಂದು ನಮ್ಮ ಲ್ಯಾಂಡ್ ಓನರ್ ಹೆಸರು PO ಶಿವಕುಮಾರ್ ಮತ್ತು ಅವರ ಮಗನು ಸಮಂತ್ ಆತನ ಸ್ನೇಹಿತರು 7 ಜನ ಸೇರಿ ಆ ದಿನ ಗಲಾಟೆ ಮಾಡಿರ್ತಾರೆ. ಆ ಹುಡುಗರನ್ನು ನಾನು ಮುಂಚೆ ಯಾವತ್ತೂ ನೋಡಿರಲಿಲ್ಲ. ನಾವು ಇರುವುದು 3ನೇ ಮಹಡಿಯಲ್ಲಿ, ಆರೋಪಿತರು 4ನೇ ಮಹಡಿಯಲ್ಲಿ ಕ್ರಮವಾಗಿ ಕಟ್ಟಿದ್ದು. ಆಗಸ್ಟ್ 25, 2020 ಬೆಸ್ಕಾಂ ರವರು ಕಟ್ಟು ಮಾಡುತ್ತಾರೆ. ಅದನ್ನು ನಾವು ಮಾಡಿದ್ದೇವೆ ಎಂದು ತಿಳಿದುಕೊಂಡು ಅವತ್ತಿನಿಂದಲೇ ನಮಗೆ MCB ಆಫ್ ಅಂಡ್ ಆನ್ ಮಾಡುವ ತೊಂದರೆ ಕೊಡುತ್ತಿದ್ದರು. ನಾವು 3ರಿಂದ 4 ಬಾರಿ ತಿಳಿಸಿರುತ್ತೇವೆ. ನಮ್ಮದೇನು ತಪ್ಪು ಇರುವುದಿಲ್ಲ, ಬೆಸ್ಕಾಂ ರವರು ಮಾಡಿರುತ್ತಾರೆಂದು ಅದು ಅವರು ಮುಂದುವರಿಸಿದ್ದಾರೆ. 6ನೇ ತಾರೀಕಿನಿಂದ ನಾವು ಊಟ ಮಾಡಿ, ದಿಸ್ ಇಸ್ ದ
ಶ್ರೀಮತಿ ಅನುಪಮ.
His wife of my
Your wife.
Yes.
All right.
6ನೇ ತಾರೀಕಿನ ನಾವು ಊಟ ಮಾಡಿ ಬಾಲ್ಕನಿಯಲ್ಲಿ, ದಿಸ್ ಇಸ್ ದ ರೆಲೆವೆಂಟ್ ಪೋರ್ಷನ್ ಐ ಥಿಂಕ್, ಬಾಲ್ಕನಿಯಲ್ಲಿ ಸುಮಾರು ರಾತ್ರಿ 11 ಗಂಟೆಗೆ ಕುಳಿತಿರುವಾಗ ಶಮಂತ್ ಮತ್ತು ಆತನ ಸ್ನೇಹಿತ ಗಲಾಟೆ ಮಾಡಿಕೊಂಡು ಕೆಳಗೆ ಬಂದರು. 2 ನಿಮಿಷ ಒಳಗೆ MCB ಯನ್ನು ಆಫ್ ಅಂಡ್ ಆನ್ ಮಾಡುತ್ತಿದ್ದರು. ನಾವು ಅವರಿಗೆ ಹೇಳೋಣ ಅಂತ ಮುಂದೆ ಮರದ ಬಾಗಿಲನ್ನು, ಮೆಟಲ್ ಗೇಟ್ ಅನ್ನು ಬಿಟ್ಟು ನಿಂತಿದ್ದೆವು. ಮೊದಲು ಒಬ್ಬ ಹುಡುಗ ಬಂದು, ಆತನ ಹೆಸರು ನನಗೆ ಗೊತ್ತಿರೋದು, ನೇಮ್ ಇಸ್ ನಾಟ್ ಮಾಡೋದು, ಮುಖ ತೋರಿಸಿರುತ್ತೇನೆ. ಆತನನ್ನ ಮಗನ ಸೈಕಲನ್ನು ಎತ್ತಿ ಕುಕ್ಕಿ ಜಪಗೊಳಿಸಿ ಮತ್ತೆ ಎತ್ತಿ ನಿಲ್ಲಿಸಿ ಹೋಗಿರುತ್ತಾನೆ. ಮತ್ತೆ 5 ಮತ್ತು 6 ಜನ ಬಂದರು. ಅವರ ಬಾಯಲ್ಲಿ ಕೆಟ್ಟ ಮಾತುಗಳು ಬಂದು, ಸೋ ಅಂಡ್ ಸೋ ಮುಂಡೆ ಸಮ್ ವರ್ಡ್ಸ್ ಆರ್ ಹೇಳೋದು ನನಗೆ ಕಷ್ಟವಾಗುತ್ತದೆ. ಅದರಲ್ಲಿ ಒಬ್ಬ ಹುಡುಗ ತನಗೆ ಖಾಸಿ ಅಂಗವನ್ನು ತಮಗೆ ತೋರಿಸಿದ್ದು ನಮಗೆ ಶಾಕ್ ಆಗಿ ಬಾಗಿಲು ಮುಚ್ಚಿಕೊಂಡು ಹೋದೆವು. ನಂತರ ಯಜಮಾನರು ಕಂಟ್ರೋಲ್ ರೂಮ್ ಫೋನ್ ಮಾಡಿರುತ್ತಾರೆ. ದೇ ಸೇಮ್ ಇನ್ಸೈಡ್ ದಿ ಗೇಟ್ ದೇ ಸೇಮ್ ದೇವರ್ ಎಲ್ಲಿದ್ದಾರೆ ಅಂದ್ರೆ ಮೊದಲು ಗೇಟನ್ನು ನೋಡಿ ಬಂದಿರ್ತಾರೆ. ಡಿಸ್ಟೆನ್ಸ್ ಲಾಟ್ ಡಿಸ್ಟೆನ್ಸ್ ದೇ ಆರ್ ನಾಟ್ ಏಬಲ್ ಟು ಶೋ ಅದು ವಾಟ್ ಆರ್ ಹ್ಯಾಪನ್ಡ್ ಅಂಡ್ ನಾಟ್ ನೇಮ್ಡ್. ಇವನ್ ಅದರಲ್ಲಿ ಒಬ್ಬನ ಹುಡುಗ ಅಂತ ಅಲ್ಲೂ ನಾಟ್ ನೇಮ್ಡ್ ಇದೆ. ಇನ್ಸೈಡ್ ಮೆಟಲ್ ಗೇಟ್ ಅಂತ ಹೇಳ್ತಾರೆ. Therefore, there is one thing more. Secondly, my lords, there appears to be, my lord, as it is found from the other annexures, number of complaints are already filed. There appears to be, my lord, rival, there are daggers drawn. ಅವರು ಮೊದಲಿಂದ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಪ್ರಾಬ್ಲಮ್, ಇವ್ರು ಕಂಪ್ಲೇಂಟ್ ಕೊಡೋದು ಬಿಡಿಸೋದು ಇದ್ದೇ ಇದೆ. Manifest is the first thing that is gone into, my lord. Records are already produced. The annexures are produced, which would show, my lord, number of complaints are already produced. ಬೇಕಾದಷ್ಟು ಕಂಪ್ಲೇಂಟ್ಸ್ ಮೊದಲಿಂದ ಇದೆ. ಎಷ್ಟೋ ಡ್ರಾಪ್ ಆಗಿದೆ, ಕೆಲವೊಂದು ಹಂಗೆ ಉಳಿದಿದೆ, ಕೆಲವೊಂದು FIR ಸ್ಟೇಜು, ಚಾರ್ಜ್ ಸ್ಟೇಜು, 6-7 ಕೇಸ್ಗಳಿದೆ. ಕಂಟಿನ್ಯೂಸ್ ದೇ ಹ್ಯಾವ್ ಬಿನ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಹಿಯರ್. This also would go show, my lord, that the manipulation has been made, my lord. ಇನ್ನೊಂದು ಇದರಲ್ಲಿ
ಏನ್ ಮ್ಯಾನಿಪುಲೇಷನ್
ಅಲ್ಲ, ಮ್ಯಾನಿಪುಲೇಷನ್ ಅಂದ್ರೆ my lord made to say, my lord, that this has happened. ಆ ಗೇಟ್ ಅಲ್ಲಿ ಇವ್ರು ಇರೋದು ಎಲ್ಲಿ ಅಂತ, ಓನ್ಲಿ ಆನ್ ದ ಬೇಸ್ ಆಫ್ ಅಲಿಗೇಷನ್ಸ್ ದೇ ಹ್ಯಾವ್ ಟು ಬಿ. ಆಮೇಲೆ ಪೇಜ್ 54 ಅಲ್ಲಿ ಮತ್ತೆ ಅದೇ ಬಂತಲ್ಲ, 161 ಸ್ಟೇಟ್ ಪೇಜ್ 54 ಮುಳ್ಳ ಅನ್ನೆಕ್ಸರ್ C. 25/8 ಶಿವಕುಮಾರ್ ಅವರು ನನ್ನ ಸಮಂತ ಸ್ನೇಹಿತರಾದ ಶ್ರೇಷ್ಠ ಅವರಿಗೆ ಜೆಸಿತವರವರು ಪ್ಲಾಟ್ ಬೆಸ್ಕಾಂ ಕಳಿಸಿಕೊಂಡಿದ್ದು ವಿದ್ಯುತ್ ಸಂಪರ್ಕವನ್ನು ಕಳಿಸಿಕೊಡುತ್ತೇವೆ ಎಂಬುದಾಗಿ ತಿಳಿದು ನಮ್ಮ ಮನೆ ವಿದ್ಯುತ್ ಸಂಪರ್ಕ DP ಅನ್ನು ಅವರು ಉದ್ದೇಶಪೂರ್ವಕ ಆಫ್ ಮಾಡುತ್ತಿದ್ದರು. ನಾನು ಮತ್ತು ನಮ್ಮ ಯಜಮಾನರು ಹಲವಾರು ಏಕೆ ನಮ್ಮ ವಿದ್ಯುತ್ DP ಅನ್ನು ದಿಸ್ ಶೋಸ್ ಯಾಕೆ ಹಲವಾರು ಬಾರಿ DP ಅನ್ನು ಮಾಡುತ್ತಿದ್ದೀರಿ ಎಂದು ಪ್ರಶ್ನಿಸಿದಾಗ, ಶಮಂತ್ ಮತ್ತು ಅವನ ಸ್ನೇಹಿತರು, ನೀವು ನಮ್ಮ ಮನೆ ವಿದ್ಯುತ್ DP ಅನ್ನು ಆಫ್ ಮಾಡುತ್ತೀರಾ, ಅದಕ್ಕಾಗಿ ನಾವು ದಿಸ್ ಶೋಸ್ there is a trust between them, there is quarrel fight. This has resulted into this complaint is the first thing. Number 1, my lord, there are other litigations, civil litigations, whatever it is, my lord. Construction, he has, my lord, he is able to secure from authorities.
They say construction is not proper and all that. Those complaints probably these fellows have, my lord, lodged. That has narration, my lord, I need not go into one aspect. Secondly, my lord, as it seems, my lord, of course, subject to one thing that narration, my lord, exact allegation appear, I can't say anything, my lord. Records are there. But that also would not be visible or may not be relied upon because she was at a distance, my lord, she was able to, yaro obbanu andare.
It's a matter of evidence, trial.
That is a matter of evidence, correct? 354A, I don't know, yet another very important ground is, why not they
Ella bit to come to 354.
That's what I wanted.
Ashte.
No, I wanted to come that. I know what lordships would immediately catch the issue and
Yes, this.
354 hang barutte anta namagunu we are not able to.
ಹೆಂಗ್ ಬರುತ್ತೆ ಅಂತಲ್ಲ ಬಂದಿದೆ ಅಂತ.
ಅಲ್ಲಿ ಬಂದಿದೆ, that's not
Yes.
ಬಂದಿದೆ, but how at all they 354 ಅಲ್ಲ. Yes. Amended. 354, my lord.
Yes, sir.
May I read, my lord, that it? Assault or criminal force to woman with intent to outrage her modesty. Whoever assaults or uses criminal force to any woman, intending to outrage or knowing it to be likely that he will thereby outrage her modesty, shall be punished in the prison for a description for a term which shall not be less than 1 year, but may be extended 5 years and shall also find it fine. My lord, for all this, my lord, for the section to invoke, my lord, first concept is there shall be an assault or criminal force. Where are they?
ಅದಕ್ಕೆ
ಅಲ್ಲಿ ಇದಕ್ಕೆ to invoke 354, my lord.
ಆಮೇಲೆ
The, my lord, very logic of that section is, my lord, legal logic, what you call as, my lord, the subject, the very contemplation of section should be, my lord, section 354 says, there shall be an assault. There is no assault, my lord, nor criminal force.
ಸರ್ 353 ಗಲ್ಲ 354 ಗೆಳಿ
ಅಲ್ಲ 354 ಗೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. 354, my lord, gist of the section is, my lord, there shall be ಅಂತದ ಅದು ಇಲ್ಲ, that's not there, my lord.
You are appearing for accused number 3 ಅಲ್ಲ.
3 and 4.
Who is the prime suspect of 354?
Accused number 3 ಅಲ್ಲ.
Apologies.
ಅಲ್ಲಿ ನಮ್ಮದು ನಮ್ಮ ಪಿಟಿಷನ್, my lord, 8849.
Correct. ಅಲ್ಲ accused number 3.
Accused number 3.
If what you have done is not 354, I fail to understand what else can it be.
Assault or criminal
Assault ಅಲ್ಲ ಸರ್, ಲಾಸ್ಟ್ 3 ಲೈನ್ ಓದಿ.
or criminal force to
ಆರ್ ಎಲ್ಲ ಬಿಡಿ ಸರ್, ಲಾಸ್ಟ್ 3 ಲೈನ್ ಜೋರಾಗಿ ಓದ್ಬೇಡಿ, ಓದಕ್ಕಾಗಲ್ಲ.
complaint ಅಲ್ಲಿ
ಚಾರ್ಜ್ ಶೀಟ್ಸ್
charge sheet
page 53.
yes, I'm sorry. ಅದು ಗೊತ್ತಾಯ್ತು, that
ಅಲ್ವಾ?
I need not to read loudly.
Then we'll dismiss the petition.
No, my endeavor is only technical. I can't
Technical ಅಲ್ಲ sir.
No, we are, my lord, under 482 before lordship, my lord. I can't. No, I know where I stand. I can't go on saying
Then
no, this is
file discharge, sir.
only, my lord.
With this allegation, I am not going to interfere.
No, I know. I never said regarding, my lord. But concept is law concept times 482, my lord. Whether 354 would be applicable is.
It is applicable. I am saying what else can be 354 if this is not
criminal force ಅಂತ ಅದು
ಓದ್ಬೇಕಾ ಏನ್ ಮಾಡಿದೀರಾ ಅಂತ. ಕ್ರಿಮಿನಲ್ ಫೋರ್ಸ್ ಅಲ್ಲ, ಲಾಸ್ಟ್ 3 ಲೈನ್ ಓದಿ ಅಂತ ಪೇಜ್ 53 ಅಲ್ಲಿ.
No, I have not.
If that is not 354, what else?
Seeking discharge. I leave it to last. Seek for.
ಏನ್ leave it ಅಂದ್ರೆ I'll pass out some merits.
Seek for discharge.
You want to prefer discharge, you prefer. ನಿಮ್ದಕ್ಕೆ ಬರ್ತೀನಿ ತಾಳಿ.
Advocate and record, I am bound to ಕೇಳಬೇಕು.
I'll pass out some merits, not a problem. ಇದು ಮಾಡಿದ್ದು ಹೌದಾ?
100%, Swami. It is just a distance of 4 feet. All were drunk, my lordship.
All were drunk.
All were drunk, yes. This is the self-declaration quote, madam.
Kodi, madam.
See, all the
don't know how to behave with a lady.
Lordship, this is in continuation of the multiple criminal overtax by a police officer and an advocate and his family, just because legally protesting a illegal construction worth more than 3 crores, which is under demolition now. And further going forward,
civility.
Let me. No. It is not a
pendency of civil litigation is not a license to do all this.
And going forward, BESCOM has disconnected the power.
ಅದೆಲ್ಲ ಹೇಳಿದ್ರ last time.
You know
I just wanted to.
The accused.
ಮಳೆ ಬರುತ್ತಿದ್ದ ಕಾರಣ ಆಟೋಕ್ಕೆ
They meet in Levels pub before
doing this overtake and they were over drunk, fully drunk for 7 people.
Where were they?
Just say around 300 meters from my residence, there is one pub. That is Ali. Conveniently, they have written it as a Levels restaurant. It is not Levels restaurant. It is a Levels pub where all have met.
So
and
it was a Levels pub. And you were drunk beyond level.
It is their own statement.
Yes.
Their own statement. And all are caught red-handed in CCTV footage of the apartment. And a person who can orchestrate an SC/ST atrocity act on a person, they can very well do it. You have already passed, your lordship has already passed an order on that. It's a
yes, sir.
repeated action. If I would like to
Great
kindly,
reluctance, I will make submission. Your lordship.
This
may
is the-
Take it, your lordship may take it as heard. Tomorrow I will file a memo with part, that's all. I will not argue. Tomorrow, take it as heard.
You want to withdraw the petition? You can withdraw.
I can get this. Tomorrow.
Worship,
Without
this is one of the incident where I have objection. There is a 13-inch operation.
Nimaga.
How this one? It is, I was about to die. It is a question of death and this one.
All right,
Not
wait.
this,
It's not here.
with the 13 screws.
Wait. Yes. The learned senior counsel, SP Kulkarni, after arguing the matter at length, would seek leave of this court to get, to list the matter tomorrow. To seek instructions or a memo from the hands of the petitioner to withdraw the petition.
Either.
On that score, the matter is adjourned tomorrow, list tomorrow in the fresh matters list.
Lordship may not mistake us, only for how real.
ತೊಂದ್ರೆ ಇಲ್ಲ. Yes. While there merits ಮೇಲೆ ಬರಿಬೇಕು ಬರೀತಿ. Not a problem. Withdraw ಮಾಡ್ತಾರೆ ಮಾಡ್ಲಿ ಬಿಡಿ.
My humble submission before this honorable court is, first 5373 is filed before this honorable
First
court.
ಒಂದೊಂದಾಗಿ wait.
Only to bring it to your kind attention, Swami. 5373, considering the severity of the problem, your lordship only has given only notice, issued only ordered for notice. Further, they suppress this and it is a huge judicial work is
ಒಂದ್
wasted.
ನಿಮಿಷ.
I have filed an IA for
ತಗೊಳಕ್ ಹೋದ್ರೆ ಎಲ್ಲ ಜುಡಿಷಿಯಲ್ ವರ್ಕ್ ಬೇಕಾದಷ್ಟಕ್ಕೆ ಆಗಿರುತ್ತೆ. ಒಂದ್ ನಿಮಿಷ.
perjury. It is up.
ಪರ್ಜುರಿ ಒಂದ್ ನಿಮಿಷ wait. ರಾಧಾಕೃಷ್ಣ ಅವರೇ, come to your petition.
Malad, in all 4 persons have filed. Subsequently, on 28,
ಇದರಲ್ಲಿ ವಿಡ್ರಾ ಆಗಿರೋದು ಯಾವ್ದು?
I have withdrawn 3 persons.
ಈಗ ಯಾರು ಉಳಿದಿದ್ದಾರೆ?
A2 is remained.
Who is A2?
A2 is, this Malad,
This, A2 is the police officer.
allegation against the A2 is concerned, Malad, page 32, Malad. He was neither present by neither.
That finding I've already given in the other case, looking at the transcript of the CCTV footage that you were present and you have tampered with it.
So for present.
Where is that? Where is that judgment? Kudi.
Judgment is
The allegations were I think according to me.
Kudi, yes. You are not present ಅಂದ್ರಲ್ಲ ಅದಕ್ಕೆ ಹೇಳಿದೆ. If you are not present, then it is a matter of trial.
Turn to page number 25, Malad. Page
Yes.
25.
Yes.
May I, my lord, seek,
Column number
my lord, may I seek to other court?
Already, sir. Yes.
Sorry.
Column number 25, page number 25.
Yes, sir.
Column number 17.
Yes, sir. Thank you.
Line for fifth, line formula. ಅಂಕಣ 12ರಲ್ಲಿ ನಮೂದಿಸಿರುವ A2 ಆರೋಪಿಯ ಪ್ರೇರಣೆಯಿಂದ. This is the allegation. He was not present at this spot at all.
ತೊಂದ್ರೆ ಇಲ್ಲ. Not present ಅಂದ್ರೆ it's a matter of trial.
Malad, that's my kindly in the case of this time. Malad, you understand? I request you, that's my kindly.
This, I have clearly observed in this matter that at your behest, everything has
My
happened.
petition, Malad, my petition, ground number 11.
Yes, sir.
These are all the cases filed by against this R2.
That may be. I am not on that. at all.
That
Sir,
is true, Malad.
he may have filed. You may have driven him to the wall to file so many cases. That's a different thing.
For a when a school, for example, my tenant, against the principal. This is, I request you, that's my kindly. 1 second.
ಅದು ಪ್ರಿನ್ಸಿಪಲ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಲಿ ಬಿಡಿ.
ಮಾಡಿದ್ದಾರೆ.
ಮಾಡ್ಲಿ. ಅದು ಸಪರೇಟ್ ಆಗಿ ನಡೀಲಿ.
ಇದೇ ಕೆಲಸನೇ.
Why are you worried?
I'm not worried about my
then
such a nature. ಇವರೇನಂದ್ರೆ 24 hours you will be in the court. ಈಗ ಇದ್ಕೊಂಡು ಎಲ್ಲಾರನ್ನು ಡ್ರಾಗಿಂಗ್.
ನೀವು ಅಡ್ವೊಕೇಟ್ ಅಲ್ವಾ?
I am advocate. I am
supposed to ಇರಬೇಕು. ಇನ್ನೆಲ್ಲ ಇರ್ತಾರೆ.
For easy litigation, not for public litigation.
ಬೇರೆ ಕೇಸೇ ಇಲ್ವಾ?
I have filed 138 before your lordship and filed a memo also. He has no right to say that.
ಕ್ಷಮಿಸಿ, para 11.
On that front, sir.
Over.
Para 11 ಬಂದ್ಬಿಡಿ. Para 11, page 5 of my petition. Total cases which I have stated. I request you, one second. Yes.
ಹೇಳಿ.
Para 5. Page 5, my petition. Para 11. Respond number 2, Roman 1, Malad. Respond number 2, CM Dinesh filed a case in crime number so and so against Spurti, Nikhil, who are tenants of petition number 2.
ಮೂರ್ತಿ ನಿಖಿಲ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಾರಾ? ಮೂರ್ತಿ and ನಿಖಿಲ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಾರ?
ಕೆಲ್ಸನೇ ಇದು ಒಂದ್ ಚೂರು ಏನಾದ್ರು ಜೋರಾಗೆ ಕೆಮ್ಮಿದ್ರು ಗಲಾಟೆ ಮಾಡಿ ಒಂದು ಕೇಸ್ ಹಾಕ್ತಾರೆ. ಪೊಲೀಸ್ ಆಫೀಸರ್ ಲಾಯರ್ ಇಟ್ಕೊಂಡು ಲಾಯರ್ ಹಾಕಿದ ತಕ್ಷಣ ಎಲ್ಲಾರನ್ನ ಕೇಸ್ ಹೇಳುದು ಕೋರ್ಟ್ ಗೆಲ್ದು ಬಿಟ್ಟು ಕೇಸ್ ಹಾಕ್ತಾರೆ ಅದನ್ನ.
That is not the concern. I would not have entertained that at all. Just because he is a lawyer, it is not that.
My client is concerned, madam. He was not present at this part. My their main
Your-
case is
This is P.O. Shivakumar alva, your client. Yes, no problem. I have held, he was present in these, all arising out of the same incident.
that, so for that aspect.
If you are not present, adjournment illa.
I am not seeking.
If you are not present, it's a matter of trial.
Cases, case details.
ತೊಂದ್ರೆ ಇಲ್ಲ.
ಇನ್ನೊಂದ್ಸಲ ನೋಡಿ ಸರ್.
ಅಲ್ಲ, para 5 ಅಲ್ಲಿ ಮತ್ತೆ he accepts that it is not that he is denying. He accepts that he has
There are
filed.
5 criminal cases pending as of today with the proofs, evidence on record. Your lordships have already dismissed 2 criminal petitions.
ಒಂದು ಇಲ್ಲಿ, ಒಂದು ಜಸ್ಟಿಸ್ ಸಂಜಯ್ ಗೌಡ್ರು ಇನ್ನೊಂದು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ. ಪಣೀಂದ್ರ ಸಾಹೇಬ್ರಿಗೆ ಗೊತ್ತು.
And also they are running a illegal brewery business in the apartment.
ಎಲ್ಲ ನೀವು ಬೇರೆ ಕಡೆ ಹೇಳಿ.
So this is all being
Yes,
a police officer to protect the law. He has been misusing the laws.
ಬನ್ನಿ.
You have heard, your lordships have observed in one police versus police, a constable misusing the power.
Police versus police.
You highlighted that.
ನಂದೆಲ್ಲ ಹೇಳ್ತಾ ಇದ್ರ.
It was just observed a constable misusing the power. Imagine a 13-inch operation.
All right, yes. Yes, Pranindra sir.
I am in 86.1, accused number 5. This complaint, if your lordship says, so far as I am concerned, the vague statement is made so far as I am concerned.
What is your name?
Abhay.
You are petition number 1 in that petition which I dismissed.
Dismissed. We were there. my lord.
Abhay was not there in this.
Abhay, we were not there. My lords, the allegations made, my lords, against another person, yes, I can understand. So far as I am concerned, except making a.
Petition ಯಾವುದು ನಿಮ್ದು? Abhay.
That's 86 point, that is 6712.
ಇದೆಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರಾ? ಹಾಕಿದ್ದಾರೆ. You are accused number?
5, my lords. A5. The statement is that I was.
354 ಬರಲ್ಲ ನಿಮ್ಮ ಮೇಲೆ, but 447, 427.
And but so far as criminal trespass, now the incident, what they say is under, near the meter board. Now that, my lords, is not a trust. I can understand if I trespass into their property.
427.
Lords, that's.
Mischief.
That, there should be some allegation, my lords.
ಇದೆಯಲ್ಲ.
If your lordship says, my lords, I can
ಪದೇ
understand.
ಪದೇ ಸ್ವಿಚ್ ಏನಿದು
Switch off.
ಆಫ್ ಮಾಡಿ ಆನ್ ಮಾಡಿ and at that point in time this accused number 3 has done something that is of course
That's
horrendous.
why, my lords, I said, accused number 3, I
For
can
all
understand.
together.
We are simply, we are staying there, we have been.
I'll
roped in.
adjourn it by 4 weeks.
No, my apologies.
But we are staying there, we are roped in because of saying that we were also present. Otherwise,
120
there's nothing.
120 B ಇದೆ.
My lords,
120 B ಇದೆ.
that's why, my lords, it's a general statement. Otherwise, there is no other allegation made against me that he only says I was present there. Now, my lords, everyone is present in the apartment. Can everyone be roped up?
Everyone are not. ಆತರ ಇದ್ದಿದ್ರೆ he would have roped in everyone.
That's, no, that's what. is
ಆತರ
happening
ಇದ್ದಿದ್ರೆ
there.
he would have roped in everyone.
I'm only
He
saying.
has roped in only a few against whom he has
That
a
is what
grievance.
He has a grievance.
Yes.
Now, my lords, that your lordships have passed. If your lordship.
Not
says
only
he is-
me, even Justice Sanjay Gowda has written the same thing.
Right.
Yes.
That's the only thing, that there is nothing so far as I am concerned, but except. a
Better
vague
you
statement.
come out clean in a trial or file discharge, whatever you want.
Your lordship may give me that liberty.
All right, discharge. Yes. Same. Yes, sir. Except SP Kulkarni ನಾಳೆ ಬಿಟ್ಟು ಮಿಕ್ಕಿದ heard senior counsel ಅಂತ ಮಾಡಿ all contentions left open before discharge. ಎಲ್ಲ ಅಲ್ಲಿ ಕೊಡಿ. ಕ್ಲೋಸ್ ಆಯ್ತಲ್ಲ ಈಗ ಅಲ್ಲಿ ಕೊಡಿ. ಎಸ್. ಮತ್ತೆ ನೀವು ಫೋಟೋ ಎಲ್ಲ ತೋರ್ಸಕ್ ಹೋಗ್ಬಿಡಿ.
No.
ಜಗದೀಶ್ ಅವ್ರಿಗೆ ತೋರಿಸಿ. All right. No, maybe he has gone overboard. That's not a thing. But definitely all of you have driven him to the wall. Prima facie, that is what I have held.
Who is the main kingpin accused?
Allah, that is what.
Mastermind.
P.O. Shivakumar,
Yes.
yes,
With the proofs.
yes.
Much obliged.
ಮತ್ತೆ ಇದನ್ನ ಮೂವ್ ಮಾಡಕ್ ಬರಬೇಡಿ.
ಇಲ್ಲ sir.
ಎಸ್.
The respondent number 2, my lords.
For the petition.
331 ಮಾಡಿದ್ದಾರೆ.
This is
ತಗೊಂಬಿಡಿ.
clubbed with,
Huh?
this is a predicate offense forms part of a ECIR registered against the accused.
PMLA ಇದೆಯಾ?
Yes, it is listed on 21st. We have challenged the summons issue.
87 list on 21st.
Mean-
330 matter
My
ತಗೊಳ್ಳಿ.
lords, if I may be permitted to file an amendment application.
File
in
it in
this-
the registry, madam. No problem.
Please.
I'll file
You
my
want it, yeah?
objections also.
Huh?
Statement of objections is.
File
already-
ಮಾಡಿ list on 21st. Whatever you have to do it. 330 matter ತಗೊಳ್ಳಿ.
Other hearing. Interim order may be
Huh?
extended. Interim order may be extended.
That will be extra. Yeah, 152.
Petition.
Yes, madam. ನೀವಿಲ್ವಾ?
Yes, please.
ಇಲ್ಲಿ ರಾಘವನ್ ಸರ್ ಇಲ್ವಾ?
Yes, end up in another court.
ಹಾ. You start. Yes. He has argued at length.
I have no problem. My only problem is if he comes now again, the
No
train
problem.
of.
Let him. All of them are coming except Raghavan sir.
I just check, he's on his legs in quarter
Yes,
13.
yes.
I just take my lords through, I think, if there's any repetition, my lords may kindly correct me. That just take my lords through the complaint. Now, I think the basis was set. The basis is just this, my lords. Now that in 2020, there was an application before the Russian consulate in Dubai. That certificate is produced. Now, as an afterthought, there is an allegation that it was never my signature. I never came to the consulate. In fact, oddly enough, in the complaint also, there is no such averment, even though she was, at that, I'll take my lords through the dates. She was aware of the fact that this was done because in fact, it is mentioned in our second MC case, which we had filed in 2023. There is a reference to this. I'll just, since I mentioned it, my lords, may kindly see in the petition, page 78 is the 23 petition.
2023 petition.
Yeah, that's right, my lords.
Page?
Page 78 of the writ petition.
All right.
My lord, may kindly see paragraph number 12, page 83.
Oh, this is the MC petition you filed.
That's it, the second one. The first one, my lords, of course, was filed in 2020.
All right.
This is the one which possibly as a matter of abundant caution to make sure that there is no loose ends left, this is filed. Paragraph number 12, page 83. On 23/12/2020, this is my averment, 23/12/2020, acceding to the respondent's request, the petitioner jointly applied for an administrative divorce before the Consul General of Russia in Dubai, UAE, with the respondent. Since the petitioner respondent did not have any children and had consented for the divorce, the Consulate General of Russia in Dubai, UAE, acting as a civil registry office under Russian law, registered the divorce and issued a divorce certificate on 24/1/2021. Now, let's just give me a list. The notice of this, my lords, was served on the respondent. This was filed on 16th of November 2023. Notice was issued in this on 17th of November 2023. Notice was served on 5th of December 2023. Filed on 16/11.
17/11 notice.
Notice issued on 17/11. Served on 5/12. And once again served through airmail on 4/3.
Once again served on?
I'm sorry, what?
Once
4/3, 4/3/24. And this complaint, my lords, was filed on, what date was it? 11th. No, 7/3/24, this complaint was filed.
All right.
Now kindly see the complaint, my lords. Complaint starts at page 40.
Yes, sir.
I won't trouble my lords reading the entirety of the complaint, just some relevant paragraphs, but my lords may take it from me that there is no whisper about this, this afterthought of an argument, if I may call it, regarding the fact that that decree of in the Russian consulate was obtained due to fraud and a false signature and so on.
There
So,
is
my
no
lord,
averment.
no such averment in the complaint. Now, my lords may kindly see para 41. Sorry, page 41, para 3.
Yes.
The petitioner submits that the respondent had deserted and abandoned the petitioner for no rhyme and reason so far and has not made any efforts towards reconciliation. My lords may kindly mark this. The petitioner and the respondent are living separately since 2021. But occasionally, the respondent visited the residence of the petitioner in Dubai along with his friends, disconcerting the peace and harmony of the petitioner by partying all night and subjecting the petitioner to cruelty. The respondent from 2019 has subjected the petitioner to immense cruelty and humiliation throughout her stay with the respondent by casting aspersions on her conduct. The petitioner was put under constant stress from 2019 due to all the cruelty exerted by the respondent. The petitioner was employed in the business of the respondent, and since 2021, she has been laid off by the respondent, and the petitioner had to shoulder the financial burden of maintaining herself and would require substantial amount towards quality lifestyle, conveyance, so on, incidental expense, and so on. Then last, about 3 lines from the bottom, my lords. The respondent being gainfully engaged in a profitable business has not been supporting the petitioner since 2021, and therefore the petitioner is constrained to file this petition seeking an order of protection, so on. Now, 2 things emerge from this, my lords. One, that these allegations seem to be all relating to the period 2019 to 21. Admittedly, complaint filed in 2024. 2, there's an admission that since 2021, we have not been living together. Only sporadically, this person, the petitioner, used to visit and harass me. That's all. So, my lords, there is no allegation also in the complaint that we had either a marital relationship or any relationship in the nature of a marriage. And now this seems to be the theme throughout, my lord. Paragraph 6, my lords may kindly see on the next page, page 43. Now, this is the third point, Maras. One is 2019 to 21. Since 2021, they've been living separately. Third aspect, Maras, may kindly see at para 6.
Paragraph 6.
Paragraph 6, page 43.
Yes.
It is further stated that the petitioner and the respondent shared a better understanding and companionship until the year 2019 and had jointly purchased a house in Dubai in the year 2014, namely the Meadows House, in a joint name as the petitioner had invested to the extent of 50% of the sale consideration. It is further submitted the respondent had promised to transfer. I'm sorry, I'll just continue reading. It is further submitted the respondent.
What purpose are you reading this?
The purpose is, my lords, all of these allegations pertain to alleged acts committed in the United Arab Emirates, not even in India.
All right.
So those are the 3 aspects, which emerge from the complaint. I won't trouble my lords reading the entire thing. If my lords were to see it, throughout the theme appears to be 2019 to 21. We have lived separately since then, and all the acts that he has committed, when he comes to Dubai to visit me, all these acts are committed. So those are the 3. My lords may kindly see para 13 also.
Para
13, 1-3, page 49. It is further submitted, paragraph 13, it is further submitted that the respondent, that is the petitioner before your lordship, is representing to close family and friends that the marital bond between the respondent and the petitioner has been dissolved by virtue of a divorce decree, which is far from the truth and is fictitious. It is submitted that the said representation of the respondent is tarnishing the reputation and good name of the petitioner, as the respondent is representing the petitioner a negative connotation to the mutual close family and friends. It is submitted the respondent is soliciting illicit relationships from numerous women by representing himself as a divorced individual. It is further submitted that the act of the respondent is contrary to the marital obligation which was agreed upon. Now, once again, my lords, again, as I was submitting, all of these submissions pertain to acts in Dubai, again, from 2019 till about 2021.
Yes.
And finally, my lords, paragraph 22. 22. Paragraph 21, I'm sorry, previous page, page 52. It is further submitted that the petitioner had issued a comprehensive legal notice dated 27/11/23, calling upon the respondent to refrain from the acts of harassment and to dissolve the marriage by transferring 50% ownership in all the assets owned by the respondent, which the petitioner is rightfully entitled to. The respondent on receipt of the said legal notice has chosen not to reply for the same in the Meadows house, and the respondent would have the petitioner and her daughter killed. It is further submitted the petitioner had issued a second legal notice dated 6/12/2023, calling upon the respondent to refrain from harassing the petitioner and her daughter. So notices were issued in the year 2023. Again, there's a lull between 21 and now all of this seems to have been triggered by this 2023 MC petition. That's where it appears as if suddenly there is a second awakening. And now that I have filed petition on, as it was alleged, wrong advice, as the case may be, I still believe, my lord, it was the correct thing to do, because since there was a certificate subsisting, and certificate, as Mr. Raghavan pointed out on the last date, it was a certificate only certifying that the marriage had been solemnized as per Russian law. So as a matter of abundant caution, this MC petition was filed. Now all of this gets triggered by this. And all of these allegations, and conspicuously, there is no denial of the certificate of 2021, which was alleged in our complaint, which admittedly she had received notice of. So those are the aspects I'd like to point out. Now, my lord, of course, the lordships has seen the prayer. It's
Prayer I have seen.
prayer.
Not read.
Yeah, my objection.
Lull has become the key word now.
Correct. I understand.
Taking cue.
No,
from-
no check period. No, no.
Ah, yes. It's lull period.
Now, my lords, my lords, may kindly see the objections to my writ petition that have now been filed. Now, how there is an improvement of the case on the allegations in the complaint. My lords, may kindly see the objections that was originally filed, not the sur rejoinder, but the
Objections of the petitioner.
objections. Yeah, yes, that's right. So objections, it's stylized.
Not the sur rejoinder.
Not the sur rejoinder. Or
Sir. ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ದಿನ ನಡೆದ್ರೆ ಸರ್ ಟು ದಿ ಪವರ್ ಆಫ್ ಟ್ರೂ. 1 minute. The first objections, right?
That's right, my first objection.
Memo of citing, madam, objections. First statement of objections.
Yeah, yes.
Objections copy. Page. Rejoinder to the statement. Objections.
Rejoinder. Page number illa, but paragraph number I'll just mention. Paragraph 6.
Then,
Now, just before taking my lords, one thing I'd like to point out was now mentioning during this lull period, after we filed the second MC case in 2023, there is, for lack of a better term, these package proceedings. One is this case. There's also a case, my lords, which she files for restitution of conjugal rights.
yes.
All of them, everything is done within a few dates of each other. 7th of March, this is filed. 12th of March for restitution of conjugal rights. And what else is filed? And 125 also. So there are 3 proceedings within 5 days of each other. As soon as notice is issued, it appears as if this is done as a reaction to it. Now, my lords, may kindly see the objections. Paragraph 6, my lords.
Yes.
Now, this is for the first time, she says, following the dismissal of the divorce petition by the family court in MC so-and-so, the petitioner also submitted an application seeking a divorce by mutual consent before the Consulate General of Russia in Dubai without the respondent's knowledge. The first time this government comes in. The respondent neither subjected herself to the jurisdiction of the Consulate General of Russia in Dubai, nor appeared in person. However, the Consulate General of Russia in Dubai has accepted the forged affidavit of the respondent presented fraudulently by the petitioner and granted dissolution of a marriage under Article 160, Clause 2 of the Family Code of the Russian Federation. So therefore, this is the first time this allegation is made. Now, again, Malaj, just to see how another improvement. Paragraph 8. Upon repatriation from Russia in July 2023, the petitioner pressured the respondent to remain in Dubai. After the respondent arrived at their joint residence known as Meadows House, the respondent was surprised to discover all her belongings from Bangalore has been relocated there. When the respondent inquired about this, this petitioner falsely claimed to be on a business trip. The respondent subsequently joined the petitioner on his business travels, but inexplicably prevented them from staying at their Bangalore home. The respondent asserts that while she had accompanied the petitioner on business trips, he was covertly taking steps. Now, next sentence. Further, the petitioner and the respondent cohabited in both Bangalore and Dubai until November 23. Again, just to point out, there's an improvement every time. Then paragraph 9.
In what?
In the original complaint,
Oh, yeah.
there's a specific government that
All right.
2021 onwards. That's all. So now again, there's just to establish all of this finally is to establish that there is, even if there is assuming no marriage, there's a relationship in the nature of marriage. Of course, she's denying the fact that the marriage is dissolved at all because of the fraud. But in essence, what I'll come to the case law on the aspect. But in short, at least my submission would be this: the Russian divorce. There's a certificate. We have, in fact, to be safe, recently we applied for another certificate from in Russia itself, in St. Petersburg. Oh. That also exactly the same. The divorce certificate number is the same. So it's not as if this certificate was cooked up. So just to make sure, the same certificate was obtained by us from Moscow also, or St. Petersburg. Now, sorry. No, if Lordships wants, we can file it. There's no denying the fact that there is a Russian divorce. Now, in essence, my submission is this: rightly or wrongly, a court of, or rather an authority of competent jurisdiction, as per Russian law.
Russian consulate in Dubai.
That's right.
Yes.
An authority, which is why I said,
all right.
Even if it's not a court, an appropriate authority of competent jurisdiction has granted a divorce certificate. Now, this divorce certificate is produced. There's a Russian lawyer's opinion also explaining the law on the aspect. Now, essentially what the respondent is asking this honorable court to do is to ignore it, or rather hold that to be fraudulent. Now, whether that is permissible is what your lordships would have to consider. Now, to hold that divorce certificate is not binding and that marriage still subsists, your lordships would necessarily have to hold that the Russian divorce certificate has been obtained by fraud. Now, my lords, there are serious allegations of fraud, who forged the signature, so on. Admittedly, no action taken between 21 to 24.
But if the respondent is able to show that she was not even present at the time, then
that, my lords, I would respectfully submit, assuming if she is able to show that she was not even in Dubai, she was in India or wherever, any other part of the world. Now, would it be appropriate for that to be raised before your lordships, or would it be appropriate for proceedings to be raised as per Russian law?
All right.
As per, because there, my lords, let us assume there is a decree of divorce from the US. Now, to ask an Indian court to ignore that would, in my respectful submission, not be appropriate. One would have to go to the US court, convince the US court that it was a fraudulent decree, and then present that. Then, of course, your lordships would have to, in the interest of comity of courts, follow it. Now, in fact, my lords, may kindly see in our rejoinder, just to buttress the fact that this is all an afterthought, there are messages that we have produced. I think Mr. Raghavan read them out on the last date. I won't. This is the rejoinder to the statement of objections. My lords, may kindly see page 9. The messages themselves are reproduced, but we have extracted them just for the sake of convenience. Page 9 of the rejoinder. Kindly see, my lords, first in bold, you no more my husband. I'll decide what to sell. This was sent on 16th.
Raghavan sir has read this.
Yes, my lords. So basically, my lords, this is, it all falls into place that there was never any marriage. Now, after this MC case, this seems to be, everything seems to have now dawned upon them that they should start these proceedings. So that's just to show that, my lords. Now, may I take my lords through some of the judgments on the aspect.
Yes. Yeah, copy ಕೊಟ್ಟಿದ್ದೀರಾ?
Copy, I think we're having.
Memo of citations are here. You have it, madam? Memo ಕೊಟ್ಟಿಲ್ವಾ?
Well, I think we've given, I think there are 2 memo of citations that have been given. I think there is one more possibly. I think those have been given. That's all. That's all.
1 and 2.
1 and 2, that's it. I think there are 2. Now, all the propositions are laid out, my lords. I'll just read them out, and all the paragraph numbers.
No, this Raghavan sir is already referred.
That's right, my lords. So then I won't trouble. I'm sorry. That's why at the outset I apologize if there's any repetition.
No, it's all right. Bird of passage.
That's right, correct.
He has referred to it, yes.
Then I think paragraph, sorry. No, that's okay. Then I think my lords may kindly come to, if possibly the judgments at 6 and 7 I'll just read the proposition.
Propositions,
I'll just read the proposition. It's
Muhammad
basically-
Ali.
That's right, the judgments on Muhammad Ali and Achin Gupta. If they're with the, your lordships knows it, so we've marked the paragraph.
Muhammad Ali is for the contention perhaps that it's a cleverly worded complaint. All right.
And also, my lords will have
Achin
to
Gupta,
read
498
between the
days.
lines and so on. So that's it. Which is why my lords, your lordships is well aware. So that's why we only extracted the proposition. Your lordships may see it at an appropriate time. Now, the second memo of citation, my lords, which are more pertinent to the.
I think second memo I have not seen. Yes. Second memo is.
The second memo. I'll just. That's been served. Now, the first proposition, my lords, is regarding delay. Your lordships has it?
Yes.
That's right. So basically, all these allegations as I was submitting pertain to the period 21 to 23. The complaint,
Chanchalapati Das.
sorry, 19 to 21. I'm sorry, Chanchalapati Das. So therefore, any inordinate delay would have to be explained. So without any explanation, and there is admittedly no explanation as to why 3 years went by, 3.5 years went by, and still no action was taken. Then the second set of propositions, my lords, is that the provision of the DV Act can be invoked only when domestic relationship is in existence, and where the domestic relationship ceases, the provisions under the Act cannot be invoked.
Which is that?
Now, my lords, that will be the line of judgments from serial numbers 4 to 7. These are all various high courts. My lords may kindly see the first one, Ravel Singh, which starts at page 30. Now, if I may draw your lordship's attention to para 8 onwards, at page 32.
Yes.
Now, the question that arises for consideration in this case is as to whether the marriage between the parties stands dissolved and the complainant respondent herein has lost the status of wife, and that there is no domestic relationship between the parties in order to invoke the provision of the DV Act. Now, para 10, my lords, lays down the facts fairly similar to this, my lord. No, not, I'm sorry.
Para 10 of?
No, please.
Ravel Singh.
Mr. Raghavan has come.
I apologize to your lordships.
No, no problem. Let him finish, or you want to continue, you can.
I'll just finish this line of judgments,
yes.
and then now, para 10, my lords may kindly see.
Yes.
There is no dispute with regard to the fact that the petitioner number 4, Baldev Singh, was settled in Germany since 2002 on account of his employment. He married the complainant respondent herein, and after the marriage, she also went to Germany, and both of them were residing there. They became permanent residents of Germany, and after having stayed in Germany and becoming permanent residents of Germany, the relationship between them became hostile to each other, and both of them started living separately. Thereafter, petitioner number 4, Baldev Singh, approached the district court, Wisman, and filed a petition for divorce. The complainant herein contested the same, but petition number 4, Baldev Singh, succeeded in getting the marriage dissolved. The fact that the petition number 4, Baldev Singh, has approached the district court, Wisman, Germany, and the said court having dissolved the marriage by pronouncement of a judgment, petitioners have produced a certified copy of the judgment and decree dated 27/2017. This pausing, the only difference, if at all, would be it's a court. Here, my lord, it's an appropriate authority. Now, the Russian law permits a divorce before an authority. I don't think anything can be read into the fact that it's an appropriate authority, which I'll leave it at that. Now, my lords may kindly see para 15. The complainant respondent herein in the complaint has nowhere stated that such decree of divorce has been obtained by fraud or has been passed in breach of any law enforced in India, nor any ground has been stated in clauses A to F of section so-and-so of CPC. In the absence of any condition as contained in clauses A to F, presumption regarding the fact that such judgment is conclusive is attached to the said judgment. Now, the findings, my lords, will find it para 21 onwards.
Yes.
From the aforesaid discussion, it is clear that the petition number 4, Baldev Singh and
Para 21.
Para 21, page 36.
Oh, yes.
From the aforesaid discussion, it is clear that the petition number 4, Baldev Singh, and the complainant respondent herein were permanent residents of Germany and were subjected to the laws of that country, and the district court, Wisman, Germany, having jurisdiction, had decided the petition filed by the petition number 4, Baldev Singh, for divorce, and has dissolved the marriage. By passing of the decree of divorce dated 27/2017, the marriage relationship between the petition number 4, Baldev Singh, and the complainant respondent herein came to an end and has ceased to exist. Now, paragraph 27, my lords may kindly see it. Therefore, for the reasons stated herein above, it is held that the judgment/decree of divorce dated so and so, passed by the District Court, Wismar, Germany, whereby the marriage has been dissolved, is conclusive and binding upon the parties. The said judgment decree has not been challenged, kindly mark this, has not been challenged by the complainant respondent herein. Therefore, it is held that the relationship of husband and wife between petition number 4, Baldev Singh, and respondent so and so, has come to an end. The complainant respondent herein, after passing of the aforesaid decree of divorce dated 27/17, filed a complaint against the petitioners without observing that the marriage has been dissolved by the District Court, Wismar, Germany. The relationship between petition number 4, Baldev Singh, and the complainant respondent herein has come to an end, and they are no more husband and wife after passing of the decree of divorce. Here also similar, which is why I was submitting. If at all any remedy has to be availed, they have to avail the remedy under Russian law to set aside that decree or as the case may be, this certificate of divorce. Then, my lords, paras 34 onwards, my lords, they come back to the DV Act, having established that there was no marriage subsisting.
Yes.
While having regard to the facts and circumstances of the case in hand falls under the rarest of rare cases in which discretion is required to be exercised, because there is no domestic relationship between the parties, and in the absence of such domestic relationship, provisions of Domestic Violence Act cannot be invoked. Therefore, the allegations made in the complaint would not constitute commission of any offense under the provisions of the DB Act, which requires existence of a domestic relationship. The allegations in the complaint thus are absurd and inherently improbable, and on the basis of such allegations, there is no sufficient ground for proceeding against the petitioner accused in the complaint. These criminal proceedings are thus manifestly attended with malignant and ulterior motive for wreaking vengeance on the petitioners. Thus, the grounds taken in the petition made out a case in favor of the petitioners of quashing the proceedings. Now, my lords, may kindly see one document. This is in the same compilation at page 82. This is a treaty between the Republic of India and the Russian Federation. Article 10. Article 10, my lords, may kindly see at page 87.
Article
10 at page 80. The treaty starts at page 82. It says, attaching importance to the development of cooperation in the field of legal assistance.
The recognition of documents.
That's right. Documents issued or certified in the prescribed form and sealed with an official seal of the court or other legal authority, other competent body or official person in the territory of one contracting party shall not require any form of authentication in the territory of the other contracting party. Documents considered as official in the territory of one contracting party shall have the evidentiary force of official documents also in the territory of the other contracting party. And Article 24 speaks of judgments. Your lordships expressed a doubt whether it's a judgment or not, but this, of course, Article 10, I think, should cover the issue. I'll just ask Mr. Raghavan if I think all those judgments, I'll just close with this. Those judgments which I had read out at Ravel Singh, the remaining judgments in the same compilation follow Ravel Singh to the same extent. So where there is no subsisting marriage or any relationship in the nature of marriage, provisions, and so all Amit Agarwal, Santosh Kumar, Sanjay Singh Thakur, all follow.
All to the same effect.
All to the same effect. All right.
Yes, sir.
Yes. I want to point out, your lordships, one important aspect. My lord, one of the points that we have raised, apart from the fact, my lord, that the marriage has been dissolved in accordance with the Russian law, even when your lordship looks at the averments in the petition that has been filed before the DV court, all the allegations are with respect to what has happened in Dubai. Now, the question that I place for your lordship's consideration is, the point that I place for your lordship's consideration is, in respect of acts, because we are in a 482, my lord, I will assume that whatever is said in the complaint is true. In respect of acts alleged to have taken place in Dubai, is a petition before the Bangalore court maintainable is a question. And in this regard, my lord, that's why, my lord, I want to show to your lordships what is the summum bonum of their complaint before, or the petition before the DV court. It is that in Dubai all this happened. And then, my lord, it will be my submission that their filing a petition here, coming, and even if they were staying for 1 day, 2 days, 3 days in Bangalore, they were birds of passage. She was a bird of passage. I'm not using this term a lot. Supreme Court uses that word. That you can't say you will take a hotel room and then say, I'm residing there. That's what happened in Delaware, in the United States. I'm told it is easy to get divorce. So what persons do is to go from one state, even though they are permanent residents of that state.
No, you're talking of Newark?
Nevada.
Sorry.
Nevada. I'm talking of Nevada. The state of Nevada. Yes, my lord. Not Delaware, Nevada. No, my lord. Nevada, it is very easy to get a divorce, I'm told.
Both,
so they go.
both marriage and divorce.
So, my lord, what they do is.
Incorporate a company.
Yes, correct.
That's what.
Delaware is easy to incorporate a company. That was what is in my mind, my lord. Because we have so many Delaware companies where I'm told, my lord, there are a series of boards there.
Delaware is, yes, that is company.
All companies are incorporated.
Our concept is only Nevada.
Nevada. I had that in my mind when I said Delaware. I made a mistake. I'm told, my lord, in Delaware, there are some boards put, series of boards. Board matra. No, my lord, in Nevada, I'm given to understand, my lord, that it is very easy to get a divorce because the law in that state, my lord, allows that. So, my lord, people from different state where it is difficult to get a divorce because of the law of that state, go, my lord, and take a hotel room and then show that as the address and then get a decree. When that type of a decree which was obtained in a Nevada court was put before the Honorable Supreme Court here saying that the marriage has been dissolved, Supreme Court said you are a bird of passage. Therefore, we will not recognize that decree. My lord, insofar as the respondent here is concerned, insofar as the Bangalore court is concerned, she is a bird of passage. And therefore, my lord, I want to show to your lordships the averments in the petition that has been filed, which is very material.
Vikram sir has read it out.
There are, if it is shown, my lord, I will not repeat
Paragraph
it.
I'll tell you.
I will show.
Yes.
Yes. My lord, would your lordship kindly turn to the complaint, my lord?
Yes, sir.
My lord, please see page 40.
Page?
40, my lord. Which is shown.
Yes, sir.
Complaints also.
Paragraph?
My lord, I'm told, my lord, that paragraph 3, 4, and 6 have already been shown to your lordships.
Yes.
Therefore, I'm not going to repeat it.
Yes.
I'm going to show to your lordships a few other paragraphs, which according to me, my lord, would be material. My lord, please see paragraph number 7. It is submitted that since 2019, there was a sea change in the attitude and behavior of the respondent. The respondent started to behave rudely with the petitioner and also used to quarrel with the petitioner for no reason. And there always existed a difference of opinion between petitioner and the respondent ever since the petitioner confronted the respondent on an illicit relationship with one by name so-and-so, who is a close friend of the petitioner herein. It is further submitted that petitioner since 2019, the relationship between petitioner and respondent has deteriorated on the fact that the respondent had involved in an illicit relationship with a friend of the petitioner, namely so-and-so. Then, my lord, I'm going to skip that. Then kindly come to paragraph number 9. That is very crucial. It is further submitted that in the year 2021,
yes,
the respondent had placed African American securities at the entrance of the Meadows house and installed CCTV cameras inside the house. It is further submitted that upon arrival of the Meadows house is in Dubai, my lord, and the allegation of violence, domestic violence is there.
Yes.
Is supposed to have happened in that place. It is further submitted that upon arrival of the petitioner from a business trip, the said African-American securities prevented her from entering into her own house, obstructing her entry in an intimidating manner. The said act of the henchman hired by the respondent made the petitioner fear for her life and limb and left a deep psychological scar in the mind of the petitioner. It is further submitted that the petitioner could not enter into her own house and was allowed to enter only once. It is further submitted that the respondent had kept the petitioner's daughter out of the country on the pretext of her job, and when both the petitioner and her daughter traveled together, respondent had taken over the house and placed CCTV cameras in every nook and corner, including the bedrooms and common areas of the house. The daughter, my lord, here referred to is the daughter of the respondent through some other relationship. She sees there's that.
Some other relation?
Yes. Yes, my lord. She doesn't say.
Not the daughter born from, from this wedlock. Not from this wedlock.
No. In fact, the divorce, my lord, that is granted is premised on the footing that the marriage did not, there was no offspring from this marriage. Because, my lord, the Dubai consulate, the Russian consulate in Dubai will get authority and jurisdiction only if from the marriage there are no children.
Oh, that's the
requirement of that law. That's what your lordship saw in that legal opinion given by the lawyer.
Yes.
No, madam, she is a daughter. In fact, she doesn't say which relationship also. She says from another relationship. Whatever, madam, I'm not going into all that. I'm not relevant. Not relevant. I'm not going.
Whether she says or not, you are aware. So leave it. Yes.
I'm not. Yes. In any event, madam, what is material? I wanted to point out that this is not a daughter born out of this marriage. That is all that is relevant for the purpose of this case. It is further submitted that the respondent had kept the petitioner's daughter out of the country on the pretext of her job, and when both the petitioner and the daughter traveled together, respondent had taken over the house and placed CCTV cameras in every nook and corner, including the bedrooms and common areas of the house. Additionally, placing 3 African-American security guards to the house. It is further submitted that the respondent had informed the petitioner's daughter to pack her belongings in Bangalore and to return all her work equipment such as laptops, namely 1 MacBook. It is further submitted that when the petitioner and daughter were allowed to enter into her house, petitioner was barely allowed to rest and was not even allowed to freshen up as her belongings were kept packed in boxes. It is further submitted that the petitioner and her daughter were not allowed to consume food and were kept under hard, dire and threatening conditions with 3 African-American security guards in the house round the clock.
Where?
All this is in Meadows. All this is in Meadows, my lord.
Yes.
That's why, my lord, I'm pointing out, assuming everything is true, I ask myself, how does it become a domestic violence for the purpose of the DV Act here? It is further submitted. It is that the petitioner was made to follow the directions and dictum issued by henchmen hired by the respondent. Petitioner, being a title holder of the house, was put under command of African-American security guards who dictated every move in the house and screened all the visitors for their IDs, which caused great embarrassment and caused the petitioner to suffer severe mental trauma. It is further submitted that there was an unidentified gentleman in the house on watch, assumingly from law enforcement, given the respondent's financial position and political influence in the vicinity.
Political influence?
Mana?
Political influence?
Anta avaru helodu.
In Dubai?
That's what they are saying. Yes. Yes, that's what they're saying. It is further submitted that 3 days subsequent to this event, petitioner was wrongfully confined in her own house, with every move and conversation being recorded and tracked by the respondent. And then, my lord, they say again, same thing, my lord, this African-American allegation is repeated. Your lordship may kindly turn to page 47. Line number 8. It is further submitted that the petitioner and her daughter at Meadows house spent sleepless nights by keeping their life on the hand with 3 unknown African-American henchmen deployed by the respondent. The petitioner and the daughter were locked inside the room and threatened by the henchmen to sign on certain blank sheets of paper, failing which they put the life of the petitioner and daughter under dire consequences. When the petitioner declined to sign the blank papers, petitioner and the daughter had to face unpleasantness, humiliation, torture, and life threat, which shows the respondent's arrogance and atrocity towards women through henchmen. It is further submitted that the petitioner and daughter were left behind in the Meadows house by the respondent after the respondent had taken petitioner's jewels from the aforementioned safe. It is further submitted that the petitioner had spent a full month under supervision of cameras installed by the respondent in house, and additionally with 3 African-American security guards on watch round the clock, the petitioner and daughter faced severe mental pressure and a gross invasion of their private space and privacy. It is further submitted that petitioner and the daughter reluctantly decide to move out to the Meadows house as they could not bear the gross invasion of privacy and, more importantly, the life threat posed by the intimidating African-American security guards. It is further submitted the petitioner was threatened with dire consequences if she were to file a police report in Dubai
Against
against the respondent. Respondent threatened the petitioner that if
the
you
complaint is registered in Dubai?
no, ಏನು ಮಾಡಿಲ್ಲ ಇವರು. I showed your lordship, he comes today to Bangalore, tomorrow institutes a petition for restitution of conjugal rights. Next day, files a petition under 125. Third day, files a DV case, goes off.
Back to Dubai.
Back to Dubai. This is what you have done. All this in 3 days is over now. But there's clear abuse of process of court. I mean, in fact, my lord,
No, we are only examining whether the petitioner for under the domestic section 12 of the Act
Yes.
is maintainable for the reliefs that they are.
maintainable is one issue. Second is it an abuse of process of court?
Only if it is abuse process of law, if I come to that conclusion, only then I can entertain this.
Yes. No, there are 2 ways. One is if on the basis of the allegations in the complaint, it does not constitute, the DV Act does not apply. That is one ground. Secondly, taking the totality of circumstances and reading in between the lines, which is what your lordships will do, my lord, when all these complaints are filed day in and day out. And today, my lord, I saw something on bar and bench also. In a matter, my lord, his lordship Justice Gawai is sitting with 2 of the, of course, it's an observation, not that he has said the act which is totally misused in this country is the DV Act. Of course, it's a statement that was made. I'm just not that it has any bearing on the judicial aspect of the case.
Yes.
Then, my lord, now, my lord, kindly see para 13. That's very important.
1-3.
1-3. Oh, I'm told it is shown to your lordships. If it is shown, I'm not going to waste your lordship's time.
Shown, read and reread.
Very well. I will skip that. But if it is shown, I'm not. Shown. Shown. Para 15, your lordship.
That I have seen.
Your lordship.
It is not shown. That's all right. Okay. Yes.
It is submitted that after the said confrontation with the respondent, petitioner has been ill-treated by arrogance and sadist character of the respondent, but petitioner has tolerated all cruelty meted out by respondent for the sake of maintaining cordial family relationship with the fond hope that the respondent will correct himself, but by taking advantage of the same, respondent has tortured, harassed, and humiliated in all aspects since 2019. Then, my lord, then they come to the aspect of how rich the respondent is. The whole object of this is to extract money. Because the rest of it, my lord, is what a wealthy man he is. Now he is going to give me so much of money. Therefore,
Alimony.
That's the prayer, my lord. Plus maintenance. Yes, 2 crores, no?
Compensation.
They ask for 2 crores maintenance.
2 crores monthly maintenance.
And then
500 crores compensation.
Crores, my lord, compensation under section 22.
We'll hear the response.
Yes. And there are a few authorities that I want to place.
Apart from what they...
My lord, my lord, I want to point out your lordships, my lord, on section 4. Kindly see, my lord, section 4 of the IPC as it then was. In where the law wanted to provide for extraterritorial operation, it specifically said so. Kindly see section 4.
You told me in the beginning.
Yeah, section 4, no?
Yes.
Of the IPC. Idu amel
argument first day
now, my lord, I'm substantiating with reference to the law.
Extension of the court.
Yes, to extraterritorial offences. Where the lawmakers intended that the law here should apply to acts which are committed outside the country, they specifically said so.
There's no IPC offense here.
Yes, such a provision is absent in DV Act, is what I'm pointing out. My lord, that is the contrast, my lord, that I want to point out, your lordships. In IPC, if I commit an offense outside, it's an offense under the IPC, a person can be tried here. But it is not so with respect to DV Act. Domestic violence committed outside does not attract the provisions of the DV Act within. That's the submission I'm making. Then, my lord, there are a few citations that I want to place for your lordship's consideration. Which are the ones we want to show? Which one?
No, he has read a few.
Yes, my lord. My lord, please see, my lord. There is one judgment that I want to point out to your lordships, my lord, in 1963 Supreme Court, page 1. That is the famous Vishwanathan case, my lord. It is found, my lord, in which citation?
Since you took me through bird of passage.
No. Bird of passage. No, Vishwanathan's case is on how Section 13 of the CPC has to be construed and how it is to be done. Not for the purpose of birds of passage. I have already shown.
Orders passed by foreign courts.
Foreign courts. And your lordships will not look at the order passed by a foreign court with reference to the law in India.
Obviously, yes.
Your lordships will look at the enforceability of a foreign judgment with respect to the law in that country.
Yes.
That is what Lord Vishwanathan case lays down. It is a very famous case, Lord, right from...
and the concept is rudimentary. Concept is rudimentary.
But it has received the attention of
yes.
Such...
yes.
It's a judgment, my lord, which your lordship may just see these paragraphs, my lord.
19 and 20.
Yes, no, my lord. 2021.
All right.
If I may just read that, my lord.
Yes, sir.
Undoubtedly, in fact, this is a case where, my lord, Mysore state was a foreign state compared to Bombay. In that context, the enforceability of a judgment of the Mysore court was called in question. Undoubtedly, my lord, para 19, my lord. Undoubtedly, a court of a foreign country has jurisdiction to deliver a judgment in rem, which may be enforced or recognized in an Indian court, provided the subject matter of the action is property, whether movable or removable within the foreign country. It is also well settled that the court of a foreign country has no jurisdiction to deliver a judgment capable of enforcement or recognition in another country in any proceeding, the subject matter of which is titled to immovable property outside the country. But there is no general rule of private international law that the court can in no event exercise jurisdiction in relation to persons, matters, and property outside jurisdiction. Express enactment of provisions like Section 20 CPC and Order 11 of the Supreme Court rules in England negative such assumption. The courts of a country generally impose a threefold restriction upon the exercise of their jurisdiction. Jurisdiction in rem by a court over res outside the jurisdiction will not be exercised because it will not be recognized by other courts. The courts will not deal directly or indirectly with titled immovable property outside the jurisdiction of the state from which it derives its authority. And 3, court will not assist in the enforcement within its jurisdiction of foreign penal or revenue laws. The suit filed by the plaintiff was possession of estates disposed of by the will of Ramalingam in para 3 of the plaintiff in Bangalore District Court suit. Then, that's on the facts. I'm not going
to. That's on the facts.
I'm not going.
That's why I said 1920.
Yes, kindly now see para 24. In an action in personam, the court has jurisdiction to make an order for delivery of movables where the party is submitted to the jurisdiction. This is important. A person who institutes a suit in a foreign court and claims a decree in personam cannot, after the judgment is pronounced against him, say that the court had no jurisdiction which he invoked and which the court exercised, for it is well recognized that the party who is present within or who has submitted it to jurisdiction cannot afterwards question it. This is the point. No, this is the case where both of them have gone and done it. And the order of divorce granted, my lord, records that it is a joint application. So, my lord, having regard to the law laid down in para 24 of this judgment, they cannot question it, having submitted themselves.
We'll hear the counsel.
Very well, if there's anything in reply, I'll point.
Anything. Because both of you have extensively heard when the matter was taken up on the first time. The first occasion.
And after my learned friend, if my learned friend is going to rely upon any of the subsequent pleadings, which has been filed in this case, post the petition that was filed before the DV court, I will point out, my lord, how they have purged themselves.
Got it.
Might
Yes,
I
madam.
request your lordship the Domestic Violence Act?
Huh?
Lordship, Section 3. Go to 3.3. Verbal and emotional, sorry. 3.3, verbal and emotional abuse includes insults, ridicule, humiliation, name calling, insults, ridicule, especially with regard to not having child, male child, whatever. Next, repeated threats, cause physical harm. Next is economic abuse, which is also something we've raised. Deprivation of all or any economic or financial resources to which the aggrieved person is entitled to under law. The other one is last C, prohibition or restriction to continued access to resources or facilities which the aggrieved person is entitled to use, enjoy by virtue of domestic relationship, including shared household. Now they try to say that she's staying in a hotel, and probably birds of, I'd rather say paradise. So instead of passage. Lordship, if she's not allowed into her home, and they might find it amusing that we are trying to say that she's under constant threat. But a person who is worth 20,000 crores, as I mentioned to your lordships, that even the zeros that we cannot count, they're extremely powerful in Dubai. Even after her giving her initial complaint, and which proof of which by way of a WhatsApp message, of a message that she received on her phone, which is produced before your lordship. She was told very clearly after that, since there are several cases pending in Bangalore in India, why don't you address it there? After that, they will unwilling to take it up. Your lordship, in fact, I have noticed that even the metro stations there are named after top Indian builders. They have sufficient and tremendous power over there. With respect to her in her, the Dubai consulate, there are several occasions when they have gone to the Dubai consulate with respect to issues on passport, several issues, they have gone there. She has also gone there. Now she's unaware of this. Now what they're trying to take is bring out a certain message between the two there where she says, yes, I might not be your wife. Reason being, he has told her that there's a provision and I have used that and I've gone and got myself a divorce is what he says. So I'm led to believe that there is one. But later, which I have taken your lordship through those messages, it says, give me a divorce, come to India and sign it, and then I will give you the Dubai house. That is when she realizes that that was a fabricated document or a lie or whatever she was led to believe. And now he's pushing her to give her the divorce in Dubai. The dates are critical here. What they're trying to say is that my DV is an afterthought. In fact, it's quite the contrary. I've sent 2 legal notices before any of this transpired. One in November 2023, asking him to refrain from all his threats and asking him to even provide some kind of assistance in monetarily. Second, the moment that notice came, he doesn't reply. Instead, he calls and says, both your daughter and you will find yourself dead. Better agree to what I have stated. Second notice then comes in. After the second notice comes, now the MC petition, your lordship, is served upon me on 23/20/24. That is in the record in the family court. On 20th, I'm served. The DV that I filed was on 7/3. So I have filed the DV.
After the filing of the DV petition, this is filed.
No, this was filed probably earlier, but I have received notice of it on 20th, whereas my DV was filed on 7th. But my legal notices were in the previous year in November, during which time they proceeded to file the MC petition, your lordship. So it's quite the contrary. Your lordship, might I also request your lordship to kindly see page 63 of the writ petition, your lordship.
Yes.
This is what they've referred to stating. After the wedding in Russia in 2011, they straight away came here and registered under the Special Marriage Act. Kindly see the photograph. That itself reveals that there was a Hindu marriage.
Oh, and because he's wearing that. Okay.
And if it is a reception, they don't, Your Lordship. There's a difference in North Indian weddings. During the Bharat and the wedding is when they wear the peta and where the lady wears her head gear. That is not there during a reception. So as Your Lordship normally says, self-goal in certain matters, this is one of them. So there was a wedding. Subsequent to it, this was registered, and a wedding in Embassy School. Practically who's who of Bangalore were there. A very grand one to say.
2011.
2014.
What is 11?
11 is in Russia, it was registered. Your Lordship, from 2008, both of them have been
So
together.
2014, you get married here according to
In India. And it is under the
where
special.
is the certificate of registration of that marriage?
That marriage, they have produced here.
2014.
2014.
Ah,
Oh, there's no.
that is what I'm asking. No. The senior counsel said 2014 you get married here. You don't register that marriage here.
After the Indian wedding, this is the marriage registration.
Indian wedding happens when?
A few days before this, Your Lordship. This is 16th. This is registered on 24th of
Oh,
May
this is
2014.
2014 itself. Correct.
Please.
You're right.
And they have a marriage about 16th.
All right.
16th of May.
The certificate
April,
is 2014 only.
Please,
Yes.
please.
This is of a marriage already solemnized.
That's all right.
And therefore, to state that that was the only wedding is untrue. This is the wedding that has taken place. Your Lordship may also kindly see page 72.
Yes.
Your Lordship, before that, page 63. Kindly see the witnesses. The hue and cry created last time, that I will come to.
Why witnesses what?
Necessary.
It is not unnecessary because this would be the entire crux of the matter, because we have to show that this mutual consent that they claim that was filed in India was not, Your Lordship. Kindly go to page 72.
No, why did you say about the witnesses?
Your Lordship, that would have a bearing on who filed this mutual consent case, even without her presence, Your Lordship.
But if that is being
Page
my lord, I think
70.
it's a serious issue, my lord.
Page
Because
7.
if my learned friend is relying upon those paragraphs that I showed to your lordships about allegations made against counsel,
They started
then my
it.
lord, it's a serious issue.
They started it. I
I
will
will
respond.
be
If they
clear
don't
about
want
that,
to
my
go
lord.
into
I
it,
mean,
I will also stop.
Yes.
I will not go further if they don't want to push it further.
No,
But if
where have they gone against the council?
No, they have not. All that they stated in their paragraphs is that that entire MC petition was concocted. It was filed when she was not there and later conveniently withdrawn. And Your Lordship, I'll take Your Lordship to page 72. Your Lordship may kindly see. This is the MC petition in 2020. 17/6/2020, Your Lordship.
Yes.
Now, if Your Lordship turns to the next page, the verifying affidavit. 3/3/2020. 3/3/2020, she files her verifying affidavit, notarized before a notary, but it is filed on 17/6/2020, 3 months later. Reason being, 3/3 is the date given and this whole thing is registered and notarized in view of the fact that they calculate when she was in the country and therefore this date is put. But when it was filed, it was actually 17/6.
3/3?
3/3 and 17/6. 3 months later, normally a verifying affidavit.
From 24/3, for 3 months, courts were closed. COVID.
True, that is what I'm coming to. So 2020, now they say, in view of the COVID period, we could not proceed with it. And
They've
she,
said so, is it?
Your Lordship may go to their petition. Well, I will.
All right, yes.
So what they claim now is that we filed an MC petition, but it was upon her insistence. He claims that it's respondent who insisted, let's go to the embassy in Dubai and let us register it there. And then they say there was an application filed here in this MC petition, mutual consent, asking to be advanced. Then they say they did not pursue it in view of COVID. And then they say later on, it was dismissed for non-prosecution 2 years later. Now, if they say that it was upon her insistence that the embassy was filed, she would have come and completed this.
So the crux of his submission is the divorce has not happened in accordance with law.
Absolutely.
So
And your
the DV petition is maintainable.
DV is maintainable. Now, for a minute, let's assume that they say that there was some such the marriage which I have to dispute. Whether the courts have clearly held that whether there's a subsisting marriage or even after a divorce, if a lady is still troubled by her husband, she is still entitled to. So as a worst case scenario also, I would still be entitled to maintain the domestic violence petition. Here is a matter where now they have read only paragraphs where it says that there was torture only in Dubai, nothing in India. She very clearly states that she caught him red-handed. This whole issue is only because of his infidelity, nothing else. And your lordship, if they seem to portray this lady in one of those typical stereotypes of a Russian woman, stating that she is after his money. No, she has filed a restitution. If there is a restitution, where is the question of any of this amount to your lordship? If he consents to that. I have not asked for any of that. We have filed the restitution. Now they claim that the restitution also was an afterthought. No, she filed her domestic violence. She's just asked him to refrain. But going by all the documents, it just seems to be a very toxic marriage, which is on and off. They seem to have a very good time. They seem to have a very bad face. In my sir, your lordship may kindly take.
Sir, rebuttal.
Please, your lordship.
Sir, rebuttal.
Please.
No.
I'll go to the
Photograph.
judgments later, your lordship. This is,
Judgments idea.
I have extracted portions of it in the sir, but I will hand it over separately, your lordship. Your lordship, contrary to their claims that I never came to India later, and their stated, each of those paragraphs have been addressed with proof. Page 37 onwards are all the seals and stamps every time she entered India. Your lordship, next is at page 44 onwards, your lordship.
Photographs.
Your lordship, this is on his birthday on 18/2/2023. 18/2/2023. The next one is, this is when they arrived back from Maldives, your lordship. Earlier in our memo of documents, I had showed that this is after her return. Now they claim that the flight details that have produced is incorrect. She did not land in Bangalore. She landed in Delhi. And this, your lordship, is arrival in Bangalore from Delhi on 25th June. And these are the photographs where their friend had a baby. And both of them have gone there to congratulate them at page 45. Both of them are husband and wife with a small baby there.
All right.
Next is page 46. 28 June 2023. Attended a family gathering. This is with the family, your lordship, all of them together at Ganganagar on 28th June, your lordship, 2023. Have you written this? You're not written?
Yes.
If your lordship permits later, I will just ask him to write down the dates to the side, your lordship, just to
No,
assist.
you just give a synopsis of
Please,
dates
I
and
shall do
events.
that. I shall do that. Below that at page 46 is on 10/12/2022. This was again in Four Seasons, Bangalore. Next one at 47 is Maldives at June 2023 together. From this, after this is when they arrived in Delhi. The next one, your lordship, is 10th of February 2023, your lordship, last year. This is 48. 49, your lordship, may kindly see.
I'm at 49.
This is at Dubai, they have a holiday. Now trying to say that she separated, she went and she lived separately in Dubai and claiming desertion. Your lordship, page 51.
WhatsApp messages.
This is what now they have selectively given.
The whole thing you have produced.
We have produced this,
Yes.
and your lordship may kindly see. Beating me, asking me for a divorce at page 53. And when we're going to consulate, I knew it's not their responsibility. That's why I went. You paid the guys to get it done. She states it very clearly. And she knows later on, by way of the memo of documents that I've produced, which are subsequent to this, where he tells her, give me a divorce. Now, Your Lordship, that memo of documents to show the domestic violence, Your Lordship, that should be sufficient to establish prima facie. As we say, Your Lordship, they have taken us extensively towards whether there was a marriage, whether there was no marriage. And with respect to the child, I shall just clarify, in 2011, when they were dating from 2008 to 2011, he says, she is my daughter. And so he voluntarily goes there and puts his name in her birth certificate stating that she is my daughter. And now to say that that just goes into the root of what a person could be, irrespective of their strained relationships between a man and a woman, if he has taken her as his daughter from then, now to say the daughter of some man, that just goes to show what kind of a person. Your Lordship, might kindly see the memo of documents, Your Lordship.
No, we should be on
Just on the technicality.
entertainability of the
Absolutely.
DV Act before
Please,
the concerned court.
please. Page 32 of the list of documents, Your Lordship.
30?
Page 32.
The WhatsApp message. WhatsApp messages.
Please, Your Lordship. Hope you're okay to take the house and change your mind and Natalie passport and sign the divorce papers in India. This is what he has asked her.
All right.
Page 28. This is the most repulsive act of a person to state.
Page 28.
28. You might celebrate your birthday in Bangalore. I'm going to drag this till you become old, and Natalie, this is the daughter, will never have money to enjoy her youth unless she finds a rich man like you did. For that, you know what she has to do.
That's all right. No.
And then she berates him, stating, how can you call the daughter now?
Entertainability, but
Maintainability, Your Lordship. At continuously what she tells him is, you have left me with no money. Your Lordship may kindly
the
go to...
contention is both of you are separated in terms of the Russian law. The contention.
Contention.
Contention is that you separated in terms of Russian law. The marriage also had taken place in terms of Russian law, and later on they registered here or whatever it is. And all the incidents that are now being narrated have all happened in Dubai, is what is said.
I shall
No,
produce where,
that
please.
is all said.
Please.
Now that is why we'll just concentrate on the entertainability of the petition before the DB court. Not going what is he, how
Page
is he,
42.
how much money he has.
Page 42.
That's all.
You did raise your hands in me, and if you don't remember, you put a gun on my head. Now I've read the provisions.
Where did this happen?
Your Lordship,
Dubai?
One of it, the raise hands is here, and Dubai putting a gun on her head is Dubai.
Okay.
Your Lordship, all of this is sufficient to, one, show mental cruelty, physical cruelty. Thirdly, economically draining her out, completely stating you will not have a penny. Your Lordship, at page 5 of that very document, Embassy Group's hospitality businesses received a boost with Jitu Varwane's children, Natalie, which I've shown.
Told me.
Yes. So therefore, she took over the reins of the business. Certain businesses were handled by her. The respondent herein, that is the wife, has signed several documents where she is one of the, any of the board members, the directors, whatever. He threatens that in Dubai, he's going to have one of those cases wherein there is some kind of a fraud in the company. So she very cleverly says, which means you'll have to bring your sister down too, because the sister is also part of it. And that's where he's trapped. He's not able to do it. Your Lordship, as I had also mentioned, that's of course a matter of another trial wherein a fake, false case was filed as against her with respect to drug peddling or whatever. The moment this petition, after it came before Your Lordship, that Your Lordship had stated that she will cooperate with the investigation, that matter. This,
Oh, yeah, oh, you told me this, yes.
please.
Mm.
And this was all done the moment
That's the
this,
contention.
that is my, just the way they have several other contentions. This is my contention. The only difference is there's factually correct over here. Your Lordship, might I?
Confidence. Yes.
Your Lordship, the rejoinder and the response, Your Lordship, also with respect to the Dubai divorce, all of that, Your Lordship, I might mark the pages and give so that I don't take your Lordship further in this.
No, no more further.
No further, Your Lordship. I'm closing. I'm
yes.
closing it. Your Lordship, with respect to the Sir, Your Lordship, I'll just take out only those judgments. I will only hand it over. I'll just read
Yes.
those. Sir, really?
And I will go through everything and then pass orders.
Pass it.
No rebuttal. It's 5 o'clock. Already spent 90 minutes on this. And
Devana,
see the
Veluswamy-
council's waiting still.
ಆ ವೇಲುಸ್ವಾಮಿ ಜಡ್ಜ್ಮೆಂಟ್ ಒಂದು ನೋಡ್ಬಿಡಿ ಅಷ್ಟೇ.
ಯಾವ ವೇಲುಸ್ವಾಮಿ? ಆಯ್ತು ಆಮೇಲೆ ಮೇಡಮ್ ಮುಗಿಸ್ಲಿ.
I've noticed, Your Lordship, in every matter, I'll get less than 1/10 of the time. And yet I will not grumble.
Okay, you want me to take it tomorrow? I'll
No,
take it.
no, not
Yes.
at all. I'll wrap it
No
up, Your
problem.
Lordship. Your Lordship, at page
No,
9.
we'll take it tomorrow, madam. You continue tomorrow.
Either I'll wrap it up, Your Lordship. I'll just read
No,
out
no,
those
you can
judgments.
wrap it up tomorrow. After the wrapping up of the other case happens, you can wrap it up.
Oh, oh, yes.
Don't go back saying that
No,
you
no,
get
no.
only 1/10 of the
No,
time.
no, I'm trying to say because despite that, again, they would want to point something out. I'm not complaining. I'll just read these out and I'll hand it over, Your Lordship.
I think
shall
10 minutes.
with no complaints.
10 minutes is enough for you
Your Lordship, absolutely. Your Lordship, page 9.
to destroy the lull period. Yes.
Or run a 100-meter sprint.
Right. Yes.
Jackie Joyner Kersey.
Yes.
Your Lordship, page 9.
ನಾವೆಲ್ಲ ಟೆಸ್ಟ್ ಮ್ಯಾಚ್ ಅವರು T20.
That's because they have a Rahul Dravid there.
Wall.
The wall. Your Lordship, Sumit versus Himani Sumit.
Page 51.
Mr. Raghavan would be Gavaskar. Sumit versus Himani, Your Lordship. The domestic violence took place in Germany. I've just extracted those portions just to state that even if they say most of it took place in Dubai, this is just to bring the word. The wife filed a complaint here in Nagpur. And what the court says is she carried the trauma. That is the key words over here. So this is that judgment. According to her, mental stress and
But
trauma
there the
carried.
relationship was still subsisting.
It still subsisted. I have shown with photographs that
No, no,
it still subsisted.
In this case,
In this case, which I'm also saying in our case, it still subsists.
all right.
It seems to be a very toxic relationship. Beyond that, I don't think there's more.
No, that is why domestic violence emerges.
That is why emergence. But if all of those toxic, all of those what he messages is all withdrawn, I think it's more a question of the male ego. Once somebody with 20,000 crores, you follow what I say. Otherwise, you will face the consequences. That's all it is, Your Lordship. It's more, nothing more than
All
that.
right.
Your
No,
Lordship, paragraph.
We are on
14.
entertainability.
Your Lordship, page 14. Para 14.
Expenses. Is that you are on entertainability, not entertainment.
That Mr. Raghavan's provided enough. Page 14, paragraph 14. In my view, by drawing the analogy from these observations, it has to be held that apart from the express provision of 27, consequence of trauma, suffering, and distress carried by the complainant to her paternal home would be sufficient to reject the submissions advanced. Next is Mohammed Zubair Faruqi, Your Lordship. This is with respect to shift to India to file the DV. That is from US, shifted to India, she filed the DV, that
Yes.
entire matter.
Yes.
I will not read the rest, Your Lordship. In page 11, a continuation of that with respect to Krishna Bhattacharya. This is 2 years later after she came down, she filed it and it was still maintainable. Next one is, Your Lordship, further down, that is Rajasthan High Court's Robato. In that, Your Lordship, a foreign citizen can file a DV. Just in case they try to say, though she has an Aadhaar, passport, all of that, they're now trying to bring in that, that's also covered, Your Lordship. I shall file a detailed synopsis of all of that and please,
You can file written submissions also if
please,
you want.
please.
You watched.
ಅದು ವೇಲುಸ್ವಾಮಿ ಒಂದು ತೋರಿಸ್ಬಿಡಿ.
Vel Sami, which is that?
ಇಲ್ಲ ಇಲ್ಲಿ
ಹಾ ಕೊಡಿ
ಸರ್ ಕೋರ್ಟ್ ಆಫ್ ಸರ್
ಈಗ ಕೊಡ್ತಾ ಇದ್ದೀರಾ? ಅಲ್ಲಲ್ಲ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ ಕಾಪಿ? ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ ಇದೆಯಾ citation number 3 yeah first no it's in page number 1 2010 10 SCC 469 idralli if your lordship will kindly see my lord this kindly see my lord para 31 in our opinion a relationship in the nature of marriage is akin to a common law marriage. Common law marriages require that although not being formally married, a couple must hold themselves out, because all this was said after divorce, they went to so many places, etc., etc.
Yes.
The couple must hold themselves out to society as being akin to spouses. In fact, on the contrary, the petitioner is saying we are divorced, we are not husband and wife. This is how he has been holding out to everybody. That's her complaint. And then they must be legal age to marry. They must be otherwise qualified to enter into a legal marriage, including being unmarried. They must have voluntarily cohabited and held themselves out to the world as being akin to spouses for a significant period of time. That is, after the divorce, after the legal relationship came to an end, they must do this if they want to contend that it is a relationship in the nature of marriage. It should be a common law marriage. And what is a common law marriage has been discussed. And here, my lord, the allegation is contrary. You have been going around everywhere saying that we are not husband and wife. What kind of a husband are you? And that has caused me a lot of trauma. Is the allegation of the petitioner.
Drama?
Yes, drama, not trauma.
Trauma.
According to us, all that we do is drama.
Yes.
And then, my lord, last one sentence, in our opinion, a relationship in the nature of marriage under 2005 Act must also fulfill the above requirements, and in addition, the parties must have lived together in a shared household as defined in Section 2S of the Act. Mere spending weekends together or one night stand would not make it a domestic relationship.
Yes.
This, my lord, I think conclusively. And if there's anything more, my lord, can we have permission to file written submissions and then give
All permission grant.
Your lordships are in. Thank great.
ಏನು ಹೇಳಿದ್ರಲ್ಲ ಆ ಕೇಸ್ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕಾರೆ ದಿ ಓನ್ಲಿ ಥಿಂಗ್ ವಿ ವೋಂಟ್ ಕಮ್ ಟು ನೋ ಇಸ್ ವಾಟ್ ಯು ವಿಲ್ ರೈಟ್ ಅಷ್ಟೇ. ಸೊ ಏನ್ ಬೇಕಾದ್ರೆ
ಹೇಳಿದಾಗ ಎಸ್
ಏನ್ ಬೇಕಾದ್ರೆ ಕೊಡಿ,
ಏನ್ ಬೇಕಾದ್ರೂ ಕೊಡಿ. ಕರೆಕ್ಟ್. ಎಸ್
ಎಸ್
ಗ್ರೇಟ್ಫುಲ್. ಗ್ರೇಟ್.
ಎಸ್ ಮೇಡಮ್ 1/10 to or half.
I'll make it up with written submissions.
Yes.
Obliged.
10 minutes ಸಾಕು.
Yes. But there is other matter, my lord, where the state was supposed to.
Sir.
In the other matter, my lord, the state is supposed to have given your lordship's inquiry.
Which other
report.
matter?
Past over matter.
Scene number 23. ಇಲ್ಲ ಇದಲ್ಲ ಮುಗಿದ.
All of you please don't get up. I am not getting up. Be patient till I get up. Yes.
Interim order question.
At will. Yes.
Serial number 23 matter. Senior counsel.
No, the 230 mode matter ಇರಬೇಕು.
Oh, I see. We'll wait.
Yes. ಏನು ಮೂಡ್ ಮ್ಯಾಟ್ರ? ಸತ್ಯನಾರಾಯಣ್, ಓಯ್ ನಿಮ್ದೆ ಸೆಟಲ್ಮೆಂಟಾ? ಎಲ್ಲಿದೆ?
ಸೆಟ್ಲ್ ಆಗಿದೆ, ಬಂದಿದ್ದಾರೆ ಪಾರ್ಟೀಸ್.
ಬಂದಿಲ್ವಾ?
ಬಂದಿದ್ದಾರೆ.
ಆಲ್ ರೈಟ್,
ವೇಟಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್
ಕೊಡಿ.
ಸೈನ್ ಆಗಿರೋದು ಕಾಪಿ ಸಿಕ್ಕಿಲ್ಲ, ಅಗ್ರಿಮೆಂಟ್ ಹಾಕಿದ್ದೀನಿ. ಪಾರ್ಟೀಸ್ ಆರ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್.
ಮೀಡಿಯೇಷನ್ ಆಗಿದೆಯಲ್ಲ?
ಆಗಿದೆ
498 ಏನಾ? ವಾಟ್ಸ್ ದಿ ಒಫೆನ್ಸ್?
ಮೈ ಲಾರ್ಡ್,
ಒಫೆನ್ಸ್ ಏನು?
498 A. My learned friend is appearing for the girl.
ಸೆಟಲ್ಡ್ ಅಲ್ಲ?
Settle ಆಗಿದೆ.
ಆಯ್ತು. Parties are before the mediation in MC 2042 of 23. Yes, you
Please.
can go.
Parties are before the court.
Sign madogu.
Obliged.
Next.
Till number 2, Kiran Krishna Swami.
Office objections. Eva.
12073.
No, 13578. Krishna Swami. 5 o'clock ಆಗೋಗಿದೆ. ಇದೆಯಾ copy? This we will not permit. Road rage and troubling the drivers. Glass ಹೊಡೆದು ಸ್ಕೂಟರ್ ಮುಂದೆ ನಿಲ್ಲಿಸಿ ಗಲಾಟೆ ಮಾಡಿ. Anyway, he is not there. List the matter on Tuesday in the fresh matters list. Yes, next.
Number 3, M. Sharashchandra, withdrawal.
In terms of. Yes, Lena Abraham. Lena Abraham is here. Yes, madam.
My lord, there are two matters. One is a domestic violence case which is pending with the Metropolitan Magistrate Court.
What have you challenged in this now?
The thing is that I'm filing also a memo.
Dispose the matter. You want disposal of the matter?
No, I am the petitioner in this matter. I'm filing a memo also.
Memo for what, madam?
Memo in
What is-
Kerala court, he came for a settlement and there were terms written that he will withdraw so and so cases in Bangalore and he will file for a joint divorce petition in Kerala. But against that settlement and the judgment order passed on the petition, which was actually filed by me for the divorce.
Now, what do you want?
Now he is running two cases in Bangalore. One is divorce petition MC 209.
All right. What have you challenged here?
I am seeking for a speedy disposal. My prayer is
Speedy disposal.
yes,
That's all?
and also stay in two petitions filed by him. One is
Want speedy disposal or stay?
both.
Both you can't ask.
Okay, then I'll go with the stay, my lord.
We'll go with the stay.
Yes,
Have you appeared before the committee?
yes, my lord.
All right. Where have you sought this stay?
I have filed, my lord. Actually, I have filed 6 IAs. They have, then I have not pressed all the remaining 5 IAs. Only 1 IA is pending now. Stay for MC 209 and OS 2892 but 2022.
MC, I can't stay here.
Okay.
OS also, I can't stay here. Domestic, which is a domestic violence case. That is filed by you.
Yes, sir. Domestic.
How can you ask stay of your own case?
No. Domestic violence case, I am not asking for
In
stay.
MC and OS, I can't stay here. You should go to the GM court. GMFC.
Okay.
Hmm?
Okay.
This petition should not be presented here. I think you should go to the other court.
My lord, then can I only ask then the direction in the domestic violence matters? Because in Kerala court, I have fought 2
Domestic
years.
violence matter, if you want speedy disposal, I will direct.
Okay.
Not a problem. But if you want OS and the MC petition to be disposed, that not this court does not have jurisdiction.
Okay.
That is why maintainability is the office objection.
There are 2 cases, only 1 case.
Now, madam, your
Okay.
prayer is within 3 months to dispose PCR 5234
Yes.
in FIR 238 of 24.
Yes.
That investigation is not yet complete. You are the complainant.
Yes.
How are you asking disposal of that? Should they not investigate against your husband?
Yes, my lord, but they are taking a long time. And there
No,
were,
it is registered in 2024.
yes, after the disposal of the Kerala court case.
Oh, madam, the best thing you would do is go before the other court, seek
Okay.
expeditious disposal of all your cases. That
Okay.
court will grant.
Okay, my lord.
Here I don't have, this I will grant, but this is your own case.
Yes, I need
Same
speedy
stage.
disposal in that because there are 5 IAs are pending, my lord, in that.
That's all right. Now, I will take this day after tomorrow. Let him see what investigation has happened in this case. Then we will direct disposal. You are coming from Kerala or you are here?
I am staying here, but in OS 2892 case, they are trying to get an injection,
No, that,
I have
that before the
minor
other-
child also.
that before the other court, not before this court.
Okay.
This
And,
only, you take note, you serve a copy. Or you take a copy. Additional SPP is directed to accept notice. List day after tomorrow in the fresh matters list. Nodi investigation ಯಾವ stage ಅಲ್ಲಿ ಇದೆ, get the papers. You just show him the papers, madam.
Okay,
Yes.
my lord, the second case, CMS 99/2024, in thus kindly direct the court for the speedy disposal, my lord. In the same prayer only.
He
Prayer,
missed ಯಾವ್ದು madam? That is domestic violence.
domestic violence case. Because I have filed 5 IA in that, interim maintenance I have asked, interim protection
Then
order I have.
no order is passed.
No orders have been passed, my lord.
The petitioner appears in person, seeks the following prayer. The petitioner in person would restrict her prayer for a direction to the concerned court to dispose the applications for maintenance, shared household and other applications so filed under the provisions of the Domestic Violence Act. The submission is that the concerned court has not considered the applications despite the complaint filed under Section 12 of the Domestic Violence Act in the year 2023. The prayer is innocuous. The need for maintenance is what is projected by the petitioner. Therefore, the concerned court shall answer all the applications that are filed along with the complaint under Section 12 of the Domestic Violence Act expeditiously at any rate within 4 weeks, 4 weeks from the date of receipt of the copy of this order, if not earlier. Yes.
My lord, one more matter I have
One
filed.
more,
Yes, sir. Criminal petition 9091 of 2024.
It's not listed, madam.
It is listed.
There are 2 petitions listed of yours. One is 8560.
Yes.
That I have asked day after tomorrow.
Okay.
Government party ಮಾಡಿಲ್ವಾ? ಆದ್ರೂ ಅದ್ ನೋಡಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಏನಾಗಿದೆ. Yes. Our party in person ಗೊತ್ತಾಗಿರಲ್ಲ. 5 is 9091.
90.
That I have disposed. I have directed the court to consider your applications within 4 weeks.
Okay. The domestic violence case, my
Yes,
lord.
domestic violence
Okay,
case.
this is the criminal miscellaneous petition pending in family court
Family.
for under section 125 of CRPC for interim
125.
maintenance.
All right, that you will concern court, I have said, same order.
Same order I can produce before the concerned court.
Produce it.
Because 1 year this is pending.
Produce it, madam. No problem.
Okay.
ಅದು ಡೊಮೆಸ್ಟಿಕ್ ವೈಲೆನ್ಸ್ ಎಲ್ಲ ತೆಗೆದ್ಬಿಟ್ಟು 125 ಅಂತ ಹಾಕ್ಬಿಡಿ. Yes.
ಅಲ್ಲ ಎರಡಿನಲ್ಲಿನೂ ಬೇಕು, my lord. For because 2 courts I am running my.
One domestic, your prayer is with regard to domestic violence court or what?
Yeah, under
criminal
criminal
miscellaneous.
petition 8560.
It is criminal miscellaneous, madam.
Okay.
So I have directed under 125 to conclude the proceedings.
In 9091 kindly pass order, my lord. I
I
mean,
have already passed order, madam.
for the speedy disposal also and interim maintenance, I have filed an IA in this.
I have said to consider all the applications.
And 2 courts I can show the same petition.
No, you can't. One order you can't show in 2 courts.
Okay.
Only in 9091, which is that is before 125 proceeding, you can show that. All right.
My lord, humbly, my apologies, kindly consider to show in a domestic violence case also. One more order, my lord.
That prayer is not there.
Yes, my lord.
That is not there. I can't go beyond the prayer.
Yes, 2 petitions I have filed in 2 different prayers are there, my lord. In 9091, there is a
We'll
different
see.
prayer.
Well, if that is not there, I will post it again on Friday. We'll see. All right. Yes. Now all councils are held up.
Number 6.
Friday. Yes.
Lord, I have preferred a 311 application before the trial court, my lord, and that has
ಏನ್
been.
311 urgency?
311, my lord, he's maybe posting it for the orders, my lord, final orders. Arguments is, it is listed. for-
Petitioner to serve on the council who
Served, my
represents.
lord, already.
ಯಾರಿಗೆ?
Served, my lord.
ಎಲ್ಲಿದೆ?
Sir. Morning I have.
ಇಲ್ಲಿ ಕಾಪಿ ಕೊಡ್ಬೇಕು ಅಂತ ಗೊತ್ತಲ್ಲ.
Yeah, he served, my lord. Copies.
Next date ಏನು?
17th is there, my lord.
Yes, look into it.
Ma-
List on, learned additional SPP is directed to accept notice for the respondent.
My lord.
List on 17th in the fresh matters list. The concerned court shall defer its proceedings till further orders at the hands of this court.
Much.
Next. Office objections comply ಮಾಡಿ. To be complied in ಮಾಡಿ. 7 withdrawal, 8 withdrawal, 9 ಇದು cover, Ajay Govindraj. Covered, yes. Next.
Further hearing for settlement. Bill number 10.
Rudrappa. Settlement.
Both are present for the sum
Huh?
of settlement.
Petitioner is present.
Offense.
Point number 2.
Offense for
376.
376, so
417, 420.
promise of marriage.
Promise of marriage.
Come on merits. I will not settle 376. Merits ಮೇಲೆ argue ಮಾಡಿ. ಈಗಲ್ಲ, ಈಗ ಶುರು ಮಾಡಬೇಡಿ ಆಮೇಲೆ. We'll post it on Wednesday, fresh matters, we'll finish it.
Tomorrow.
Tomorrow? ಯಾಕೆ?
21st.
ಅವ್ರೇನ್ ಬೇಕಾಗಿಲ್ಲ ಸರ್.
21st ಡೇಟ್ ಇದೆ ಸ್ವಾಮಿ. ಡೇಟ್ ಇದೆ ನಾವು ಸೆಟಲ್ಮೆಂಟ್ ಗೆ ಅಂತ.
21st ಡೇಟ್ ಇದೆ. ನಾನು 21st ಡೇಟ್ ಇದೆಯಲ್ಲ ಬಿಡಿ. ಸೆಟಲ್ಮೆಂಟ್ ನಾನು ಮಾಡಲ್ಲ. 376 ಡೋಂಟ್ ಆಸ್ಕ್ ಫಾರ್ ಸೆಟಲ್ಮೆಂಟ್.
Second on.
ಏನು?
May kindly be taken on record.
No, sir, I will not settle the issue. 376, I will not settle. You come on merits, promise to marry, we will answer.
Not the allegation that my lord the relation my lord for from 2 years.
ಹೌದು sir, I will not settle the issue in a 376 case. Try to understand. Come on merits, we will answer.
Wait a minute.
ಏನ್ ಅರ್ಜೆನ್ಸಿ?
Agency ಇವರು
ಕಸ್ಟಡಿಲಿ ಇದಾರ ಯಾರು?
ಕಸ್ಟಡಿಯಲ್ಲಿ ಇಲ್ಲ.
ಮತ್ತೆ?
Bail ಆಗಿಲ್ಲ, ವಾರೆಂಟ್ ಆಗಿದೆ.
ವಾರೆಂಟ್ ಆಗಿದೆ.
ಯಾಕೆ ಹೋಗಿಲ್ಲ ಕೋರ್ಟಿಗೆ?
ಮೊದಲಿಂದನೂ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದರೆ ವಿತೌಟ್
List on, the matter was directed to be listed on 21st. The petition, the counsel for the petitioner has moved the matter owing to a warrant hanging on his head. The issue relates to breach of promise of marriage and the offense, the subject offenses have sprung. Therefore, list the matter on 21st as directed earlier. Warrant of any kind hanging on the head of the petitioner shall remain stayed. Yes, next.
11.
Release from status of being part heard, post the matter before the bench having roster. Next. Interim order, if any, shall continue till the matter is listed before the appropriate roster, the bench having a. Next. ಮುಗಿತಷ್ಟನಾ? Yes. Fast ಯಾಕಾಗಿರೋದು?
Records.
ಯಾವ್ದು ರೆಕಾರ್ಡ್?
Records ಮೇಲೆ
ಯಾವ್ದು?
Bill number 23 man.
ಪಾಸ್ವರ್ಡ್ ಕರಿ. 23.
Yes, but.
Passport 17.
17. ಎಲ್ಲಿ ಅವರು?
17.
ಅವ್ರು ಇರೋ ಟೈಮಲ್ಲೇ ಪಾಸ್ವರ್ಡ್ ಕೇಳ್ತಾರೆ, ಇವಾಗ ಇರ್ತಾರ? Yes, list
Day after Milos.
on Tuesday, on Wednesday in the fresh matters list as a last chance. ಮಾಡಿ. ಇಲ್ಲ ಸರ್. ಯಾವತ್ತಿದೆ ನೆಕ್ಸ್ಟ್? ನಾಳೆ ಕೊಡ್ತೀನಿ. ನಾಳೆ ಕೊಡ್ತೀನಿ. ಎಸ್, ಇಷ್ಟೊತ್ತಲ್ಲಿ ಆರ್ಡರ್ ತಗೊಂಡಿದ್ದೆ ತಪ್ಪು ಆಗಲ್ಲ. ಓವರ್ ಆಗಿ ಕೇಳ್ತೀರಾ? ನೋ ಸರ್. ದೆನ್ ಏನ್ ಎಂಟ್ರಿ ಮಾಡಿ ಪ್ರಿಂಟ್ ಮಾಡಬೇಡಿ. ಲಿಸ್ಟ್ ಆನ್ 21st. ಲಿಮಿಟ್ ಇರ್ಬೇಕೆಲ್ಲ. 5:15 ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಬಿಟ್ಟು ಎಂಟ್ರಿ ಮಾಡ್ರು ಅಲ್ಲ, ವಾರೆಂಟ್. ಏನೀಗ ಅರೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರಾ? Yes.
23.
Milord, 17 interim order may be extended.
That will be extended.
That's okay.
Although list on 18th as a last chance, awaiting the submissions of the counsel for the respondent.
Much okay.
Much obliged. 23 will take it again on.
Really, B report has been filed. Court has rejected the B report.
B report file ಮಾಡಿದ್ದಾರೆ.
Rejected the B report.
The complainant filed a protest memo. Now protest memo has been accepted and direction has been given for further investigation.
Permissible.
No, I'm not on that. there is nothing in the complaint against me.
On merits we will answer.
That's why, my lord, I want to stay.
ಅದ್-
There are no interim order, no protection so far as I'm concerned.
That's all right. ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದಾರಲ್ಲ ಅವರೇ ಏನ್ ಮಾಡಲ್ಲ.
ಈಗ ಈಗ 156 ತಿರ್ಗಾ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ, that is 173(8).
ಮಾಡಿದ್ದಾರೆ ಈಗ ಅದು ಹೊಸ್ತು. ತಿರ್ಗಾ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
filed on the ground that the
No, no.
complainant has not
ಅವ್ರು
cooperated.
ಕೋಆಪರೇಟ್ ಮಾಡಲ್ಲ. But this is hanging on me.
Who has not cooperated? Complainant has not cooperated. Then don't precipitate till I hear the matter. List the matter on heard the learned senior counsel ಅಂತ ಮಾಡಿ. Again, Wednesday in the fresh matters list. Till such time the respondent police in the garb of further investigation as directed shall not precipitate the matter or take any coercive steps. Yes. Next.
77.
70?
77, it's a fresh matter, my lord. 77, let me take it up on Tuesday, my lord. It's a DE matter.
DE matter? DA?
I have been exonerated in the department inquiry.
Oh, that kind of a case.
Yes,
All right. ಯಾವತ್ ಮೇಡಮ್ ಅದೆಲ್ಲ ಇರೋದು?
my lord, that matter I'm seeking stay for this reason. Challenging the charge sheet, my lord, I filed a revision petition. There was a stay all through. Withdrawing that, my lord,
There was a stay all through?
Yes, my lord, I'll produce the order sheet. There is a stay all through.
The
Withdrawing with, my
learned-
lord, I filed the present 482.
heard the learned, ಆ ಕಡೆ ಯಾಕಿದ್ದೀರಾ?
ಅಲ್ಲ ಜಾಗ ಇರಲಿಲ್ಲ.
Heard the learned counsel Shivaprasad Shantangod appearing for the petitioner. The petitioner had preferred a criminal revision petition in criminal revision petition 559 of 2020 against the order passed by the concerned court. The coordinate bench had granted an interim order of stay on 11/9/2020. Subsequent to the grant of the interim order, the petitioner has now been exonerated in a departmental inquiry. Therefore, the petitioner submits that the issue stands answered by the judgment of the apex court in the case of Ashu Surendranath Tiwari, so and so, reported in 2020 10 SEC page 2027 SEC, alla? Yes, so and so 736, 636, 2020 9 SEC page 636. Therefore, there shall be an interim order of stay in the light of the aforesaid reason that there was an interim order in the criminal revision petition till the next date of hearing. Next. Next. 78.
Petitioner, your lordship. Yeah.
ಎಲ್ಲಿ ತಾಹಿರ್?
Went to trial court, your lordship.
Went to trial court.
It was up to 5 o'clock here.
ನೀವೇನ್ ಸ್ಪೆಷಲ್ ಬೆಂಚ್ ಹೋಗಿದ್ದೀರಾ? Oh, I am a special bench. I thought you are not here. Which special bench? All right.
Tomorrow, lordship.
Next ಶುಕ್ರವಾರ ಅಂತ ಹೇಳಿ. Next ಶುಕ್ರವಾರ ಮುಗಿಸ್ಬಿಡಿ ಅದನ್ನ, whatever it is. 20th in the fresh matters list. Yes. Next. First over ಆಯ್ತಾ? ಅಲ್ಲ, list continue ಇಲ್ಲ. Serial number. All matters where interim orders are there, they will be extended. And they will be posted after 2 weeks. I don't know whether it'll continue or not. If I continue, we'll take it up as usual. And in serial number 110, 112, 131, 133, 137, there are no interim orders. Or not?
Malad, 135, Malad.
No, if it has come before me and I have not granted interim order, then it will come in admission.
Not reached for the 125.
Not reached ಅಷ್ಟೇನ? ಅದನ್ನ ಮೇಡಮ್ ಅದನ್ನ ಮೇಡಮ್ ಒಂದು ನಿಮಿಷ ಮೇಡಮ್ ಅದನ್ನ ಇರ್ಲಿ, ಇದು ಇದಷ್ಟಲ್ದೇನೆ ಅವ್ರೇನು ಹೇಳ್ತಿದ್ರು ಅದನ್ನ ನನ್ನ ಮುಂದೆ ಬಂದಿದ್ರೆ ಚೆಕ್ ಮಾಡ್ಬಿಟ್ಟು post them all in fresh matters on Tuesday.
Serial number 135.
Sorry, on Tuesday.
Item number 93, please, there is no interim order.
It will come on Tuesday. If it has come once before me and I have not granted interim order, it won't come on Tuesday.
Malad, serial number 135, Malad.
Amale, it will come in admission, we'll consider.
Malad, serial number 135, Malad. Malad, your lordship.
VC ಇರ್ಬೇಕಾದ್ರೆ ಸ್ವಲ್ಪ ಸುಮ್ಮನೆ ಇರಿ, ಆರಾಮಾಗಿ ಆಫೀಸಲ್ಲಿ ಇದ್ದೀರಾ, ಇಲ್ಲಿ ಎಲ್ಲರೂ ಕಾಯ್ತಾ ಇದ್ದಾರೆ. VC ಹೇಳಲೇಬೇಡಿ. All right, it will come, ಅದನ್ನ fresh matter ಹಾಕಿ.
Malad, second list, my lord. The
Same matter, my lord, yesterday, the extension, the objection was.
I'll come, sir. Second list ಬರ್ತೀನಿ ಒಂದು ನಿಮಿಷ.
Serial number 153, I request for
Short what?
153, 4
Yeah.
PM matter.
ಅದೆಲ್ಲ ವೇಟ್ ಮಾಡಿ. Huh? 14%. 122. It will be extended. You registry to print in, what's your name, sir? So and so. Registry to print the name of so and so in place of the party in person, interim order stands extended ಅಷ್ಟೇ. ಎಲ್ಲರೂ ಹೇಳ್ಬೇಡಿ please. I have told you wherever ಇದಕ್ಕಿಂತ ಕ್ಲಾರಿಟಿ ಇನ್ನೇನು 5:15 ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಬರುತ್ತೆ. ನಿಮ್ದು ಎಷ್ಟನೇ ಸರ್? 137 ಹೇಳಿದ್ನಲ್ಲ ಸರ್ ಬರುತ್ತೆ ಅಂತ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ ಸರ್. ನೋ ಪ್ರಾಬ್ಲಮ್ಸ್. ಆನ್ ಟ್ಯೂಸ್ಡೇಸ್, ನೋ ಟುಮಾರೋಸ್.
136, coming fresh matter, the lordship will direct the learned SPP to produce the B report before consideration of the interim order.
ಅದು ಹಾಕಿ ಮೇಡಮ್ ಆನ್ ಟ್ಯೂಸ್ಡೇ. ಅದೆಲ್ಲ ನೋಡ್ಕೊಂಡು 1 minute ನೋಡ್ಕೊಂಡು, ಡೋಂಟ್ ಬಿ ರೂಡ್ ಟು ದಿ ಕೋರ್ಟ್ ಆಫೀಸರ್. ಶಿ ವಿಲ್ ಲುಕ್ ಇನ್ ಟು ಇಟ್ ಅಂಡ್ ಡೂ ಎವ್ರಿಥಿಂಗ್. Wherever interim orders are there, they are going to be extended by 2 weeks. Don't ask any date. If I continue in October, we'll do it. And in all other matters where interim order is not there, the parameter is it should not have come before me. He will identify that and post all those matters on Tuesday in the fresh matters list. ನೆನ್ನೆ ಕೊಟ್ಟಾಗಿದೆಯಲ್ಲ, ಏನಿದೆ ಎಲ್ಲ ಹೋಗ್ಬಿಟ್ರೆ ಆಮೇಲೆ ಕಷ್ಟ. ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ ಮಾಡ್ದಂಗೆ ಆಗುತ್ತೆ ಇಲ್ಲಿ. You produce that circular before the service matter court. Yes, all other matters. Further hearing. One Sirajuddin. Food. Parole ಇದೆಯಾ ಎಲ್ಲರೂ? Only food. Darshan. It is here. Yes, Problem sir is here.
Any day convenient notes, I said. Any day which is convenient, we have prepared that. We have prepared a written notes. I will be in a position to assist whatever date is.
Well, 21st.
Please, Saturday, please.
Saturday, yes.
It be any other date. 21st bit.
You are for food alla?
Food.
It's working Saturday, sir.
Yes.
Saturdays you work alla?
There is some development. So adike.
ಏನ್ ಡೆವಲಪ್ಮೆಂಟ್? ಫುಡ್ ಕೊಡ್ತಾ ಇದ್ದೀರಾ ಈಗ?
Food is at home now.
That is ಅವ್ರದಲ್ಲ sir, general. I'm not concerned about Darshan.
Yes.
Concerned about all inmates who are not getting nutritious diet is the allegation.
Lord, I have prepared a note, my lord. So I will be in a position to assist.
That's all right. The senior counsel will assist. ಎಲ್ಲ ಕೊಟ್ಟಿರಿ. 21st I will take it.
Please.
How will you demonstrate? ಇಲ್ಲಿ ತರ ತಗೊಂಡ್ಬರ್ತಾ ಇದ್ದೀರಾ? Affidavit. I thought you will get food here.
Such Saturdays.
I know. See whether it is. File your respective affidavits. Everybody should have nutritious food. Yes.
The reported against the jail authorities have been solidly confined. So that's what I filed an IM alert to inform the
Jail with the prison.
something which are brought to the notice of the Honorable Court and before the IG have been solidly confined and punished for that set. So that I have filed an IM. I should be transferred. Otherwise I will be.
Yeah.
That I have produced the.
Why all that?
We will look into it.
Well, he has projected some grievance that of all inmates in the prison. So you trouble him, is it?
No, there is no complaint registered with us.
He's filed an IA is what he says.
IA before the court.
Well, IA before the court, true. What is said is in the, if what is said is in the IA is correct, then
Yes, we will go.
bring about corrective measures. What is this?
There is any complaint before the jail authorities.
Yes.
That will.
Why would someone simply complain? ಇಲ್ಲಿ ಏನೋ ಕೋರ್ಟಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಅಂತ you can't take someone to task there.
If there was a complaint, we would have looked into and ascertained whether it
No,
was.
that's
true or
not correct.
No.
Can personally visited and did that by statement also, right? But, and after that, having solved the consent, so that I will not company and, having locked for 24 hours.
He's not served the IA.
IA copy could you give the IA copy? Why do you indulge in all this?
Verify.
Yes, SPP ಅವರೇ.
Yes, we will certainly.
Look, copy ಕೊಡಿ ಈಗಲೇ.
First time.
Yes, list ಅದು Siraj 21st ತಗೊಂತೀನಿ. By then you look into it. Yes, and food, whatever affidavit you have to file, you file.
Got 141.7.
ನಿಮ್ದು food then?
Your Lordship, sir, awaiting the report from the police, Your Lordship.
For what nutritious food?
No, Lordship.
Then?
This is another matter altogether, Your Lordship. Serial number 127, Your Lordship.
127.
Lordship.
It'll await. Entry order ಇದೆ. You are somewhere outside?
Lordship, it's inside.
Yes.
I got 141.
Lordship, 139.
I got 141.
139.
141, I filed a petition to expedite the trial. The offenses are 377. It's posted for framing of charges day after tomorrow, my lord.
ಯಾವುದು 140?
1.
Madam, you let it be posted framing of charges, don't worry. Yes. ನೀವು ಇರಲಿಲ್ಲ. Why? You are not present on the last occasion. ಮತ್ತೆ?
I've been here with the entire day, my lord.
Yes. ಇವತ್ತಲ್ಲ sir, on the last occasion. Yes.
My lord, I was present on the last hearing. It was asked to be posted after 3 weeks. My lord.
Why? Why?
Hearing the matter, my lord. You said you
Why?
not yet said to hear. I have my grievances.
Lordship, 139, Lordship.
Lord.
Serial number 139, Lordship. Last date, the message was not intimated me. I was not.
Message was not intimate. Who has to intimate?
Lordship, usually I get the alert messages for the cases.
Sorry.
But the last
Please
date.
ಕೊಡಿ.
Second list, my lord. My lord, second
That
list.
will repeat Friday. ನಾಳೆ ಆಗಲ್ಲ. ನಾಳೆ CM's matters are.
My lord, second list, my lord.
Second list ಏನು? There is a meeting, I forgot. Yes.
My lord, petition number 3, my lord. He is the applicant, my lord, in this IM.
ಏನ್ second list ಅಲ್ಲಿ?
Second serial.
What is second list? ಯಾವ್ದು ಮೇಡಮ್?
1207.
Oh, travel abroad. Yeah, what happened?
My lord, he's the applicant is a petition number 3, my lord. Basically, my lord, his nexus between this particular case and the petition number 3 is only with respect to his father has purchased the property. He has included his wife and then the third petition who is an applicant here, my lord.
I will hear it day after tomorrow.
Lordship,
Lordship.
only the orders.
Serial number 114.
Day after tomorrow.
Serial-
I'm already
Serial
late
number-
for a meeting.
My lord, serial number 135, my
Serial
lord.
number.
My lord.
You know, next. ಹೌದಾ? ಇನ್ನು ಹಬ್ಬಕ್ಕೆ ಬರೋದು ಬೇಡ ಅಂತ ಹೇಳಿ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
Court officer, madam.
Ma'am.